Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Mr. Fuentes Silva, can you hear and understand the interpreter?
Señor Fuentes Silva, ¿puede usted escuchar y entender a la intérprete?
Sí.
Yes.
Sir, you're charged with 1 count of criminal trespass, damage to property.
Señora, usted se le acusa de un cargo de invasión o daños a la propiedad.
This is a misdemeanor offense.
Esto es un delito menor
Bond will be set at $4,000.
y su fianza va a ser de $4,000.
There's going to be a stay away provision on this bond to stay away from an Alexis Lucio, Lucio. Do you understand that?
Y va a haber una orden de alejamiento en este caso, que dice que usted tiene que mantenerse alejado de Alexia Lucio, Lucio. ¿Entiende usted esto?
Sí.
Yes.
Your preliminary hearing date will be set for April 26th at 8:30 in the morning.
Su audiencia preliminar va a estar fija para el día 26 de abril a las 8:30 de la mañana.
That date will get waived and you'll get a new court date in the mail.
Esa audiencia se va a cancelar y usted recibiría un nuevo citatorio por correo.
Upon posting bond.
Si usted paga su fianza y sale.
Would you like for me to see if you qualify for the appointment of a lawyer?
¿Quiere usted que yo vea si usted califica para nombrarle un abogado?
Sí.
Yes.
I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you.
Yo voy a encontrar que usted califica, señor, y le voy a nombrar un abogado para que lo represente.
Do you have any questions of me?
¿Tiene usted alguna pregunta para mí?
Solo que en realidad no fui yo, pero bueno, no, está bien.
Just that, in fact, it was not me, but oh well, that's fine.
Sir, you stand here an innocent person.
Señor, usted está aquí siendo una persona inocente.
The state has to prove every allegation against you beyond a reasonable doubt.
El Estado tiene que probar cada una de las alegaciones en su contra más allá de una duda razonable.
Make sure you communicate with your lawyer about the facts of your case.
Asegúrese de hablar con su abogado con respecto a los detalles de su caso.
Está bien.
Any other questions?
That's fine. ¿Alguna otra pregunta?
Si no pago mi fianza, no voy a salir ahorita.
So if I don't pay my bond, I'm not going to be released right now?
Correct.
Correcto.
Any other questions?
¿Alguna otra pregunta? No.
Okay, you're free to go back, sir.
Ok, puede retirarse, señor.
Mr. Gomez Montijo.
Señor Gómez Montego.
Sir, can you hear and understand the interpreter?
Señor, ¿puede usted escuchar y entender a la intérprete?
Sí.
Yes.
You're charged with 1 count of driving a vehicle without a valid license.
A usted se le acusa de un cargo de manejar un vehículo sin licencia de conducir válida.
Bond is going to be set at $1,000.
Su fianza va a ser de $1,000.
You're charged with 1 count of driving under the influence of alcohol to the extent it made you a less safe driver.
A usted se le acusa de un cargo de manejar bajo los efectos del alcohol hasta el punto de que lo hizo un chofer menos seguro.
Bond is going to be set at $5,000.
Su fianza va a ser de $5,000.
You're charged with 1 count of improper lane change.
Se le acusa de un cargo de cambio inapropiado de carril.
Bond is going to be set at $500.
Su fianza va a ser de $500.
Finally, you're charged with 1 count of improper passing of an emergency vehicle.
Y finalmente se le acusa de un cargo de rebasarle a un vehículo de emergencia de manera inapropiada.
Bond is also going to be set at $500.
Y su fianza también va a ser de $500.
You're going to have a total bond set at $7,000.
Usted va a tener una fianza total de $7,000.
These are all misdemeanor offenses.
Todo esto son delitos menores.
Your preliminary hearing date will be set for April 26th at 8:30 in the morning.
Su audiencia preliminar va a estar fija para el día 26 de abril a las 8:30 de la mañana.
That date will get waived upon your bonding out, and you'll get a new court date in the mail.
Esa audiencia se cancela tan pronto usted pague su fianza y salga, y usted recibiría un nuevo citatorio por correo.
Your case was continued from yesterday, so I don't have a court-appointed attorney form.
Su caso fue aplazado desde el día de ayer y yo no tengo una solicitud para nombrarle un abogado de oficio.
Would you like for me to see if you qualify for the appointment of a lawyer?
¿Le gustaría a usted que yo vea si usted califica para nombrarle un abogado? Yes.
Are you currently working?
¿Actualmente está usted trabajando?
Sí.
Yes.
Approximately how much do you make per hour?
Aproximadamente, ¿cuánto gana usted por hora?
16.
16.
You do qualify, sir. I'm going to appoint a lawyer to represent you.
Usted sí
do you ha-
califica. I'm sorry, Judge, go ahead.
Do you have any questions of me?
Usted sí califica, señor, y yo le voy a nombrar un abogado para que lo represente. ¿Tiene usted alguna pregunta para mí?
Si pago mi fianza hoy, ¿puedo salir?
If I pay my bond today, can I be released?
Yes, sir.
Sí, señor.
Okay.
Ok.
You're free to go back.
Puede retirarse.
Mr. Mendez Ramirez.
Señor Méndez Ramírez.
Sir, can you hear and understand the interpreter?
Señor, ¿puede usted escuchar y entender a la intérprete?
Sir, can you hear and understand the interpreter?
Señor, ¿puede usted escuchar y entender a la intérprete?
Sí.
Yes.
Sir, you've been charged with one count of simple battery.
Señora, ¿a usted se le acusa de un cargo de agresión corporal simple?
Bond is going to be set at $3,000.
La fianza va a ser de $3,000.
You're also charged with one count of obstructing or hindering a law enforcement officer.
También se le acusa de un cargo de impedir el trabajo de un oficial.
Bond is going to be set at $2,000.
Su fianza va a ser de $2,000.
You're going to have a total bond of $5,000.
Su fianza total va a ser de $5,000.
These are all misdemeanor offenses, but there's going to be a stay away provision on this bond.
Todos estos son delitos menores, pero en esta fianza usted va a tener una orden de alejamiento.
It was difficult for me to make out the first name because there's a notary stamp over her name, but it looks like Francesca Solis.
Se me hizo difícil descifrar cuál era el nombre de ella porque tenía un sello de un notario encima de este nombre, pero tal parece que es Francesca Solís.
What is Miss Solis's first name?
¿Cuál es el primer nombre de la señorita Solís?
Francisca Solís.
Francisca.
Solís.
Francisca. So,
Okay. So you do understand that there's going to be a stay away provision to stay away from her.
usted entiende que va a haber una orden de alejamiento que dice que usted tiene que mantenerse alejada de ella.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning.
Su audiencia preliminar va a ser fija para el 26 de abril a las 8:30 de la mañana.
This date will get waived upon your bonding out.
Y esta corte se cancela tan pronto usted pague su fianza y salga.
Would you like for me to see if you qualify for the appointment of a lawyer?
¿Le gustaría a usted que yo vea si usted califica para nombrarlo un abogado?
Sí.
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Usted sí califica, señor, y lo voy a nombrar un abogado para que lo represente. ¿Tiene usted alguna pregunta para mí?
No.
No.
Okay, so you're free to go back.
Ok, señor, puede retirarse.
Okay, before I release Ms. Bermudez, is there anyone else that needs the services of the interpreter?
No, Your Honor, that's gonna be everybody.
Okay, thank you, Ms. Bermudez. Have a good day.
Thank you, Judge. You do. Let's go.
Let's switch over to the female side. We're going to begin with, it looks like a Miss Aggressor Ayala.
Yes, Your Honor.
Good morning, Your Honor.
Good morning, ma'am. You're charged with 1 count of criminal trespass, damage to property. I've set the bond for that offense at $3,000. You're also charged with 1 count of simple battery. I've set the bond at that offense for $3,000 also. So there's a total bond of $6,000. These are both misdemeanor offenses. There's going to be a stay away provision on the bond to stay away from a Manuel Thomas. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. It says that you refuse to fill out the form. Do you plan on hiring your own lawyer?
Yes.
Okay. Do you have any questions for me, ma'am?
When was the preliminary hearing again? April 26th at 8 a.m.
At 8:30 in the morning, but once you bond out, that date gets waived by operation of law, and your case goes to state court, and then it'll get assigned to a final judge. And so then you'll start getting court dates from that judge.
Okay.
Okay. Any other questions, ma'am?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Brown, Zana Brown.
How you doing, Your Honor?
I'm doing well, Miss Brown. Ma'am, you're charged with 1 count of simple battery. I've set the bond at $3,000. This is a misdemeanor offense. There's going to be a stay away provision on the bond to stay away from Ariana Michaela Thornton. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Butler?
How you doing this morning?
Good morning, ma'am. You're charged with 1 count of criminal trespass, damage to property. I've set the bond at $3,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from a Kendrick Gaston. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Are you currently working, ma'am?
No, ma'am.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Dunlap.
Good morning, Your Honor.
Good morning, ma'am. You're charged with 1 count of criminal damage to property in the 2nd degree. This is a felony. Bond is going to be set at $5,000. You're charged with 1 count of misdemeanor theft by taking. Bond is going to be set at $2,000. And you're charged with 1 count of simple battery, family violence, which is a misdemeanor. Bond is going to be set at $3,000. So you're going to have a total bond set at $10,000. There's going to be a stay away provision on this bond to stay away from a Gianni Fletcher. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for April 25th at 8:30 in the morning, courtroom 201. That date also will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. Are you currently working, ma'am?
Yes, Your Honor.
About how much do you make per hour?
About 18.35.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am. You're free to go back. And finally, we have Ms. Fairley.
Good morning.
Good morning, ma'am. You're charged with 1 count of reckless driving. Bond is going to be set at $1,500. 1 count of knowingly driving a motor vehicle on a suspended or canceled registration. Bond is going to be set at $500. And 1 count of improper passing of an emergency vehicle. Bond is also going to be set at $500. Now, you may have, because these bonds are all set by schedule, you may have been given a final bond amount when you bonded in. Did you get a piece of paper?
Yes, I did. It's
Okay.
in my,
Okay, so it's going to be a little bit higher than what I stated. All of the bonds here, the sheriff's department is required by law to add a fee to each bond. And so the bonds that are automatically set by schedule, you already have your total bond. So whatever you were given, you can contact the bonding company, contact family and friends, and that you'll know that that's going to be your final number. Okay.
Okay.
You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. It said that you refused to fill out the form, so you're going to hire your own lawyer.
No, I would like to be appointed a lawyer.
Okay. Are you currently working, ma'am?
No.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am. You're free to go back. All right.
What
that
was the
should be-
reckless driving bond?
Oh, I'm sorry. It is $1,500.
Okay, thank you.
And that completes the lady side. Is that correct?
Yes, Your Honor.
Okay, let's switch over to the male side. And sir, I'm going to apologize if I mispronounced your last name. Is it Asubuntang?
Bishop Bunting, Your Honor.
Bunting. Okay. Sir, you're charged with 3 counts of simple battery. The bond is going to be the same for each count. It's going to be set at $3,000 for each. So you're going to have a total bond of $9,000. These are all misdemeanor offenses. But there's going to be a stay away provision on the bond to stay away from your father, Mr. Bernard, your mother, Ms. Consuela, and your brother, Mr. Kwame. Do you understand that?
Yes, sir, Your Honor.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, Your Honor.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. So I was charged with all 3 counts, even though it was the only incident was involved 1 person.
So based upon what I have here, they accuse you of assaulting both your parents and getting into a fight with your brother. So that's what they've written here as to the allegations. I've appointed you a lawyer. You need to speak to the lawyer about the facts of whatever happened. Like I told the other individual, the state of Georgia has to prove every element beyond a reasonable doubt. Any other questions?
Yes, sir, Your Honor.
Okay, you're free to go back.
Carter. Good morning, Your Honor.
Good morning, Mr. Carter. Sir, you're charged with 1 count of terroristic threats. This is a felony offense. I am denying bond on that count as of now. You're also charged with disorderly conduct, which is a misdemeanor. And I'm setting bond at $1,500. And you're charged with carrying a weapon concealed. I'm setting bond at $5,000. You're gonna hold on, sir. I'm gonna let you speak. You're gonna have a preliminary hearing date set for April 25th at 8:30 in the morning. You're gonna also have a bond hearing date set for April 29th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was it that you wanted to tell me?
I wanted to see if I could get the terroristic threats. I do got an IEP. So I wanted to see it wasn't more so my hands, it was more so my mouth.
Okay.
And we was going back and forth. I was going back and forth with the young lady. And she threatened me.
Hold on, Mr. Carter. This is being recorded, okay? So I don't want you to say anything that may put you in a worse position before you even had an opportunity to speak to your lawyer.
Sure. All right, so I did want to
hold on. I'm gonna let you speak, but as it relates to the IEP, discuss that with your lawyer and let your lawyer guide you with respect to that. Okay, go ahead, sir.
That was it.
Okay. All right, you're free to go back, Mr. Carter.
I appreciate it.
Mr. Daniel. Mr. Daniel, sir, you're charged with one count of improper lane change. Bond is going to be set at $500 for that offense, and one count of driving under the influence of alcohol. Bond is going to be set at $5,000. Both of these are misdemeanor offenses. You're going to have a total bond set at $5,500. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir, I'm gonna get me a lawyer.
Okay. Do you have any questions for me?
No.
Okay, sir, you're free to go back.
Yes, again, no. Newman, Richard. First name Richard. Richard. First name is Richard. Come on up.
Good morning, sir. You're charged with one count of theft by shoplifting as a misdemeanor. Bond is going to be set at $2,000. One count of crossing the roadway at a point other than the crosswalk. That's also a misdemeanor. Bond is set at $500. And finally, giving a false name, address, and date of birth to a law enforcement officer. Bond is going to be set at $3,000. These are all misdemeanor offenses. You're going to have a total bond set at $5,500. Would you like for me to see? Well, let me tell you this first. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Just one. Are you wearing pants?
Sir, you're free to go back.
Thank you, sir.
Next person is Mr. Ewing.
Good morning, Ron. I'm here.
Good morning.
Good morning, Ron.
Mr. Ewing, sir, you're charged with one count of reckless conduct. Bond is going to be set at $5,000. This is a misdemeanor. So your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I am going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. You say 5,000?
Yes, sir.
What's that? I can go through a bond?
Yes, sir.
All right.
All right, you're free to go back. Mr. Harris?
Good morning, Your Honor.
Morning, Mr. Harris. So you're charged with 1 count of driving under the influence of alcohol to the extent it made you a less safe driver. Bond is going to be set at $5,000 for that offense. You're also charged with 1 count of reckless driving. Bond is going to be set at $1,500. 1 count of an open container violation. Bond is going to be set at $500. And 1 count of improper lane change. Bond is also going to be set at $500. So you're going to have a total bond set at $7,500. Because these are all misdemeanor offenses, you're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Mr. Harris?
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Hemingway, sir, you're charged with 1 count of theft by taking of a motor vehicle. I'm setting the bond at $10,000. That's a felony offense. You're also charged with 1 count of criminal trespass as a misdemeanor. I'm setting the bond at $3,000 for that offense, and 1 count of driving on a suspended license. Bond is going to be set at $1,500. So you're going to have a total bond set at $14,500. There is going to be a stay away provision on this bond, to stay away from a trainee huff or trainee huff. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 25th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Reginald Jackson.
Good morning, Your Honor.
Good morning. Give me 1 second, Mr. Jackson. And you are Reginald Jackson, correct?
Yes, sir.
Okay, Mr. Jackson, so you're charged with discharging a firearm near a highway. This is a misdemeanor offense. Bond is going to be set at $3,000. You're also charged with disorderly conduct, which is a misdemeanor. Bond is going to be set at $1,500. You're charged with aggravated cruelty to animals and causing the death of an animal through the use of a firearm. Bond is going to be denied on that offense at this stage. That's a felony offense. You're also charged with false statements, which is a felony offense. Bond is going to be denied on that charge at this point. You're charged with 1 count of obstructing an officer. That's a misdemeanor offense. Bond is going to be set at $2,000. You're also charged with 1 count of misdemeanor theft by taking. Bond is going to be set at $2,000. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing set for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So, yes, I don't understand, like, how was I charged with these charges when there was no, like it was hearsay, sir. That's all, like, nobody, like, I don't understand, like, me and my neighbors got into it a couple of times, and it was hearsay. That's all, like, they didn't see me, nobody saw me do nothing, they just saw me outside. That's it, like, something happened, I was in the house with my baby, you know what I'm saying? Something happened, I went outside, and they was like, oh, you did that? I ain't do shit. Fuck wrong with y'all, I'm going to work. And I left, like, I don't understand, how is it probable cause when I was seen with nothing, I was seen doing nothing? It was nothing, just me and my neighbors got into it a few months ago about their dog, like 3 months ago, and they happened to their dog, and they came out, so you did, I ain't do shit. You know what I'm saying? It was a lot of people at my house, there was like 5 people there. And I don't understand, like, how is it probable cause for me when I was caught, when there was no gun in my hand, there was no recording, it was nothing, like, it was nothing that I did wrong, like, I didn't do nothing. That's why when the police came to me and asked me, I'm like, I didn't do nothing. You know what I'm saying? Like, I don't understand, like, how is it probable cause when there was no video, they got cameras at their house and everything. Like, it was no video seeing me doing it, wasn't nothing, just because me and them got into an argument a couple months ago about their dogs. Like, I have my own dogs. I have 4 dogs of my own. I love dogs. You know what I'm saying? Like, just because we got in an argument 3 months ago about their dog eating my dog's food, that don't mean nothing. That's
Okay.
why I'm asking, like, I don't understand how is it a probable cause for me not to have a bond on these cases when there was no, like, nothing that just.
So Mr. Jackson, I think that's the 5th time you said, I don't understand how they get probable cause. And every time I try to tell
Okay,
you, you keep saying, I don't understand. Is it okay for me to explain this to
Yes,
you?
sir. Yes, sir.
Okay, so the allegation, and again, these are allegations, is that you took a 40 caliber Smith & Wesson gun, shot the dog in the head, took the dog off the leash, dragged the dog back over to your property, threw the dog into a trash can, and placed garbage bags over the dog. That's the basic allegation.
Yes, sir. I understand. Go ahead.
The state has to prove it, okay? That's what they said you did. Now they have to prove it. That's why you get lawyers. That's why you have the right to know what they said you allegedly did, so that you can speak to your lawyer, and then maybe y'all can craft a defense, and this will, you know.
I understand that part, but I'm just trying to understand, like, how come I don't get a bond on these offenses? Like, I have a job, I have a 1-year-old daughter, I have a mother on dialysis I'm looking after. Like, I have.
I understand. It's because of your criminal history out of Florida.
But I served time for that, sir. That was 7 years ago when I went to jail. That was 2015. I went to jail. That was 7 years ago.
You had 19 cycles, meaning 19 interactions with law enforcement in Florida, and the allegation of discharging a firearm. I'm just not prepared to.
I never had a violent charge in Florida, though, sir. I never had. If you look at my charge, I never had a violent charge down there.
Mr. Jackson, you're asking me and I'm explaining.
Okay, yes, sir. Thank you.
Okay, all right. Anything else, sir?
So when I go, next time I go to court, they'll tell me if I'm eligible for a bond.
Well, you have a lawyer that I've appointed, and I don't work for the lawyer, so I don't know when the lawyer is going to come and get you. The lawyer has the ability to meet with someone in a district attorney's office between now and that court date to try to get them to consent to a bond. It happens all the time, but that's a decision that is solely within the district attorney's office to make, okay?
Okay, thank you.
You're welcome. All right, you're free to go back. Mr. Quavius Jackson.
How you doing, sir?
I'm doing well. Mr. Jackson, sir, you're charged with 2 misdemeanor offenses.
Yes, sir.
The first is misdemeanor possession of marijuana. Bond is going to be set at $1,500. And then you're charged with the failure to yield at a stop sign. Bond is going to be set at $500. So that's a total. Wait a minute.
So okay, go.
Hold on 1 second.
Okay.
It should say 500, but they have $150.
Huh? It should say 500.
Okay, Mr. Jackson.
Okay. Yes, sir.
My exact statement was this bond should be $500, but it's written on the bond schedule as $150.
Oh, okay.
I'm gonna leave it. So you're gonna have a total bond of $1,650.
Thank you.
Your preliminary hearing date is gonna be set for April 26th at 8:30 in the morning.
Okay.
Courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Jackson.
Is it possible for me to talk to like a public defender or something if they ask me about the case?
You just said you didn't want to speak to.
Yeah. I was just wondering. Okay, thank you.
Okay, all right, you're free to go back. Mr. Jones.
Hey, how you doing?
I'm doing well. Mr. Jones, sir, you're charged with 1 count of aggravated assault with a deadly weapon. I'm denying bond on that charge at this time. You were also charged on your warrant with the terroristic threats charge that somehow didn't make it to the bond order, but I hand wrote it in. But I'm also denying bond on that also. Those are both felony offenses.
All right. First they were telling me I got charged with assault because he came outside. He came outside, 7 deep at me, and I was just saying to myself because the whole family came outside. But the firearm never went up. I had him on my side the whole time.
Okay. So your preliminary hearing date is going to be set for April 25th at 8:30 in the morning.
All right.
Courtroom 201. Your bond hearing is going to be set for April 29th at 8:30 in the morning, courtroom 201.
All right.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
And then for the terroristic threat, what were you saying?
Bond is being denied on that also. And just so you know, based upon what's in.
They wouldn't. The thing about it.
Hold on, sir, please.
I'm listening.
Okay. The reason you got charged with that based upon what the officer wrote here is that you allegedly threatened to kill everybody in the house, that you're going to come back and shoot up the house in the officer's presence.
Oh, the thing about it, my friend came to the car. The police officer wouldn't let my friend talk. He wouldn't let him talk. He stayed right across from the neighborhood from it. He wouldn't let him talk or nothing like that. So they just went ahead and put me away. And I was trying to tell my story, but it won't work. He won't listen to me at all. Because I had 7 people coming towards me at one time. So that was just like self-defense at the end of the day right there. Especially with the Georgia license to carry the weapon.
Okay. Anything else, Mr. Jones?
No, sorry.
Okay, sir, you're free to go back.
All right.
Is it Mr. Manyika?
Yes, good morning, sir.
Good morning, sir. You're charged with 1 count of obstructing an officer. This is a misdemeanor offense. Bond is going to be set at $2,000. You're also charged with 1 count of simple battery. Bond is going to be set at $3,000. That's a misdemeanor also. And you're charged with disorderly conduct, and bond is going to be set at $1,500. There will not be a stay away provision on the bond because the alleged victims are police officers. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, I'm gonna bond out, sir.
Okay. Do you have any questions for me?
Yes, am I able to self-bond myself out?
Okay. So hold on. So you're saying, are you able to use your own resources like a debit card or something like that?
Yes, I have my money.
Hold on. That's something that you're going to have to make that request of the sheriff's department. I do not know the direct answer to that. I believe you would have to have someone that you could come and turn your property over to so that that person can then go through that process. But you're going to have to speak to someone in the sheriff's department about that.
The total bond is $6,500?
Yes, sir.
Okay.
And it'll be a little bit higher because of the whole thing of sheriff's officers required to add fees to bonds.
Okay, and I could use a bondsman, right?
Yes, sir.
Okay, thank you, sir.
Okay, you're free to go back.
Hey.
Mr. Mays.
Good morning, Lord.
Good morning, Mr. Mays. So you're charged with 1 count of theft by taking. Bond is going to be set at $2,000. and you're charged with 1 count of theft by taking motor vehicle, I'm gonna deny the bond on the theft by taking of the motor vehicle at this point. You're gonna have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. You're gonna have a bond hearing date set for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Not really at the moment, sir. I just lost my.
Okay, I'm gonna find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So I can bond out on one, but I can't bond out on the other, right?
That's correct. Okay, you're free to go back, sir.
So what's the one I can't bond out on? Why I can't bond? Why y'all denied that?
Theft by taking motor vehicle. I looked at the allegation here, and I believe your criminal history. Hold on one second. I'll tell you exactly. Sorry, I gotta go through Mr. Jackson's criminal history. Okay, yep, you have 19 cycles, your criminal history. Do you know what I mean by that?
No, sir.
That means you've had 19 interactions with law enforcement. And in this particular instance, the allegation is that you took, I'm assuming, a girlfriend's vehicle and returned it. I just, at this point, I don't feel good about setting a bond on this offense without knowing more about what took place. Okay.
Okay, I was saying, but if somebody give you the keys, so that's not really taking. That's how I want, just asking you a question about that.
Okay. Well, the allegation was that you not only took the vehicle, but took 2 cell phones.
2 cell phones?
iPhone Pro Max. Oh, no, I'm sorry, I took 1 cell phone. Victim number 2 cell phone.
But that was all given to me though.
Okay. That's where you speak to your lawyer. Okay.
All right.
All right, you're free to go back. Mr. Weeks.
Yes, sir, Your Honor.
Okay, Mr. Weeks, sir, you're charged with 1 count of cruelty to children in the 1st degree. That's a felony offense. I'm denying bond on that offense at this time. You're charged with 1 count of battery, family violence. I'm setting bond at $5,000 for that offense. There's going to be a stay away provision on this bond, stay away from Juan Davis, LaTanya Temple, and DeAndre Temple. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 25th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
None at this time.
Okay, you're free to go back. Finally, Mr. Williams.
Yes, Your Honor.
Mr. Williams, sir, you're charged with 1 count of aggravated assault with a deadly weapon. This is a felony offense. I'm denying bond on this charge at this time. There's going to be a stay away provision if you're given bond to stay away from a Jamie Wright. Do you understand that?
Say that again, sir.
There's going to be a stay away provision if you're given a bond to stay away from a Jamie Wright. Do you understand that?
I don't know who that is.
Okay. So Mr. Wright is the person that you allegedly shot in the leg and was transported to Grady Memorial Hospital. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. You're gonna have a bond hearing date set for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So basically you let me know that my bail, I don't have the bail.
Right now, you do not have a bail. You're in pretty much the same position as the other individuals. Your lawyer can go speak to the district attorney's office and see if they're willing to consent on a bond. If not, then this will be set for a bond hearing for April 29th.
Okay.
Anything else, sir?
Do you know why I was denied? Was it, I don't like my
The
history.
allegation is that you shot somebody in the leg and that person had to get transported to Grady Memorial Hospital.
Okay.
Okay. All right. You're free to go back, sir.
All right, thank you.
You're welcome. Okay. Does that complete the call of today's calendar?
Yes, Your Honor, that's everybody.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Ma'am, you're charged with one count of driving under the influence of alcohol to the extent it made you a less safe driver. That's a misdemeanor. Bond is going to be set at $5,000. One count of possession of marijuana less than an ounce. That's also a misdemeanor. Bond is going to be set at $1,500. Improper lane change. Bond is going to be set at $500. And speeding. Bond is going to be set at $500. So you're going to have a total bond of, let's see, $7,500. Do you believe you can post that bond?
Yeah, I can make a phone call.
Okay, your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sure.
So could you say yes or no, please?
Yes.
Thank you. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
You said alcohol for the first one?
Driving under the influence of alcohol to the extent it made you a less safe driver, and they have an indication of drugs on the warrant.
Okay. Did
All right.
the urine just come back or anything?
I have no idea.
Okay, thank you.
Okay, so I am appointing a lawyer to represent you. Do you have any other questions?
No.
Okay, you're free to go back, ma'am. Ms. Dean? Ms. Dean, ma'am, you've been charged with one count of possession of marijuana less than an ounce. That is a misdemeanor offense. Bond is going to be set at $1,500. You've also been charged with speeding. Bond is going to be set at $500. You've been charged with improper passing of an emergency vehicle. Bond is going to be set at $500. You've been charged with driving under the influence of alcohol to the extent it made you a less safe driver. Bond is going to be set at $5,000. And you've also been charged with obstruction well, it says obstruction or hindering the display of a license plate, but it's basically saying that the license plate was obstructed. Bond is going to be set at $500 for that. So you're going to have a total bond set to $8,000. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, ma'am?
What you said? I'm sorry.
I said, are you currently working?
No, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. No,
Okay,
Your Honor.
ma'am. Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Ms. Dixon?
You can go back to your room. Don't let the doors on, please.
Ms. Dixon, ma'am, you've been charged with 1 count of simple battery. That's a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, and it appears as that something happened, but so these stay away provisions are going to apply to everybody, just so you know. For you, there's a stay away provision, stay away from an Alexis Wallace and a Tijuana Williams. Do you understand that?
Yes, sir.
I'm sorry, ma'am.
Yes, sir.
Okay, your preliminary hearing date is going to be set for April 26th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm sorry, ma'am.
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back. Ms. Humphries? Ms. Humphries, ma'am, you've been charged with 1 count of driving under the influence of alcohol to the extent it made you a less safe driver. Bond is going to be set at $5,000. You've been charged with 1 count of following too close. Bond is going to be set at $500, and 1 count of giving or not giving a turn signal. Bond is going to be set at $500. So you're going to have a total bond set at $6,000. Your preliminary hearing date, and these are all misdemeanors. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, ma'am?
No, Your Honor.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back. Ms. Jenkins?
Good morning.
Good morning. Ms. Jenkins, ma'am, you've been charged with 1 count of cruelty to children in the 3rd degree. This is a misdemeanor. Bond is going to be set at $3,000. You've also been charged with 1 count of battery. Bond is going to be set at $5,000. You're going to have a total bond set at $8,000. There's going to be a stay away provision on this bond, and it looks as though the name was Williams Carr. Is that name familiar to you?
Yes, Your Honor.
And is that person's actual name, Williams Carr?
Without an S, William Carr.
William Carr. Thank you. That makes a lot more sense now. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. I don't.
Okay, ma'am, you're free to go back.
Thank you.
Miss Neely? Miss Neely, ma'am, you've been charged with 1 count of possession of a Schedule 4 drug and 1 count of having a drug outside of the container or pill outside of the container. I've dismissed both of these charges. When the jail receives your paperwork, you'll be released. Do you have any questions of me, ma'am?
Thank you, Your Honor.
You're welcome. You're free to go back. Miss Gates, I'm sorry, Miss Robinson. or Robinson Gates. I apologize, ma'am.
Good morning, Your Honor.
Good morning, ma'am. You've been charged with 1 count of speeding. I'm gonna set the bond at $500 for that. 1 count of driving on a suspended license. Bond is gonna be set at $1,500. And 1 count of having an expired decal on your vehicle. Bond is gonna be set at $500. So you're gonna have a total bond set at $2,500. All of those are misdemeanor offenses. So your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for, it says, well, you didn't fill it out. Would you like for me to see if you qualify for the appointment of a lawyer? Or do you plan on hiring your own lawyer?
Yes, you can.
Okay. Are you currently working, ma'am?
Yes, sir, I am.
Approximately how much do you make per hour?
Okay, so my first job, I make 17 an hour, and my other job, I make 14 an hour.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Am I able to get on probation if I don't have the funds to bail out?
So that's not a determination that I can make at this stage. Once your case gets bound over to, these are traffic related offenses. So you may go to the traffic division of state court, and it will be up to the judge as to at that level as to whether they place you on probation. Okay.
Thank you.
You're welcome. You're free to go back, ma'am. Miss Rose.
Good morning, Your Honor.
Good morning, Miss Rose, ma'am. You've been charged with 1 count of simple assault. Bond is going to be set at $3,000. You've been charged with 1 count of simple battery, family violence. Bond is also going to be set at $3,000. And you've been charged with speeding. Bond is going to be set at $1,000. So you're going to have a total bond of $7,000. There's going to be a stay away provision on this bond to stay away from Anthony Leon. Do you understand that? Yes or no?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Thank you. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. You're on the borderline, but I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you are free to go back.
Thank you.
You're welcome. See, Miss Smith. Ms. Smith,
Good morning,
ma'am.
sir.
Good morning, ma'am. You've been charged with 1 count of simple battery. I've set the bond at $3,000. You're going to also have a stay away provision on your bond to stay away from an Alexis Wallace and a Tijuana Williams. Do you understand that?
Yeah, I totally
I'm sorry,
understand.
ma'am. Yes or no?
Yes, sir.
Thank you. Your
Just
preliminary
a
hearing
little
date
bit.
is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify,
Yes,
Ms.
sir.
Smith. I'm going to appoint a lawyer to represent you. Do you have any questions for me, ma'am?
No questions at all. I'm
Thank
just
you.
ready
You're
to
free to
get
go
it.
back.
Thank you.
Ms. Wallace? Miss Wallace?
Good
Good morning, Ms. Wallace. You've been charged with 1 count of simple battery. I've set the bond at $3,000 for that offense and 1 count of battery. I've set the bond at $5,000. So you have a total bond of $8,000. There's going to be a stay away provision on this bond to stay away from a De'Ara Jackson, Tierney Williams, Tierra Smith, and London Dixon. Do you understand that, ma'am? Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Ms. Wallace?
Yes, Your Honor.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Williams.
Good morning, Your Honor.
Good morning, Ms. Williams, ma'am. You're charged with 1 count of simple battery. Bond is going to be set at $3,000. That's a misdemeanor offense. There's going to be a stay away provision on this bond, stay away from Alexis Wallace and Tijuana Williams. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, ma'am. Let me ask you this question. Are you currently employed?
No, sir.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Tijuana Williams.
Good morning, and it's Tiana.
Tiana. Okay, I apologize, ma'am. Ms. Williams, you're charged with 1 count of battery. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from Tierney Williams, Tierra Smith, and a London Dixon. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Okay, looks like we have a Miss Stevens. Ms. Stevenson, ma'am, you're charged with 1 count of being a fugitive from justice. And what that simply means is that you don't have currently a charge pending against you in Clayton County to hold you within the jail. But there is a warrant for your arrest out of, looks like that was issued by the Mississippi Department of Corrections for a parole violation charge from a shoplifting case. And they have indicated that they will seek to extradite you. So you have the right to challenge this. And if you tell me today that you want to challenge it, sometime between now and the next 90 days, there will be a hearing held in this court. And the purpose of that hearing will be to determine whether you are the person named in the warrant and whether, in fact, the warrant exists for a valid charge. If at the end of that hearing, the judge determines that you are the person named in the warrant and the warrant is valid, the judge will sign off on a writ. And what that means, or a governor's writ, sometimes what we call it. Basically what that means is that now the state of Mississippi is free to come and get you. State of Mississippi will have 30 days up to 60 days to come and get you from that date. If they don't get you, the sheriff come and get you, the sheriff's department here will contact Mississippi and see if they in fact still want to extradite you. If you believe that you are the person named in the warrant and you believe that the charge is potentially valid, not that you're guilty of it, but that is potentially valid, you can waive that process today, that up to 90-day process. And then that 30-day up to 60-day clock will begin to run today. Are you keeping up with me with what I'm explaining to you?
Yes, sir.
Do you have any questions so far about this process?
No, sir.
Have you thought about whether you want to have the hearing or whether you want to waive the hearing?
Waive it.
Okay. There should be forms there for you to sign. Once you sign those forms, they will send the forms to me for my signature, and that clock will begin to run today. I would encourage you to, if you have the ability and the means, to hire an attorney in Mississippi to represent you on this, because I've seen, especially with the COVID and the pandemic and all that kind of stuff, a lot of jurisdictions, if you hire an attorney or you have someone representing your interests in that district, they will contact the sheriff's department here and say, hey, we've reached an agreement, you can release her. And then they'll either give you a new court date, or if it's a fine or whatever, you can get all of that stuff worked out and you don't have to just sit here in custody. Okay, ma'am?
Yes, sir.
Do you have any questions?
No, sir.
Okay. Once you sign that waiver, you'll be free to go back. Did I miss anyone? I see a person, I'm sorry, sitting behind Ms. Stevens. Did I miss someone?
No, Your Honor, that's everybody on the calendar.
Okay, thank you. Let's switch over to the male side. We're going to start with Mr. Ballard.
Ballard.
Okay, Mr. Ballard, you've been charged with a number of offenses, and I'll go through them each. First, you're charged with a tinted window violation. That's a misdemeanor, bond is set at $500. You're charged with possession of marijuana over an ounce, but the only indication in the warrant was that the officer believed that it was a large quantity. That's not sufficient for that charge to go forward at this stage, so I'm dismissing that charge. Doesn't mean the state can't bring the charge back, but I'm dismissing it for that technical reason. You've been charged with possession of a controlled substance, Schedule 1, pills that they believe to be oxycodone. That's a felony offense. Bond is going to be set at $3,000 for that. You've been charged with violation of Georgia Controlled Substance Act, possession with intent to distribute. And as I indicated before, that's related to the marijuana charge. Because I dismissed the marijuana charge, I'm dismissing that charge. You're charged with one count of obstructing or hindering a law enforcement officer. That's a misdemeanor. Bond is going to be set at $2,000. You're charged with possession of a firearm during the commission of a felony. That relates to the pills. Bond is going to be set at $5,000 for that. And you're charged with one count of use or possession of drug-related objects. That's a misdemeanor. Bond is going to be set at $1,500. So you're going to have a total bond set at $11,500. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. It appears that you do qualify, Mr. Ballard. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Okay.
Mr. Brooks. Mr. Brooks, you've been charged with 1 count of aggravated assault with a deadly weapon and 1 count of possession of firearm by a convicted felon. These are both felony offenses. Bond is going to be denied at this point on both of these charges. There's going to be a stay away provision on this bond to stay away from a Mr. Jamie Wright. Do you understand that?
Yes, I do.
Your preliminary hearing date is going to be set for April 25th at 8:30 in the morning. You're going to also have a bond hearing date set for April 29th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
I'm sorry, sir?
Yes.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Your Honor, why am I being denied bond? I don't even know the guy.
Okay. The allegation in this particular case is that Mr. Wright was shot in the leg and he had to be transported to Grady Hospital. There was a person that appeared before me on Monday with this same victim under these same circumstances, and I denied that person's bond also for the same reason. So obviously, and that person said the same thing. I don't know this person. I've appointed a lawyer. You need to speak to the lawyer about this. But the reason bond is being denied is based upon the facts, the allegations that are placed in the warrant. Anything else, sir?
No, sir, Your Honor.
Okay, you're free to go back. Mr. Brown.
So,
Good morning.
Good morning, Mr. Brown. You're charged with 1 count of possession of firearm by a convicted felon. I am denying bond at this stage. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing set for April 29th at 8:30 in the morning.
Can I ask you a question? I'm being denied bail and I don't live there.
Okay. Give me a second. Let me finish what I have to say, and then we'll engage in a dialogue, okay? Your preliminary hearing date is going to be set for April 25th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah, no problem.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, the allegation in the warrant is that the U.S. Marshals executed a search warrant at this location. And during the warrant, you were questioned or you were detained. And according to them, you stated you stayed upstairs in the upstairs bedroom to the left. And that's where the United States Marshals indicated that they located a .380 pistol. And they advised that you are a convicted felon. So the allegation is that you told them you lived there. I don't know the veracity of it, meaning I don't know whether it's true or not.
All right, can I ask you a question?
Yes, yes, sir.
Does it says that the owner of the gun said that was theirs and they lived there?
No, no.
It's crazy.
I'll read it word for word for you if you want.
Nah, I'm telling you the judge because the owner of the guns that lived in that room, because I don't live there, she was also present, but I see what happened.
Right. And so, and that's where the reason that we appoint lawyers at this stage is that you know that they're saying, or the allegation is that you told them that you lived there. Hopefully they were wearing body worn cameras, that all your interactions were recorded. Your lawyer knows that you're saying, hey, I didn't say that. I don't live there. Lawyer can get the information. Lawyer can then go to the district attorney's office and say, release my client.
No bond, though?
No, sir.
Thank you.
You're welcome. Mr. Buchanan. Mr. Buchanan, sir, you're charged with 1 count of criminal trespass, damage to property. This is a misdemeanor offense. I've set the bond at $4,000. There's going to be a stay away provision on the bond to stay away from India Corbett, INDYA Corbett. Do you understand that?
Yes, sir. With me staying there too?
I'm sorry, sir. Let me finish and then we'll engage in a discussion. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. It looks like you refused to fill out the form. So do you plan to hire your own lawyer?
Yes, I already have one.
Okay. Now, what was your question, sir?
Me and my baby, like, what was I charged for that with? Because we had an altercation. I was gone. The police was called 4 or 5 hours later.
Mr. Buchanan, I'm willing to answer your question. Okay. So the warrant was taken out on March 20th. Looks like at about 2:30 in the afternoon. The allegation is that it says, said accused, meaning you, did intentionally damage the property of India Corbett without the consent of the property owner, and the damage thereto is $500 or less. It says, said accused had a outburst and ripped the door off the hinges to the bathroom and completely damaged the bedroom door, which as a result rendered both doors useless. So that's the allegation, is that you ripped one door off the hinges and what does it say? That you damaged the bedroom door and the bathroom door.
Yes, sir.
Okay. Anything else, sir?
Nope.
Okay, you're free to go back. Mr. Drummond.
Yes, sir.
Mr. Drummond, sir, you're charged with 1 count of battery. This is misdemeanor offense, bond is set at $5,000. 1 count of obstructing an officer, bond is going to be set at $2,000. And 1 count of simple battery, bond is going to be set at $3,000. There's no stay away provision being placed on this because basically his allegation is there is a outburst at the airport. You're going to have a total bond of $10,000. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Drummond.
All right, thank you.
You're welcome. Mr. Dudley? Mr. Dudley, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act. That's a felony offense, bond is going to be set at $5,000. 1 count of speeding, bond is going to be set at $1,500. 1 count of possession of firearm or weapon during the commission of a felony, bond is going to be set at $5,000. And 1 count of obstructing or hindering the display of a license, bond is going to be set, the tag, bond is going to be set at $500. So you're going to have a total bond set at $12,000. Because 2 of these offenses are felony offenses, you're going to have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Mr. Dudley?
Sir.
I'm sorry, sir.
Yes, sir.
You do qualify, Mr. Dudley. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah, if I end up finding a lawyer, do I need to still
use the court appointed lawyer?
No, if you find or hire another lawyer, retain a lawyer, what you should do is contact the appointed lawyer, let them know that you now have your own lawyer so that they can withdraw from the case.
Gotcha. Thank you.
Okay, you're welcome. You're free to go back, sir. Mr. Fallon. Mr. Fallon, sir, you're charged with 1 count of burglary and 1 count of criminal trespass. The burglary is a felony offense. I've denied bond at this stage on that charge. The criminal trespass charge, I've set a bond at $3,000. Your preliminary hearing date is going to be set for April 25th at 8:30 in the morning, courtroom 201. I'm also setting a bond hearing date for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Qualify for what?
The appointment of a lawyer.
Yeah.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me, Mr. Fallon?
Why I got denied bond?
It's within my discretion. A burglary offense is a serious offense. So I have to look at this a little more closely before bond is granted on this charge. Okay, you're free to go back, sir. Mr. Gravely?
Good morning, sir.
Good morning, sir. You're charged with 1 count of basically possession of marijuana within the Clayton County Prison. I'm setting a bond at $2,000. I'm assuming you're under sentence. Is that correct, sir?
Yes, sir. I got released from prison yesterday.
Okay. Okay. I'm going to set the bond at $2,000. Because this is a felony offense, you're going to have a preliminary hearing date set for April 25th at 8:30 in the morning, courtroom 201. That date will get waived if you're able to post a bond. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, sir, you're free to go back. Mr. Gunn. Mr. Gunn, sir, you're charged with trafficking marijuana. I am not allowed to set bond at this stage on this charge if the amount alleged is more than 10 pounds. The amount alleged in your case is 29 pounds. So bond is going to be denied according to the Georgia Code 17-6-1. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning. Looks like that you are going to hire your own lawyer. Is that correct, sir?
Yes, sir.
You're going to have a preliminary hearing date, a bond hearing date set for April 29th at 8:30 in the morning. So when you hire your lawyer, Mr. Gunn,
excuse me, I'm sorry. Can you can appoint me one first, and then I just get one? Like, you know what I'm talking about?
Yes, sir. Are you currently working, Mr. Gunn?
No, sir.
I'm sorry.
No, sir.
Okay. You do qualify for the appointment of a lawyer. So whether you go with the appointed lawyer, whether you hire a lawyer, the lawyer will be able to speak to the district attorney's office about whether they will consent to a bond in your case. So you don't necessarily have to wait until April 29th to have a bond, but that's a discussion between your lawyer and the district attorney's office. And that determination is solely within the discretion of the district attorney. Do you understand that?
No, sir. You said I can get a bond before then if I do what? What I gotta do?
Okay, are you ready?
Yes, sir.
Your lawyer can look at the facts of this case and go speak to someone in the district attorney's office about whether they will consent to a bond. Believe it or not, I have at least 5 or 6 of these cases a day. A week. Sometimes prosecutors consent to a bond, sometimes they don't. A lot of that depends upon the person's criminal history, what happened during the arrest, and they take a look at it. It is a decision that the district attorney's office makes. This does not come back before a judge until April 29th. So between now and April 29th, your lawyer should be speaking to the district attorney's office to see if they will consent to a bond. If they do not consent to a bond, you have a bond hearing set for April 29th when this issue of bond comes back before a judge. Okay. Any other questions, sir?
I want why you can't grant me a bond on marijuana?
Okay, I'm going to repeat it. Hold on. I will answer that question for you. It's my job to answer your questions. Okay, you're doing the right thing and asking questions. So the statute in Georgia for trafficking marijuana says that a judge in my position at the first appearance cannot set a bond on a trafficking marijuana charge if the allegation is that the weight of the marijuana was more than 10 pounds. In your situation, the allegation is that the weight was 29 pounds. If the allegation was that the weight was 9 pounds, I could set a bond. So it's totally, you know how they do like mandatory minimum sentencing and all of that kind of stuff, and they take the discretion out of the judge's hands? Well, this is one of those situations where they've taken the discretion out of my hands at this stage. Comes back around, the discretion is handed back to me. Okay?
Oh, so if I sit until April 29th, then they come back to you?
Yes, sir.
But if I get my lawyer today, I can get a bond tomorrow?
Yes, sir.
Okay, thank you.
You're welcome. You're free to go back. Mr. Howard?
Your Honor.
Yes.
Someone has posted a bond for Mr. Howard.
Okay, Mr. Howard is OTB. Thank you.
Sorry to interrupt you, Your Honor. Mr. McGruder and Jeremiah Jones. Do you mind if we do those two last, Your Honor?
Sure. You said Magruder and Jones.
Yes, sir.
Okay.
And Howard is out for bond?
Yes, ma'am.
Okay, thank you.
Okay, so the next person I have is Brian Johnson. Mr. Johnson, sir, you're charged with 1 count of theft by taking. This is a misdemeanor offense. Bond is going to be set at $2,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Excuse me. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Johnson. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you are free to go back, sir. Mr. looks like Lee.
Yes, sir.
Mr. Lee, sir, you're charged with 1 count of simple battery, family violence. Bond is going to be set at $3,000. You're also charged with 1 count of cruelty to children in the 3rd degree. Bond is going to be set at $3,000. Both of these are misdemeanor offenses. There's going to be a stay away provision on this bond, to stay away from a Michelle Hunter. Do you understand that, sir? I'm sorry?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Looks like you did not fill out the form. Do you plan on hiring your own lawyer?
Yes.
Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Lee.
And the bail is, the total is? on the bail?
$6,000.
Okay, thank you.
You're welcome. Mr. Moore.
Yes, Your Honor.
Mr. Moore, you've been charged with one count of failing to register. I'm going to deny bond at this point. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning. You're going to also have a bond hearing date set for April 29th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, so you're free to go back.
Thank you.
You're welcome. Mr. Norwood.
Yes, sir.
Mr. Norwood, sir, you've been charged with driving under the influence of alcohol to the extent it made you a less safe driver. Bond's going to be set at $5,000. This is a misdemeanor offense. So you're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. And it appears you're going to hire your own lawyer. Is that correct, sir?
Yes, sir.
Okay. Do you have any questions for me?
No, sir. No, sir, because I figure it's still the same because he told me I was driving under influence high. He didn't tell me that alcohol.
So it's written on the bond order as alcohol. The allegation is that they believe that you were under the influence of drugs because they gave you the horizontal and vertical gaze nystagmus test. And so they believe that there were clues based upon what they gave you, the test they gave you, to lead them to believe that you were under the influence of a substance. Anything else, sir?
So that's still the same as alcohol.
Well, it's written the same. It says DUI less safe, so that's driving under the influence. And when you read the warrant, the influence or under the influence, they believe it was some type of substance. Okay. Anything else, sir?
Okay. You said $5,000?
Yes, sir.
All right. All right, thank you, sir.
You're welcome. You're free to go back. Mr. Stafford. Mr. Stafford, sir, you're charged with a number of offenses, and some felony offenses and some misdemeanor offenses. So the first count is aggravated assault by strangulation. Bond is going to be denied on that charge. Looks like there is an indication that you are on probation or parole.
Ain't no probation, Your Honor.
That's what it looks like, sir. But I also would have denied bond if that was not the case on this count. You're also charged with cruelty to children or to a child less than 18 years old. And that's a felony offense also. Bond is going to be denied on that. You're charged with driving a motor vehicle with an invalid registration or tag. Bond is going to be set at $500. Charged with fleeing from a police officer. Bond is going to be set at $2,000. Charged with obstructing or hindering law enforcement. Bond is going to be set at $2,000. You're charged with an improper U-turn. Bond is going to be set at $500. You're charged with improper lane change. Bond is going to be set at $500. Charged with reckless driving, bond is going to be set at $1,500. Charged with driving on a suspended or revoked license, bond is going to be set at $1,500. And you're charged with essentially making a turn without using the appropriate signal. Bond is going to be set at $500. There's going to be a stay away provision on this bond to stay away from a Jessica Hawkins. Do you understand that? Is it your intent to hire your own lawyer?
They never brought me the paper. I need an attorney.
Okay, hold on one second for me, sir. So would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
Per hour, 15.
I'm sorry, say that one more time, sir.
$15.75 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. I'm also setting a bond hearing date for April 29th at 8:30 in the morning, courtroom 201. And check with your lawyer as it relates to the parole or probation condition. Now, because of this charge of aggravated assault by strangulation, district attorney may not agree to a bond without having a hearing. But if you are not currently on probation or parole, you could receive a bond, but it will be within the discretion of the district attorney until we have a bond hearing. Do you understand that, sir?
Yes, sir. So how much is the bonds and all?
$9,000.
Okay, and why wasn't I granted bond for the cruelty to children? Even though my son wasn't on the scene when it happened, he came after the fact, like before the police arrived.
It was within my discretion, sir.
So the only two I didn't get bond for was the cruelty to children and
Aggravated assault by strangulation. Yes, sir. Mr. Sims. Mr. Sims, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision to stay away from a Taya Ledford, Tayah. Do you understand that, sir? Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Sims?
What if Taya contacts me?
This is to prevent you from contacting her. If you receive any kind of communications from her, you may want to not respond. But you should speak to your lawyer about whether you should or should not respond. Okay.
Yes, sir.
All right. Do you have any other questions?
No, sir.
All right. You're free to go back. I have Zayas, Zayas.
Yes, Your Honor.
Okay. Sir, you're charged with 1 count of criminal trespass. That is a misdemeanor offense. Bond is going to be set at $3,000. You're also charged with 1 count of disorderly conduct. Bond is going to be set at $1,500. You're going to have a total bond of $4,500. There's going to be a stay away provision to stay away from a Destiny Collins. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Looks like do you plan on hiring your own attorney?
You can appoint me one, Your Honor.
Okay, are you currently working, sir?
Not at the moment.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, sir, you're free to go back.
Thank you.
Let's see. I have a El Monte Sadler. So you're charged with 1 count of armed robbery. I am not allowed to set bond on this offense at this stage. You're going to have a preliminary hearing date set for April 25th at 8:30 in the morning. You're going to also have a bond hearing date set for April 29th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back.
Okay.
All right. I have an Abdul Nabi, Nabie, that was an add-on.
He's better, Your Honor.
Okay, sir, you're charged with 1 count of obscene or profane language. And basically saying during a 911 call, you use obscene or profane language. That's a misdemeanor. Bond is going to be set at $1,500. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor. May I ask a question?
Yes, sir.
It's a statement that will be retrospectively based upon what happened.
Okay.
Retrospectively and retroactively based upon what happened in that matter on that day. As I'm a sick individual suffering from manic depression, been in this country 31 years, looking at my history, my criminal background, I've never ever committed a crime in this country or any part of the world, traveled to Europe and all over, never committed a crime. Served for your military in this country. I tried to serve. I fell sick in the Navy, Great Lakes, Illinois. But yet still they look, people accuse me of crime. The dispatcher over the phone, whom I was speaking with, this is the statement in the question. I did not mean to speak to them that way because the person, they had infiltrated my phone and made sure that the person that I was talking to was not the dispatcher. I was assuming it was not. I was assuming that it was somebody else. So in this case, will clemency be granted? That's all I'm asking. Clemency. This is the 3rd appearance I made now. 2 appearances for obstruction of 911. So something has to be looked into. The matter the gravity of substance has to be weighed in court. And clemency has to be granted. I'm sick. I suffer from bipolar. They actually provoke me. This is something provocative going on. They infiltrate my phone, the electronic configuration that they messed up with. I know math and physics. I know about it. I studied in college. I know about physics. Physics is my area. But I'm sick. In my Einstein was sick. Something with dyslexia. I studied about the history.
Okay. Thank you, sir.
Yes,
I
sir.
have appointed a lawyer to represent you. Make sure you speak to your lawyer about the allegations contained in this warrant. You need to understand that that conversation was recorded.
Yes,
And hold on. Conversation was recorded, and
Yes.
that's the basis of the arrest. So speak to your lawyer about this case, and your lawyer will assist you. Do you understand that?
So you said the bond was 1,500?
Yes, sir.
Okay.
You're free to
I
go
have
back.
I have the right to call my people so they can pay my bond.
Yes, sir.
At the bonding companies, 10% or 15%, correct?
Roughly, yes, sir.
Okay, no problem. Thank you, Your Honor. Thank you.
You're welcome. Can we do Mr. Rosado before we get to the other two, Magruder and Jones?
Yes, Your Honor.
Mr. Rosado, sir, you're in the same boat as the young lady that I spoke to at the end on the lady side. It looks like there is a warrant for your arrest for armed robbery out of, looks like it says Connecticut Superior Court. And that they have indicated that they will extradite you. Did you hear what I told the young lady before as it relates to fugitive from justice?
Yeah, I was kind of listening, but it was kind of loud in here. But I just want to, with this offense that they're saying armed robbery, it had to be a type of, isn't this like a, well, because I'm on, it was a violation of my probation from 5 years ago. And it should be a rob too. It shouldn't be an armed robbery or anything like that. Like I understand what's going on. I had a court date out there that I missed, and I had COVID, so I was speaking with my probation officer. She told me, all right, just do what you got to do, bring your paperwork in, and they'll vacate it. But I guess I took a little too long, and they came and got me. But it shouldn't be an armed robbery like that. I believe that's a typo on it. I just wanted to clarify that so I know what I'm up against.
So what I'm looking at is a handwritten document from Clayton County Police Officer Denard. And it says that you have a current and valid warrant for, it says armed robbery out of Connecticut Superior Court, which would indicate to me that what you're saying is true because it says Connecticut Superior Court.
Is there a date on that, the armed robbery? So I can just.
I have the warrant number. It is 20111.
Hold on, I'm waiting for a pen. Sorry about that.
Oh, okay, no problem. Just let me know when you're ready.
All right, I'm ready.
2011205-133. And then there's something I can't understand the handwriting. It looks like it's DOW.
That should be date of warrant. Yeah, the date of warrant. That's what I'm asking for.
Thank you. So it says February 16th of this year.
February 16th of this year. Yeah, that doesn't sound like
Now let me, and I'll read the numbers to you because its handwriting is really bad, but it says DOW:0216221 period. So I don't know if that was 2021 or 2022, but those are the digits 0216221 period.
That sounds like something's wrong there. I have the probation robbery. It should be like 5 of them there, like that. The rob tool, the larceny, and all that. It shouldn't be nothing, no new charges or anything like that. Your Honor, could you read that?
I'm sorry.
Can you read those numbers to me again?
021622, and it looks like you know what? That's not a 1. It's 021622. That should be a closed parentheses, but it looks like a 1. So 021622 is the date of the warrant.
Yes, sir. It should be right after I had court on the 14th for my February.
Okay.
And I missed that court date, so now they came. It should be like a VOP for. I'm on probation for a rob too, like years ago, 5 years ago. That's what that should be reflecting. Just the armed robbery. That's what I was like. Hold up, this doesn't sound like something I'm aware of.
So I'll tell you, Mr. Rosado, sometimes there is a discussion that is had within court, and some judges, they'll just issue the warrant and say, well, if I issue the warrant now, I don't have to worry about it later. So if he's picked up on the warrant, then we can deal with it. As opposed to like you said, well, he has COVID, and then the case moves forward, and or it falls through the cracks or something like that. So it sounds like you have a handle on it. You may want to, well, the decision as to whether you want to waive that original hearing or not is up to you. Like I indicated to the young lady before, the only thing that's determined at that hearing is whether you're the person named in the warrant and whether the warrant is valid. Sounds like you're saying that you had a court date that you missed and that possibly this is valid. So you can waive that hearing as to determining whether it's valid or not, and then the clock begins to run. But as I indicated to the young lady, if it sounds like you've already been in communication with somebody in Connecticut related to this charge, do you have a lawyer? Do you have a lawyer?
Not about this.
Hold on. Do you have a lawyer representing you in Connecticut?
Not at the moment. I was seeking counsel.
Okay. So the first thing you should do is to get a lawyer, because if what you're saying to me is valid, that lawyer most likely can have this warrant lifted, a new court date set, and you'll get released from here.
So, right. So with that being said, that's what I would need to know. What's the right thing? Should I waive this or should I not? Because I know for a fact, I talked to my probation officer, the bondsman. I have my COVID paperwork. They said, as long as you got your documents, we can prove that. All right, when you come in, it's still a warrant out for you, but we can get it vacated once you arrive, and we'll go about it that way. So now I just need to know what's my next steps doing that.
So I can't advise you whether it's in your interest to waive or not waive. I can only explain the process to you. It's my job to answer any questions. So if you have questions about the process, I can answer those, but I can't advise you as to what you should or should not do, because that's totally within your discretion. Does that make sense to you?
Yeah.
So let me explain the process again to you, or more fully explain it, and then that may bring questions to your mind that I can answer. So because you're wanted out of Connecticut for this, it looks like failure to appear, there's a warrant issued for your arrest. The only thing that we determine here is whether there is a warrant and whether the requesting jurisdiction, which is Connecticut, whether they intend to extradite you. If there is a warrant and they say they intend to extradite you, it is our duty to hold you. Now, once you're being held, it is my duty to inform you of the process. So if you were to say to me, hey, I don't believe these charges are valid, I believe this is bogus, you have a right to a hearing. And if you ask for that hearing, sometime within the next 90 days, the hearing will be held. But we're not here to determine whether you're guilty or innocent or any of that stuff. We're only here to determine. Okay, go ahead, sir.
The only thing I was just, all right, so we could clarify this. Is there a FT attached to the armed robbery, or is there just a whole new case? Like, is it just, because I will understand right now, then I know what I can do on moving forward. There should be the FT, I can understand, and I actually know what's going on.
That's fine. I'm gonna read to you what I have before me, okay? Right. And this is from, looks like Officer Denard. The allegation is that you have a warrant, a current and valid warrant for armed robbery out of Connecticut Superior Court. It gives the warrant number, it gives the date of the warrant. It says the warrant was verified on GCIC, which means they ran your criminal history and verified that the warrant is showing as outstanding. So then this is the language that gets into sort of the term of art. The accused did unlawfully enter in this state or remained in this state unlawfully and willingly. This occurred in Clayton County, Georgia. That's it. So what that language means when it says that you entered or remained, that's what makes you a fugitive. Because because the basic allegation is that you have warrant for your arrest and you're fleeing from that jurisdiction. Okay. Now, does that help you as to decide what you want to do?
It really doesn't, because I just.
Okay, so let me finish. Let me finish. Hold on, stop. Let me finish everything I have to say, and then I'm gonna ask you again, okay? All right, so at the end, but sometime between, if you ask for a hearing, sometime between that, from today and 90 days out, there will be a hearing. The only purpose of that hearing is to verify your identity and to verify whether this warrant actually exists. If at the end of that hearing, the judge determines that those conditions exist, the judge signs off on a governor's writ, and that tells Connecticut, now the clock begins to run for them to come and get you. That clock starts from the date that the judge signs that writ after that hearing. It can be 30 days up to 60 days, okay? If you know that you're the person named in the warrant and you believe that the warrant exists, you can waive that 90-day period. And by waiving that 90-day period, the clock begins to run today on the 30 to 60-day period where Connecticut has to come and get you. If Connecticut does not come and get you, the sheriff's department here will contact Connecticut and determine whether they intend to come and get you. And they may say, no, we changed our mind. And then you'll get released out the front door. But the warrant is still valid. So you can get released out of the front door. You go 5 minutes from here, you encounter another law enforcement officer. They run your history. They see that the warrant exists. They're going to arrest you. And then that process starts all over again. So that's why it's important to have someone in Connecticut to deal with this issue up there. Because if you don't, you're just going to potentially be on a wheel. So what I tell people is that I have seen circumstances where a person hires a lawyer, the lawyer contacts up in Connecticut, the lawyer contacts the district attorney's office or prosecutor up in Connecticut, hey, he had COVID, this is the stuff we have, it was all a misunderstanding. And they've said, oh, okay, you're right. We'll just call down to Georgia and tell them to release him because we've agreed on a new court date. That has happened, it does happen. I don't know what will happen because I don't know anybody up in Connecticut. So all I can do is tell you the process. You know more about this than I do. Exactly. So that you tell me which way you want to go, and I'm fine either way.
Yeah, I know. I'm ready to get this situation over. I know I have the warrant now. It's just it seems like it's not the right warrant on these documents that's in front of me. That's the problem I'm facing. Like the armed robbery, it's new to me right now, and I know that I shouldn't have an armed robbery out right now. Unless you're saying it's coming from the courts, if it's that, it should be attached with like the FTA, and then I can say, all right, yeah, everything is fine. I can sign waive, tell them come get me, and we can just take care of it. That's the problem.
So, sir, all I can tell you is what I have before me. It says armed robbery out of Connecticut Superior Court. If it was a warrant from a Clayton County Sheriff's Department, it would say warrant for armed robbery verified by the Clayton County Sheriff's Department.
Okay. Oh, so it's already in court is what it's saying. That matter is already in court.
Sir, I can only read to you what it says. Again, I'm a lawyer. Listen, stop. I'm a lawyer here in Georgia. I have never stepped foot in Connecticut. Anything I tell you about the court system up in Connecticut, I will be pulling it out of left field. So that's why I have to be clear with you that I can only read to you what I have before me. I can't opine on what's going on up in Connecticut because I have never set foot in the state of Connecticut. Does that help? So let me say it this way. Whatever decision you make here today, you are not pleading guilty to anything. So if your concern is that, hey, if I do one thing or another, they got me.
Right, that's what I'm worried about, me attaching my name to an armed robbery right now. And I know
Hey, your name is already attached to this.
but I'm me signing off on it is like me saying I'm guilty.
Sir, you are not pleading guilty. Your name is already attached to this. That's why you're here before me right now. The only way your name gets unattached to this is by dealing with it up in Connecticut. Does that make sense to you?
Mhm.
We don't care whether you're guilty or innocent. We don't know whether you're guilty or innocent. We don't make a determination as to whether you're guilty or innocent. Our job is to determine whether you are the person named and then notify them so that they tell us whether they're going to come and get you or not. If they were to say to us again, we ain't going to come and get him, you could get picked up every 90 days on this until you deal with it. Does that part make sense to you?
I mean, well, I should have, by the date you told me, I should have just understood it, because I know I wasn't even in the state to 16, but I'm gonna go ahead. I want them to come get me so we can just get this situation over with.
Okay, they will give you the waiver forms. The waiver forms will be sent to me. And as I indicated before, you should get a lawyer to represent you or someone to make contact up there. Because if this is a situation where you simply missed a court date, they may not want to spend thousands of dollars to come and get you to bring you back up there when they can just set a new court date and release you.
That's what's going on. That's what I was under the impression was going on. Me, I'm complying with my probation officer. She said, "All right, just let me know what's going on when you get it situated. I know you're sick right now." I'm like, "All right." Next thing you know, the cops is coming and pull me out.
So based upon that, who's the first person you should contact?
My probation officer.
There you go. I guarantee your probation officer knows way more about this than I do.
And then, like you said, and if they're not coming to get me, how long do I have before you guys will be able to release me?
So I have seen through personal experience, today is Wednesday. Person appears before me Wednesday, person hires a lawyer. This was in Tampa. By Friday, there is an order from the judge in Tampa to release the person. But it's on you, sir. It's not on anybody but you. Okay? All right. Once you sign the waiver, sir, you're free to go back. So who do you want to deal with next? Is it Jones or Magruder?
All of this?
Go stand by the sheriff. I got you.
I'm done?
Yeah, sign of them just normal. Yeah, I have both Jones and Magruder present and ready to go. We're here.
Okay.
First.
Let's deal with Mr. Magruder. Good afternoon, Mr. Magruder. Sir, you're charged with 4 misdemeanor offenses, and each one of these offenses, the bond is set by schedule, which means it's automatically set. So I'm going to read the charge to you and the bond amount. Okay.
Yes, sir.
You're charged with 1 count of pedestrian walking along the roadway. That's a $500 bond. You're charged with 1 count of giving a false name, address, or date of birth. Bond has been set at $1,000. You're charged with 1 count of carrying a concealed weapon. That's a misdemeanor. Bond is automatically set at $5,000. And you're charged with 1 count of obstructing an officer. Bond is automatically set at $1,000. So you're going to have a total bond set at $7,500. Your preliminary hearing date is going to be set for April 26th, excuse me, at 8:30 in the morning courtroom, 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to appoint a lawyer to represent you?
No, sir.
Okay, do you have any questions for me, Mr. Magruder?
No, sir.
Okay, sir, you're free to go back. Mr. Jones?
Jones. Yeah.
Mr. Jones, sir, you're charged with 1 count of criminal trespass, meaning that you were told to not come back to a location and you came back to that location. I'm setting the bond at $1,000, which is the lowest amount I can set for you to be able to post bond through a bonding company. It indicated on the warrant that you're homeless. Is that correct, sir? Did he say yes or no?
Sir, so what?
It said that you are homeless. Is that correct, sir?
Yes, sir.
Would you like for me to appoint a lawyer to represent you?
Yes, sir.
I'm going to appoint a lawyer to represent you. Now, sir, you have to stay away from this Exxon on Tara Boulevard because they have given you a criminal trespass warning. Whenever you go back to that Exxon, you're liable to get arrested. Do you understand that, sir?
Sir.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay, give me one moment. Before I get started, are there any other issues or problems that I need to be made aware of or that we need to address?
No, Your Honor.
No, Your Honor, I'm good to go.
Okay. We have one more CAA form, trying to take advantage of my time, use my time wisely. Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bail. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God? Okay, let's begin on the ladies' side with Ms. Cannon. Ms. Cannon, good morning, ma'am.
Good morning to you too.
You're charged with one count of an open container violation. All of these are misdemeanor offenses that you're charged with. The bond for the open container violation is going to be set at $500. You're charged with one count of driving under the influence of alcohol. Bond's going to be set at $5,000. And you're charged with one count of tampering with evidence. Bond is going to be set at $1,000. So you're going to have a total bond of $6,500. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, yes, sir.
Okay, approximately how much do you make per hour, ma'am?
It varies. I work for a staffing company.
Okay.
So it varies from like 13 to 15.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, I do not.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Ms. Harry?
Good morning.
Good morning, Ms. Harry, ma'am. You're charged with one count of theft by taking as a misdemeanor. The bond is going to be set at $2,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, thank you, sir.
Okay. Do you have any questions of me, ma'am?
May you repeat the, so, I'm sorry, if I bond out, I get a new court date?
Yes, ma'am.
Oh, okay.
So
All right, that's
just so
fine.
you understand, what happens is when you bond out, your case gets sent to the state court, and then it gets assigned a judge. And because I don't know who that judge is, yet we can't give you court dates for that judge. So once your case gets to that judge will then send notices out for that judge's court dates.
Okay.
Okay. All right, ma'am, you're free to go back.
All right, thank you.
You're welcome. Ms. Hughes. Ma'am, you're charged with 2 misdemeanor offenses. I've set the bond at $1,000 for each offense, so that's a total bond of $2,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yeah, I've already done that.
I'm sorry, ma'am.
I've already filled out the paper. I was wondering if I can possibly get an OR bond. Someone spoke to me.
Okay.
I really wish I
no.
wasn't walking with the wrong person. I just want to do a cut.
Okay, ma'am, I did not
Wasn't hanging
see your form. So let me ask you this question again. Would you like for me to determine whether you qualify for the appointment of a lawyer?
Yes, you can.
Okay. Are you currently working, ma'am?
I don't have no income. I have income that I can't get because I don't have my birth certificate. So I can't get out on a $200 bond.
Are you currently working, ma'am?
No, I'm not.
Okay.
Trying to get my stimulus from last April, my SSI checks. I have not yet got identity force. I'm not working.
Okay. You do qualify for You do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. I'm going to deny your request for an OR bond. Is there anything else, ma'am?
No, there's not anything else. So I have to sit up in here and wait for April. Got no income at this moment I can reach.
I would encourage you to speak to your lawyer and see what your lawyer can do. Your lawyer most likely can work something out with the solicitor's office for your release, but you're going to need to speak to your lawyer about that, okay?
I'm ready to go back home. I live in Virginia. I've been here almost 2 years. I'm so ready to go back home.
Okay. Is there anything else, ma'am?
I don't talk to you. No.
Okay. Okay, you're free to go back.
They talk a lot out here in Georgia. It bothers me. They talk a whole lot. So what is my court date or whatever? Because this man rushing me. I don't want to go to my cell, judge. I already said I was going to say it to you because I have a female in there. I came in yesterday, of course. It's peeing on the floor.
Your Honor, is she?
And they want to make me go into some cell with the girl peeing all over the floor. This is nasty and waking me out of my sleep.
Okay, ma'am, you're free to go back. Ms. Kilgore? Ms. Kilgore?
I'm sorry.
Since she's still in the court date, can you retire? Can you recite the court date?
Oh, excuse me, y'all.
Can you?
April 26th at 8:30 in the morning, courtroom 201.
I'm sorry, you may continue.
Okay, are we ready to move forward with Ms. Kilgore?
Yes, Your Honor.
Ms. Kilgore, ma'am, you've been charged with 1 count of loitering or prowling. This is a misdemeanor offense. Bond is set by schedule at $1,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, did you say yes?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Miss Marion, you're welcome. You're free to go back, Miss Kilgore.
Okay.
It looks like the video is frozen.
You don't have to sell it, just wait in here. If you came from intake, wait in here, because you don't have to sell it.
Okay, I can see it now.
Okay, Your Honor. Cool. Let me try it again. Give me one moment, Your Honor.
No problem. Okay, are you Miss Marion? Ma'am, you're charged with 2 driving-related offenses. The first charge is driving a vehicle with defective headlights. The bond is set by schedule, meaning it's automatically set at $500. You're also charged with 1 count of driving on a suspended license. This is also set by schedule. The bond is set by schedule at $1,500. So you have a total bond of $2,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. Excuse me, that date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please. Yeah.
I'm sorry, ma'am?
Yes.
Okay. Okay, ma'am, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back. Miss McClure. Ms. McClure, ma'am, you're also charged with 2 driving-related offenses. The first charge is driving on a suspended license. Bond is automatically set at $1,500. And you're also charged with having an obscured license plate. Bond is set at $500. These are both misdemeanor offenses. You're going to have a total bond set at $2,000. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. About how much do you make per hour, ma'am?
I make about 15, between 15 and 16 an hour.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, that'll be all. Thank you.
Okay, ma'am, you're free to go back.
Oh, I'm sorry. What was the date? You said April?
April 26th.
26th. Okay.
Yes, ma'am. But that date will get waived upon your bonding out, and you'll receive a new court date in the mail.
Okay, thank you.
You're welcome. Miss Neely.
Hey, how you doing?
I'm doing well, ma'am. You're charged with one count of aggravated assault. I've set the bond at $10,000. This is a felony offense. There's going to be a stay away provision on this bond to stay away from a Stacy Walcott. Do you understand that, ma'am?
Yes.
Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201.
Hold on, can you repeat that one more time?
Yes, ma'am. April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yeah.
You didn't
sure.
fill out the form, so that's why I was asking. Do you plan on hiring your own lawyer? Or?
Yeah, my wife was gonna do it. So.
Okay. So now I can make that determination, or you can go with hiring your own lawyer. It doesn't make me. I'm sorry, ma'am.
I'll let you do it. Check into it for me just in case something goes wrong.
Okay. Are you currently working, ma'am?
No.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, not that I can think of right now.
Okay. You're free to go back, ma'am.
Thank you.
You're welcome. And I apologize if I pronounce the name wrong, but is it Pacheco? Good morning, ma'am. Did I pronounce your name correctly?
Good morning, you did, Your Honor.
Ma'am, you're charged with one count of contributing to the delinquency or deprivation of a minor. This is a felony offense. Bond is set at $3,000. You're also charged with one count of reckless conduct. The bond is also going to be set at $3,000. And I don't know if you're aware or not, but apparently these warrants were taken out in May of 2019. So that's where these charges are stemming from. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. About how much do you make per hour?
16.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back. Miss Shannon. Miss Shannon, ma'am, you're charged with one count of obstructing an officer. This is a misdemeanor offense. Bond is going to be set at $2,000. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, I'm sorry. How much do you make per hour, ma'am?
18.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Sorry, I just discovered an error that I made. Put the wrong information on the wrong form. Give me 1 second. Okay. Do you have any questions of me, ma'am?
No.
Okay. You are free to go back. Miss Smith, Bianca Smith. Ma'am, you're charged with one count of theft by taking as a felony, bond is going to be set at $5,000. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
You say
Would you like
April
April 27th? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Miss Williamson.
Yes, Your Honor.
Ma'am, you're charged with one count of simple possession of a controlled substance. Bond is going to be set at $3,000. This is a felony offense, so your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201.
Sir,
That date,
I do have a question for you.
I'm going to get to that in a second. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was the question you wanted to ask?
I was actually called and turned myself in, or turned him in so I could get in a rehab center. What can you help me get in rehab?
Okay, so that matter is not before me at this time. Your case is going to get assigned to the public defender's office. Have you been in a rehab situation before?
No, sir.
Okay. Speak to your lawyer, the district attorney's office. They will enter into, sometimes they call it they'll call it a drug court fast track. And basically what happens is your lawyer, district attorney's office, you work out a situation that will result in your being able to get treatment. And depending on what they negotiate, sometimes is treatment in lieu of punishment, so that there will be the possibility of punishment if you don't complete treatment, or they'll do certain things. They may consider other choices. But the short answer to your question is that yes, you can get help. You have to let your lawyer know so that your lawyer can advocate on your behalf with the district attorney's office, okay?
All right, thank you.
You're welcome. You're free to go back, ma'am. Ms. Wilson.
What's the first name, Your Honor?
Denzel, her charges are set by schedule, so she could have bonded out.
That's a
Yes,
mail.
ma'am. Yes, ma'am.
She's out the bond.
That's gonna be a mail, Your Honor.
It's a male?
Yes, Your Honor.
Okay, I'm sorry. It does say that on this form. All right, so Marshall Pope, or Pope Marshall. I'm sorry, go ahead.
Before she goes, we have a Sydney Reynolds.
Sydney Reynolds. Hold on. Let me look at my other stack.
Excuse me, Your Honor, when Ms. Marshall Pope goes up, can Mr. Bicken go up as well? He's featured on the male side.
Yes, sir. Okay. I do have Miss Reynolds. It's in the wrong stack. So let's see. Let's bring up Sydney Reynolds.
Good morning, Your Honor.
Good morning, ma'am. You're charged with 3 offenses. The first offense is driving a vehicle with defective equipment. Bond is going to be set at $500 for that. The next 2 charges are felony drug-related offenses, and bond is going to be set at $5,000 for each offense. So you're going to have a total bond set at $10,500. Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
Your
Would you
Honor,
like to?
I
Hold on,
apologize.
hold on one second, ma'am. Would you like me to see if you qualify for the appointment of a lawyer?
Sure.
Okay. Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Now, what was your question?
I just wanted to know if you could repeat that date. I didn't get it. I'm sorry.
Sure, April 26th at 8:30 in the morning, courtroom 201. But keep in mind, upon your bonding out, that date will get waived and you'll receive a new court date in the mail, okay?
Yes, sir. Thank you.
Any other questions, ma'am?
No, sir. I appreciate
Okay, ma'am, you're free to go back. So now let's bring up Miss Marshall and Mr. Rick Bickham. Okay, Miss Marshall and Mr. Bickham, you are both in the same position, meaning that you are alleged to be fugitives from justice. And what that simply means is that there is a warrant for your arrest in another state, and that other state has indicated to the Clayton County Sheriff's Department that they intend to extradite you, to bring you back to the requesting jurisdiction to have these charges resolved. In the case of Miss Marshall, you are charged with being a wanted person out of Greenville County Sheriff's Office in South Carolina. There's a warrant for your arrest for fraud. And Mr. Bickham, you're charged with being a warrant, I'm sorry, being a fugitive for justice. There's a warrant for your arrest out of Harnett County, North Carolina, for trafficking marijuana. So for both of you, Clayton County has no interest in your innocence or guilt. We're simply holding you due to a contractual relationship that all states have, that they will hold a person that another state labels as a fugitive. This process involves 2 components. You can waive your right to a hearing today, and a clock will begin to run where each state, South Carolina, North Carolina, will have 30 days to come and pick you up and bring you back to that jurisdiction. They can request an extension of an additional 30 days for a total of 60 days. If either South Carolina or North Carolina, if they don't come and pick you up, you will get released out of the front door. But that does not mean the warrant goes away. So you could get released out of the front door. 5 minutes later, you encounter another law enforcement officer. They run your information. You can go right back to jail, and this process starts all over again. You have a right to have a hearing to determine whether you are the person named in the warrant and whether the warrant actually states a charge that can be prosecuted. If you were to tell me today that you want to demand that hearing, sometime between today and the next 90 days, that hearing will be held, where at that hearing, the only thing the judge is going to determine is whether you're the person named in the warrant and whether the warrant in fact states a charge. Are you with me so far, Miss Marshall?
Sort of.
Okay. Do you have any questions? Because I'm here to answer any questions that you may have.
And I still don't quite understand either one of these.
And so I'm asking you to tell me what you don't understand so I can explain it to you.
I would say, if I waive my rights to a hearing, what happens?
If you waive your right to a hearing, the 30-day clock that I indicated earlier begins to run today.
Okay.
And if South Carolina does not come and pick you up within that 30-day period, and they do not request a 30-day extension, you will be released from the sheriff's department.
Okay, so 30 days I gotta spend in jail.
Not necessarily. What I explain to people is this, especially during this pandemic times. A lot of times, person that's in your position or Mr. Bickham's position, if you were to hire a lawyer up in South Carolina, I've had, for example, people that appeared before me on a Wednesday based upon the same allegation, fugitive from justice. They either had a lawyer or hired a lawyer in the jurisdiction where they were located. They worked everything out, and by Friday, that person was released from the jail. So that's the importance of what you have to understand is that Clayton County is not here to do anything related to these allegations.
Okay.
So if we are told to release you, we will release you. If we're told to hold you, we will hold you pursuant to the statutory period of time. Okay. Any other questions, ma'am?
That's with waiving my rights, is that right?
What you're doing is you're waiving the hearing to determine whether you are the person named in the warrant and whether the warrant actually states a charge. That's what you're waiving. You're not waiving, you're not pleading guilty, you're not doing anything other than saying, hey, I believe I'm the person named in the warrant. I may not agree with the warrant, but I understand that it's charging me with a criminal offense. I'm innocent of that offense. I want to go back to South Carolina and I want to fight this. Okay. Whether you choose to have the hearing or whether you choose to waive the hearing, the end of that result of the end result will be you will be going back to South Carolina to deal with those charges. So the question is it going to be 6 months from now? Is it going to be 30 days from now? Is it going to be 10 days from now? You have control of that. That's the one thing you do have control over.
Okay, I'm just trying to figure out which one is the 10 or 30 and not the 90.
That is if you were to waive the hearing to determine whether you are the person named and whether the charge is in fact a charge. That's the only thing that you're waiving.
Okay.
Okay. So
I haven't had a lot of sleep.
No, ma'am. It's my job to answer your questions. So that's why we have this process. Are there any other questions that you have about this process?
No, but I would like to say that I was in the last 12 hours. They did not go ahead and do whatever they do to put you in jail. They did not let me call anybody. And I haven't eaten or had any food or anything to drink.
Okay.
The treatment was not good.
So what generally happens, ma'am, is there is you can imagine like this is a wieldy process. And sometimes your treatment is dependent upon when you enter the process. As the jail, primarily, they're trying to get people before a judge as quickly as possible. And so depending on the time that you were brought into the jail, largely that dictates what they do. So what I do know, what they try to do is to get people before a judge as quickly as possible. And sometimes that may mean that you don't get a chance to use the phone as you may want to, or you don't get a chance to eat as you may want to. Generally, after this process, things slows down and you're able to use the phone, you're able to get medical attention, you're able to get the things that you need. So I apologize on behalf of the county for that, but
And
it
so
will happen. It will happen.
I stood in the window and watched. And when they got the point that they weren't busy, they didn't do anything. They literally didn't do anything. It was wrong.
I understand. And like I said, I do apologize on behalf of the county. But do you know what you want to do as it relates to waiving the hearing or having the hearing?
Yeah, we decided to waive the hearing.
Okay. They're going to present you with documentation. You're going to sign that. They're going to send it to me and I'm going to sign. And the process will begin to run today. I will, I can't state anything of certainty, but based upon what I see, if you're able to get someone to contact the authorities in South Carolina, you have a very high likelihood of walking out of this jail and having to go back and deal with those charges on your own. Okay.
Yeah, well, I can somebody if I can get to a phone.
Okay. You will be allowed to use a phone after this here. Okay. Mr. Bickham, is there anything else, ma'am?
No.
Okay. Mr. Bickham, did you hear my conversation with Ms. Marshall?
Yes, sir, I did.
Do you have any questions about this process?
No, I fully understand the process, but I do have questions about like the way the process was handled overall.
Okay.
So I just heard you tell the other lady that, you know, Clayton County is not interested in my innocence or guilt or my prosecution in this case at all.
That's
So
correct.
I was apprehended at the airport by the fugitive task force and I guess the marshals for the warrant. I guess you guys have this connection between states. And but you know, I had money on me, not a large sum of money, just pocket money, and I had jewelry on, and they confiscated everything here, you know, not by request of North Carolina, because I'm on bail from North Carolina with a paid attorney. I'm not exactly sure why they revoked it, but like this has nothing to do with Clayton County. And you know, like, I mean, the money's just spending money. I have no money on my books. I have no one in this state. I'm just passing through. You know, I mean, the jury was left to me from my family. You know, I got receipts and GI certifications at home, and I just don't want to get caught up in the process of everything that's going on because I may never see this county again with COVID and everything going on. I just really don't understand like what that would benefit them for keeping it here if I don't have any charges here whatsoever.
You're saying your property?
Yeah, like, well, they gave me the clothes I was wearing, but it's like I had, you know, my carry-on suitcase. They're like, oh, the jail's not going to take this. We're going to put it in evidence. I had my money. They're like, oh, you know, you don't want to answer our questions after we Mirandatize you, but I just exercise my right to remain silent. I don't have anything to do with this county. So once I exercise my right to remain silent, that's when everything kicked into place. You know, they confiscate my jewelry, went from my property bag to an evidence bag that's going to go in an evidence locker somewhere. My money went from a property bag to an evidence bag that's going to go in evidence somewhere. It's like $900. You know what I mean? And it's just like, I mean, I don't know. They deal with a lot of different walks of life. So maybe they thought I was being a jerk or maybe they're trying to be spiteful, but I just would like to get my stuff and go about my business and take care of my situation so I can get back to my family without having to revert back here. Because, you know, it is worth a large sum of money.
Oh, okay. I was listening to you. I have an answer for you.
I'm ready. Apologize for the long drawn out, you know.
No, I understand. So what happens is this. If your property is placed in an evidence bag, the agency that made the arrest, they will place that property in evidence. You still have an ownership interest in that property that's placed in evidence. If there is some kind of connection between that property and any crime that's being investigated, that property may remain in evidence. As it relates to things like cash, most often what happens is that cash gets logged into evidence, and unless the cash itself is considered contraband, meaning, let's say, like they believe it to be fraudulent, that is forged documents. So that may be evidence that is brought out in a trial. It remains in evidence. If it is cash, they will convert it into a check. And so you can understand the value of just not having cash sitting around on a shelf where someone can just come and open the bag and take some money out. So that relates to the cash. As it relates to a suitcase or anything like that, placing it in evidence is actually for your benefit, because it gets basically is safely kept. You will have the ability to request your property back, your money back, everything back. If you are in a situation where let's say you're arrested at the airport and they just leave your suitcase there, somebody could walk along and take your suitcase, and now they're enjoying your items.
No,
So hold on, place it in evidence is safekeeping for your benefit. The sheriff's department is not in a position where they're going to take your suitcase, because that's not evidence. Any property that is on you when you're booked in, the sheriff's department will place it in their own storage, so that when you bond out or you leave, you get everything that they took from you here. So it looks like it was the Clayton County Police Department that arrested you. So you're going to have to go through the Clayton County Police Department to obtain your property back. And it's simply a request for the return of property.
I mean, I understand about the suitcase, but it's like you said about the cash and the jewelry. There's no evidence. I mean, it's not, there's nothing that they need to keep here to help my case, not to help it, but that's evidence a part of the case I have going on there. What I have going on there has nothing to do with here. They don't want my jewelry there. They don't want my money. Like, they already returned that to me when I got bailed out from there. It was just, what I mean? It's literally, Your Honor, that I can understand the suitcase, but the suitcase is not here. It's at their police station, wherever they're at.
I understand. Let me try to explain it to you, Mr. Bickham. I don't know the jewelry that you had. Let's say it's $100,000 worth of jewelry, and you're walking through that jail with $100,000 worth of jewelry. You're probably going to be stuffed in a locker somewhere with blood coming out of you, and somebody's going to be walking around with that $100,000 jewelry. So do you understand how that?
I do understand. I think that I'm kind of not being too clear. I wasn't trying to keep it on. I just wanted it to be put in my property with the rest of my property here in the jail, where they store the property in the jail. My property is not in this jail. It's not, the sheriff's department doesn't have it here. They have it at Jonesburg or wherever the narcotics.
If you were arrested by the Clayton County Police Department. So let me, again, I don't know your case. I don't know if they're looking at you as being El Chapo Jr. And they are investigating you in that regard. So I hear what you're saying. I'm explaining to you the circumstances under how and where that took place. You definitely need to speak to your lawyer about it, because again, sir, you could be El Chapo Jr. They could have had helicopters watching you the whole time. I don't know. And so when you're telling me about this, I have no idea. All I can tell you is that there's a process that's in place. There's a process that your lawyer would know, and how to obtain that property. It's not going to be the officer that arrested you. Guarantee you, he's not walking around now with your jewelry on. I guarantee that. So, sir, you know your circumstances, and I'm not going to ask you about your circumstances. I can only explain to you the possibilities under where what you've explained to me, how that can happen.
Yeah, and I understand that. That's what I'm saying. It went from my property bag to them saying, oh, no, we're not giving it to them. We're gonna take it. You know?
Sir, again, I don't know if you are Mr. Smith that teaches Sunday school every Sunday, or if you're El Chapo Jr. I don't know. So I can't answer what you were trying to get me to answer.
Yeah. I mean, but even the state has interest in El Chapo, you know?
Sir, let me ask you this. Do you know where I went to school? Do you know what I did yesterday? Do you know what I said to my wife this morning? You don't know any of that stuff because you're not involved in my life.
No, yeah, for sure.
So if I come to you and I say, well, you know what? I talked to my wife and she said, blah, blah, blah. And like, I don't know your wife. I don't know this. Maybe you messed up. Maybe you didn't mess up. Maybe she's right. Maybe she's wrong. I am a stranger to you, just like you are a stranger to me. If law enforcement took it, they took it for a reason. But you know it's in evidence, and you know that you have a lawyer, and you know you can make the appropriate steps to take it back. Because I don't know you and I don't know the circumstances of your case, I'm not going to opine as to whether it was appropriate or inappropriate. Whatever took place, that matters not before me. The question before me right now is, do you want to sign the waiver or do you want to have the hearing?
I signed the waiver.
Okay. Did I answer your questions to your satisfaction, Mr. Bicker?
Yeah, you did. I just have one more question. What's the process that I take to start to like get my stuff back?
If this was taken for safekeeping, then you most likely would just have to call over to the Clayton County Police Department to request the return of your evidence. Your property. If it was taken as a part of a larger investigation, you will most likely have to go before a judge to have a judge sign an order for the return of that property to you. Because upon request, if the police say, well, we're investigating Mr. Bickham for X, Y, and Z, they will have to show to a judge's satisfaction that the property that they're holding is properly subject to an investigation. And if they can't, the judge will sign the order for the return of the property. Okay.
I can make that request while I'm still in custody, or do I have to be out of custody to make the request for the property?
The best thing for you to do is to first get yourself out of custody and then go back and get this, because you said you have a lawyer. First thing you should be worried about is your freedom, not some jewelry. Once you have your freedom, then you can start worrying about the jewelry and the money. Because you get it back and you're still in custody, it's not gonna come to you. Okay?
Oh, for sure.
Anything else, sir?
No.
Okay, you're free to go back after you sign the waiver. Let's switch over to the male side.
Oh.
Let's begin with, and I apologize if I mispronounce the last name, but it looks like it says a Mason or a Manson, M-A, I'm sorry, A-M-A-S-O-N.
Yes, supposed to be spelled A-M-O.
Sorry, sir.
It's supposed to be spelled A-M-O.
Ah, okay. Sir, I'm gonna make that change on your bond form just so it will hopefully prevent any confusion. So you're charged with 2 driving related offenses. The first is driving on a suspended license. The bond is going to be set by schedule, which means automatically set at $1,500. You're also charged with having a expired tag. The bond is set at $500 for that offense. Your total bond is going to be $2,000. These are both misdemeanor offenses. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to, well, it looks like you said you refused. You're gonna hire your own lawyer, sir?
I'm homeless. I can use a lawyer.
So you want me to see if you qualify?
Yes.
Are you said you're homeless. Are you currently working?
I know.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I know, sir.
Okay, you're free to go back.
You said April 26th.
Yes, sir, but that date will get waived upon your bonding out. And based upon these charges, if you don't believe that you're able to bond out, speak with your lawyers and they can move this process along a lot faster.
Okay, thank you, sir.
Okay, you're free to go back. Mr. Anderson. Mr. Anderson, sir, you're charged with 1 count of battery. Your bond's gonna be set at.
That's not me. Are you looking for Michael Anderson or James Anderson?
James Anderson. I'm sorry, James Anderson. Mr. Anderson, sir, you are James Anderson, correct?
Yes, sir.
Sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. And you're charged with 1 count of false imprisonment, which is a felony. Bond is going to be set at $10,000. So you're going to have a total bond set at $15,000. There's going to be a stay away provision on this bond to stay away from a Cynthia Anderson. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Anderson. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
She's not able to bail me out at this point.
No, you can go through a bonding company, but Cynthia Anderson is not going to be allowed to be on your bond.
Thank you.
Okay, you're free to go back, sir. Michael Anderson. Okay, Mr. Anderson, you're charged with 2 misdemeanor offenses: possession of marijuana less than an ounce. Bond is going to be set at $1,500. And use or possession of drug-related objects. Bond is also going to be set at $1,500. So that's a total bond of $3,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Anderson. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Yes, sir.
Mr. Is it Bath, B-A-T-T-H?
Yes.
Leave the weapon. Huh? Leave the weapon.
Yes, sir.
Sir, you're charged with 1 count of simple assault. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Crystal Conklin. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, sir?
Yes.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. Mr. Battle. Mr. Battle, sir, you're charged with 1 count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. 1 count of possession of a weapon by a person or handgun by a person under the age of 18. Bond is going to be set at $5,000. That's a misdemeanor. And you're charged with possession with intent to distribute marijuana. Bond is also going to be set at $5,000. So hold on, sir. I'll let you speak. Just let me speak. So you're gonna have a total bond set at $15,000. Your preliminary hearing date is gonna be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, I cut you off. What is it that you wanted to tell me?
Oh, now I was just finna ask you, was it $15,000? And I was finna ask you, do that first offender jump, is that jump real or like what that is? I ain't never been in jail.
Okay. So we're not at that stage yet, but first offender is real. That's something that you should have a discussion with your lawyer about based upon the facts and what take place. Your lawyer may look at the case and say, hey, I can get these charges dismissed. So you're not looking at first offender. Or the lawyer may say, hey, look, they got you. So now that comes into play. But that's a discussion that you have with your lawyer. Okay, sir?
Mm-hmm.
Any other questions?
No, sir.
Okay, sir, you're free to go back.
All right.
Mr. Bullock.
Your Honor, he was the one that had the drug.
Oh, yes, sir. Thank you. So I'll do a continuance order for Mr. Bullock for tomorrow.
Yes, Your Honor.
Mr. Chung.
Chung, bro. Chung.
C-H-U-N-G.
Yes, sir.
Sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Sabrina Chung. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That day will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, sir?
Yes.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Trump?
No, sir.
Okay, sir, you're free to go back.
What was the bond amount again?
I'm sorry, $3,000.
Thank you.
You're welcome. And I guess it's is it Emile? E-M-E-L-L-E?
Yes, sir.
Sir, you're charged with 1 count of failing to register. Bond's going to be denied at this point on this offense. I'm going to set a preliminary hearing date for April 25th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to appoint you a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back.
All right, thank you.
You're welcome. Mr. Ford.
Yes, sir.
Mr. Ford, sir, you're charged with 1 count of felony theft by receiving stolen property. Bond is going to be set at $10,000. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Ford?
No, sir.
Okay, sir, you're free to go back. Mr. Gay, G-A-Y-E.
How are you doing, Your Honor?
I'm doing well. Sir, you're charged with 1 count of battery. I've set the bond at $10,000 for this offense. It's listed as a misdemeanor, but you have a lot of arrests for this behavior.
No.
I'm sorry, let me finish. You're also charged with criminal trespass, damage to property. Bond is going to be set at $3,000. And you're also charged with criminal trespass. Bond is going to be set at $3,000. So you're going to have a total, hold on, sir, please. You're going to have a total bond set at $16,000. There's going to be a stay away provision on this bond to stay away from a sincere Shannon. Do you understand that?
I do.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
I do.
Okay. You do qualify, sir. You're going to, I'm going to appoint a lawyer to represent you. Now, before I let you ask the question, I may be able to answer the question you're asking. The reason I set the bond at the amount that I set it is because on 2 separate occasions, warrants have been taken out for your arrest for an allegation of domestic violence involving Miss Shannon. There is a warrant taken out on December 30th of 2021, and there's warrants taken out on March 17th of 2022. Both involve Miss Shannon as the victim. So that's why I set the bond the way that I set it. So did I answer the question you were going to ask, or do you have a different question?
No, you did not answer my question.
Okay, what's your question?
It was pertaining to that, but you said that I was arrested multiple times for battery.
Okay, so I misspoke, sir. You had 2 warrants pending at the same time involving allegations of domestic violence, where both you and Miss Shannon. I just gave you the dates, sir. I mean, you want me to give you the warrant numbers too, so you can verify it?
No, the only problem I have with it is I was not aware, and actually I am the person that everything was happening to. The only thing is I left. I just left. Every time I was never the aggressor or the person that started anything. So the fact that I'm the one that has to pay and have this slander on my name that's the problem that I have. And I'm not the person that looks like. I'm the one.
Okay. So let me give you a piece of advice. It sounds like you're saying that your relationship with Miss Shannon is toxic and that she is the person that is offering violence against you. Is that correct?
Precisely.
So should you stay around her or should you leave her alone?
It's been many times that I've tried to leave.
Should you stay around her or should you leave her alone? She's not like, she can't command you to be around her. You can choose to, sir, you can choose to leave. If you choose to stay, you now have 2 warrants for your arrest that she is the complaining witness. Sir, I'm not saying you're guilty. I'm not saying you're innocent. That's why we appoint lawyers to represent you. All I'm telling you is that what I see from now, if you choose to go back around Miss Shannon, there's going to be another warrant for your arrest at some point in the future. So that's your choice. If you want to live your life like that, that is your choice. Okay? So I'm sorry, I cut you off. Any other question?
I lost my train of thought.
I'll tell you what, sir. I'll let deputies, would you let Mr. Gages have a seat and we'll come back to him at the end. I'm going to allow him to gather his train of thought because it's unfair for me to not answer a question. Do you understand that, sir? Okay, we'll have a seat. Well, let's bring up Mr. Harris, Derek Harris. Mr. Harris, sir, you're charged with 1 count of theft by taking. That's a misdemeanor. Bond is going to be set at $2,000. You're also charged with 1 count of simple possession of a controlled substance. Bond is going to be set at $3,000. You're charged with 1 count of use or possession of drug-related objects. Bond is going to set at $1,500. Charged with giving a false name, address, or date of birth to law enforcement. Bond is going to be set at $2,000, and you're charged with criminal trespass. Bond is going to be set, at $3,000. Now, the simple possession is a felony offense. So your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Okay.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me, Mr. Harris? Okay, sir, you're free to go back. Is Herschel Harris, is he OTB?
Yes, Your Honor.
Thank you. After Mr. Herschel Harris, we have Mr. Is it Hedden or Heaton? Headen?
It's Heaton.
Heaton. Sir, you're charged with 1 count of theft by receiving stolen property, being a firearm. Bond is going to be set at $10,000 for that offense. 1 count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. 1 count of 1 count of driving on a suspended. 1 count of driving a vehicle without a valid license. Bond is going to be set at $1,000. And 1 count of driving a vehicle without valid insurance. Bond is going to be set at $1,000. So that's a total bond of $13,500. You're going to be, you're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, so you're free to go back. Mr. Howell.
Hey there, how are you?
I'm doing well, Mr. Howell. Sir, you're charged with 1 count of driving a vehicle with no tail lights. Bond is set by schedule, which means automatically set at $500. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. You're charged with 1 count of possession of more than an ounce of marijuana. Bond is going to be set at $5,000. You're charged with 1 count of, and that's a felony offense. You're charged with 1 count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. That's a felony offense also. You have an open container violation. Bond is going to be set at $500. And finally, you're charged with possession with intent to distribute the marijuana. Going to set the bond at $10,000. So you're going to have a total bond set at, let's see, $22,500. Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer, Mr. Howell?
Yes, sir. And could you repeat that date for me real quick?
Yes, sir. April 27th at 8:30 in the morning, courtroom 201. I'm going to find that you qualify for the appointment of a lawyer. Do you have any other questions of me, sir?
Yes, sir. So would I be able to bond out like ASAP as soon as I'm released to a bond, or not as of right now? I was asking for I work also, and I was asking because if I needed to do like, or could do work release just in time being, that, because I do have 2 kids also.
Okay. So the answer to your first question is that you will be able to bond out today once the jail receives the paperwork. After this hearing is over, I have to prepare the paperwork and send everything back to the jail. And they start inputting the information into the system. Once that process is complete, you will be able to post a bond. So you know the bond amounts that you've been given. When you go back and you're able to use the phone, you can start calling people and start making arrangements, okay?
Yes, sir. And could you send me that amount one more time? Was it 22,000? How much?
22,500.
All right, thank you.
You're welcome. Mr. Arthur Jones.
Morning, y'all.
Good morning. Well, it's now afternoon. Mr. Jones, sir, you're charged with 1 count of simple battery. Bond is going to be set at $3,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from a Kelly Jones. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Jones?
Yes, because I do work and I guess what I need to know is if I could bond out today. If I can bond out today, we both share a home and a son and whatnot, and my stuff is there. How would I go about getting my stuff? Because I can't lose my job.
I understand. When you bond out, sir, as you're going through the process, make arrangements with the sheriff's department so that there will be an appointment time that you show up with the sheriff's department, with a law enforcement officer. It may be the police, but someone is going to be there so that you can obtain your items, so that you can continue with your daily living, and then you'll be able to get your stuff and leave. It's not going to be a move-in situation. So law enforcement not going to be there for 5 or 6 hours while you're, moving everything out. But it's just because this most likely will be a temporary situation. There's an understanding that there needs to be a temporary sort of bridge until this matter is resolved. Any other questions, sir?
No, okay, no, that should be all. Thank you.
Okay, you're free to go back, sir. Mr. Long.
Afternoon, Your Honor.
Good afternoon, sir. You've been charged with 4 felony offenses. Possession of marijuana over an ounce, possession of marijuana with the intent to distribute, possession of a firearm during the commission of a crime, and possession of a firearm by a convicted felon. I've denied bond on these 4 offenses at this time. I'm going to set a preliminary hearing date for April 25th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
And I will let you speak. I promise I will let you speak. Okay. I'm going to find that you qualify for the appointment of a lawyer, sir. I am going to appoint a lawyer to represent you. Now, what is it that you wanted to tell me?
I needed to try to hold my job, sir. I would like to bond out if possible. I have a job, so I work 6 days a week, sir. I just bought a house in September. I face losing my house if I can't bond out to continue working to pay my mortgage, sir.
Okay. I'm going to deny that request at this point, Mr. Long. You have to understand, sir, the allegations are that these items were found during a traffic stop. So I have to assume that these items were under your custody. You have a co-defendant, Mr. Michael Anderson, who was also arrested at the time. So
yes, sir. Everything that I had, Your Honor, I took responsibility for. That would be amount of CBD marijuana in my fire. I'm sorry. Everything that I, yes, sir.
So hold on, sir. The thing that I'm trying to impart upon you is that the decisions that you made are the decisions that you made.
Understandable. But what I was saying was, sir, some of the decisions that I made were the charges weren't true. The convicted felon isn't true. The other stuff isn't true.
Hold on 1 second.
Yes, sir.
I'm gonna look up your criminal history.
Yes, sir. I was granted first offender and I still got a convicted felony on my.
When were you granted first offender?
2006, 2004, I want to say 2005 from Butts County, sir.
Did you successfully complete the first offender?
Yes, sir. Yes,
Did
sir.
they,
No violations, no parole, no anything. No, sir.
did they discharge you from the first offender?
Yes, yes, sir. Yes, sir. And all my rights were restored back. Could I maybe sit here and talk to you later, let you look into it? Because I really would like to get a bun, and I really don't think that.
Okay, you have a seat with Mr. Gay, so I can at least finish these individuals.
Yes, sir.
It won't take long for me to look at your criminal history. Mr. McFadden.
Good afternoon.
Sir, good afternoon, sir. Do you understand what you're charged with?
Yes, sir.
I cannot set bond at this hearing for these charges. I'm going to set a preliminary hearing date for April 25th at 8:30 in the morning. Because of the nature of these charges, you're going to have to appear before a Superior Court judge for a bond hearing. I don't have that date yet. It appears that you're going to hire your own lawyer.
Oh, yeah.
Okay.
But do I qualify for one just in case I might can just,
You didn't fill out the form, so do you want me to qualify you?
Yes, sir.
Are you currently working?
Yes, sir.
How much do you make per hour?
I'll make $20 an hour.
Okay, you do qualify, sir. I am going to appoint a lawyer to represent you. I'm sorry, give me 1 second. So whether you retain a lawyer or whether you go forward with the appointed lawyer, there's going to have to be a bond hearing date set for you. Do you understand that?
Yes, sir.
Do you have any questions for me, Mr. McFadden?
No, sir.
Okay, you're free to go back.
Thank
you. Mr. Mitchell. Mr. Mitchell, sir, you're charged with 1 count of simple battery. Bond is going to be set at $3,000. You're also charged with 1 count of criminal trespass. Bond is going to be set at $3,000. That's a total bond of $6,000. You're going to have a stay away provision on this bond to stay away from a Krishana Ivy. Do you understand that, sir? Give me 1 second. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Mitchell. Mr. Reese?
Yes, sir.
Mr. Reese, sir, you're charged with 1 count of driving under the influence of alcohol to the extent that it made you a less safe driver. Bond's going to be set at $5,000. This is a misdemeanor offense, so you're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That day will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. It said you refused. Are you currently working, sir?
Yes.
But how much do you make per hour?
17.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I would like to pay cash bond tomorrow at a lower cost because I get paid tomorrow. I work for FedEx, and Saturday will be my day to start back work.
Okay. Currently, you have 3 options in posting bond. cash, commercial, or property. Cash means you pay the entire amount in cash. The sheriff's department will hold that money and then return it to you when your case is over. You can go through a bonding company where you pay a percentage of the bond, generally about 10%, 10 to 12% of the bond. That amount that you pay is a fee for the bonding company. They will not return that money. If you have property in Clayton County, you can use that property as collateral. The property, I mean real property, real estate. Property has to have at least an equity of at least 3 times the bond amount. So in your situation, the property will at least have to have an equity of about $20,000, $25,000. Sheriff's Department places a lien on that property. When your case is over, they remove the lien. Those are the ways that you can postpone.
Right now, me and my wife, we getting ready to buy a house. And all the money that went in the land in that house, I get paid tomorrow and I have my bank card in my property that I can pay straight out, but I don't.
This is, yes. What it sounds like you're negotiating the bond amount. I set, as maybe you've heard, I've set every bond for this offense at the same amount for everyone.
Well, this is the first time I've ever called a charge like this. I've never been DUI and none of that.
I understand. I understand, sir.
Can you give me a signature bond?
No, sir.
You know, I just can't afford it right now. But not with the bond that you put down, I can't afford it. It's hurting me because my job on the line and everything.
And I do understand that. It looks like it says that you were arrested at 12:30 this morning.
Yes, sir. Just got off work at something like 10, from 6 that morning to 10 that night on the way home. This is a livelihood that I didn't fought for, to have a house and land and everything. And I made one mistake.
All right, Mr. Reese, you have successfully argued your case. I'm going to dismiss this charge.
Thank you.
So what's going to happen is when I'm done with this, when I'm done with this hearing, I prepare the paperwork. I send everything back to the sheriff's department and they will enter into the computer. And when they enter into the computer, you will be released, but that's going to take at least a couple hours.
I can deal with that.
Okay. And sir?
This is my punishment for the mistake that I made.
I looked at your thing again and I'm comfortable with dismissing this charge. Okay. All right. You're free to go back.
All right. Thank you.
You're welcome. Mr. Sawyer. Mr. Sawyer, sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. This is a misdemeanor offense. So your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. There's going to be a stay away provision on this bond, stay away from a Rebecca, looks like either Maines, M-A-I-N-E-S. Do you understand that, sir? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, please.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, sir, you're free to go back. Mr. Marquise Smith. So you're charged with one count of theft by taking as a felony offense. I've set the bond at $5,000. You're gonna have a preliminary hearing date set for April 27th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you're on the borderline, but I'm gonna find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you for that.
Okay, you're free to go back. Mr. Tomlin. Mr. Tomlin, sir, you're charged with one count of simple battery. This is a misdemeanor offense. Bond is going to be set at $5,000. You're charged with. I'm sorry, did you say anything?
No, Your Honor.
Okay, you're charged with one count of theft by taking. Bond is going to be set at $5,000 for that offense. And you're charged with one count of aggravated assault. Bond is going to be set at $15,000. So you're going to have a total bond set at $25,000. There's going to be a stay away provision on this bond to stay away from a Celeste Thomas. Do you understand that?
Yes, Your Honor.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. I do find that you qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, Your Honor.
Yes, sir.
I really want to take trial for the you said theft by taking?
Yes, sir. That's one of the charges.
Yes, sir. I want to take a trial. I want to take that to trial because everything they accused me of stealing was in the house and never left the house.
So, Mr. Tomlin, at this stage, we're not determining guilt or innocence. Once you bond out, your case is going to get moved to the Superior Court. I've appointed a lawyer to represent you. That's where you have the discussion about going to trial.
Okay.
Okay. Anything else, sir?
Am I approved for any type of bond?
Okay. What did I say your total bond amount?
Okay, 25.
That's your bond.
Okay.
Anything else, sir?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome. Mr. Weaver.
Yes, sir.
Mr. Weaver, sir, you're charged with one count of hit and run, accident, basically leaving the scene of an accident. The bond has been automatically set at $1,500. This is a misdemeanor offense. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Mr. Weaver. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Is there any way that I can bond out today?
Yes, sir.
Okay. So,
When it'll take probably a couple of hours, but you should be able to use the phone after this proceeding, and you can contact either a loved one or a bonding company. You know what your bond is set. You actually can do that now because it's already been placed in the system. So you should be able to make arrangements to bond out immediately.
Okay.
All right. Anything else, sir?
So the bond has already been in progress?
It has been, this is an offense. Some offenses, the jail has what they call a schedule. So they will automatically just assign it to you. So you didn't even have to come before me. You can go make your arrangements and you can bond out now.
Okay.
All right, sir. Free to go back. Mr. Marquise Williams.
Yes, sir.
Okay, sir, you're charged with 1 count of criminal trespass. That's a misdemeanor offense. Bond is going to be set at $3,000. You're also charged with 1 count of battery. Bond is going to be set at $5,000. So you're going to have a total bond set at $8,000. There's going to be a stay away provision on this bond to stay away from Jamelia Abdul Hakim. Do you understand that, sir?
Yeah, yes, sir. One question.
I'll get to that in a second. I'll get to that. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was your question?
The officer, it was simple battery because I did.
Yes, sir.
Is it simple or is it battery?
It's listed as simple battery on the bond from the allegations.
Yes, sir.
You know what? I'm going to change that the bond for the simple battery to $3,000. So you're going to have a total bond set at $6,000.
Yes, sir.
Okay, sir?
Yes, sir. Thank you.
You're welcome. Any other questions?
No, sir. You have a blessed day, sir.
You too. All right, let's deal with Mr. Wilson. Mr. Wilson, sir, you're charged with 3 driving-related offenses. These bonds have been automatically set, which means they're set by schedule. So you're charged with 1 count of improper lane change. The bond is set at $500. 1 count driving a vehicle without insurance, bond is set at $1,000. And 1 count of driving on a suspended license, bond is set at $1,500. So you're gonna have a total bond set at $3,000. You didn't fill out the form. Does that mean you plan on hiring your own lawyer?
Oh, no, I mean, I thought the form was actually to, for a lawyer.
Yes. So you didn't fill it out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Wilson?
Yes, sir.
About how much do you make per hour?
$17.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. So at the time I got these charges, I was trying to explain to the officer that my license was reinstated and I did pay the ticket off. And I guess he said that that's something that you take up with the DMV, but I was at work at the time. So I had to basically just leave work. They incarcerated me. And he didn't give me a chance to even look in the glove compartment to show him that I had insurance. So I was working, I had insurance, I've actually paid the ticket off. The DMV is something once I leave jail, and I'm going to have to give the documents that they gave me to show that I reinstated my license. I got my State Farm binder at home that I can prove. If you give me a chance to come back before you, I can bring that back as well to show you that I had insurance on my car. All this time I've been sitting here, my job is, I had to work today. They don't even know where I'm at, so it's no call, no show today. I'm trying to get out of here, but I wasn't able to get no phone calls to on my phone to make any phone calls to anyone. Is there any type of way that you would help me with, like a signature bond or anything that I could just present the documents before court and show that all these charges that's been against me are not legal? I mean, are not what's supposed to be against me right now. Only charge was the improper lane change. If he wants to charge me with that.
Okay. Okay, Mr. Wilson, this is what I'm going to do. I'm going to change these bond amounts to $500 each. You're gonna have to get that information. And let me see. You did say you wanted me to appoint a lawyer. Okay, get this information, give it to your lawyer, and if what you say is true,
Yes, sir.
these charges will most likely be dismissed.
Okay. And I do have documents to back up what I'm saying as well.
That's fine. You will not come back before me.
Okay.
Okay, you're gonna have to, this will get transferred to either the traffic court or the state court.
Okay.
And your lawyer will have the opportunity to speak to a prosecutor, okay? All right, you're free to go back, sir.
Okay, could you tell me my the bond amount or what I need to do next?
It's $500 each, so that's a total bond of $1,500.
Okay, thank you, sir.
You're welcome. Let's bring Mr. Long back up.
Yes, sir, Your Honor.
Mr. Long, I've looked at your criminal history and I'm not going to change my decision.
Yes, sir. Could I ask why, if you don't mind?
You have 9 cycles, which means you have 9 interactions with law enforcement.
Most misdemeanors? Only felonies were first offenders in 06?
Looks like you're charged with possession of methamphetamine, October 27th of 2013.
That was given a first offender too, sir, in DeKalb County.
Mr. Long, I'm not changing my mind. You're not being persuasive.
Yes, sir.
We can sit here and have a 3-hour conversation about something I'm not going to change my mind about.
All right, I'm off of it. Is there anything I can do to try to appeal that, and I'll be gone?
To appeal what?
Maybe to get a bond. Is there any way I can get a bond to keep my job in my house, sir? I just bought a house. I got a mortgage.
Mr. Long.
Yes, sir.
You've been around. You've been around. You have been around.
Yes, sir. And understand, I'm a changed person. That was when I was younger. I'm now 40. I grew up out of those ways. I promise, sir.
I understand. I'm not going to change my mind.
Okay, fine. You have a record?
You're welcome. Mr. Gay. Were you able to remember what you wanted to speak to me about, sir?
I just wanted to make it known that I kind of forgot again. Basically, what I was trying to let you know was what I'm trying to make is all those situations that happened, even though you said there were 2 situations. One of those situations, both of those are together. And I just want you to know I was never the aggressor. I'm always the guy that's trying to make things right. And I don't, basically a question I would have was, what should I have done in that situation? Because I don't see anything I could have done. I've tried to leave. I've been restrained. I've had her put her body against the door to where I cannot leave. I've had her drag my clothes, rip my clothes up. I've had so many things. It's been.
How often has that happened?
It's happened. Honestly speaking, it's happened maybe at least once a month. That's honestly speaking.
Why do you go back?
Because I actually am a good person. I am a good person. That's literally all I say about that.
And what has that gotten you? How has that benefited you?
I was never in a relationship for benefits, to be honest. I've been trying to help her.
What I mean, Mr. Gay, is that you're sitting in jail right now saying that the person that has been beating on you once a month, you go back to because you're a good person. At some point, you have to start thinking about self-preservation. And until you start thinking about self-preservation, you're going to be in jail. You're going to be coming back to jail. We might as well start setting appointments up every month for you to come back and you to tell me how she beat you behind this last month and how you left and you tried to be a good person. You tried to leave, but you didn't leave. So she went to the police and she got you arrested and you're just such a great person. And you don't know how you can stop yourself from going back to a person who you say is abusing you and having you arrested. I'm not your father. I cannot lead your life. You have to lead your own life. And this is what you want out of life. This is what you're going to get. Do we understand ourselves, sir?
Sir, can I get, well, 1 second?
Yeah.
As I grew, speaking about my father he was in law enforcement. So my mother, she died when I was at least 1 year old.
I'm sorry to hear that.
So when it comes to women, I've seen my father sacrifice himself. So it's like, I understand her because I know where she comes. She comes from,
When you say you understand her, are you saying Miss Shannon?
Yes, I'm speaking about her because I
Okay.
understand everything is not her fault. Everything is not her fault. And we've actually been making great progress within the last month or so. That's why this hurts. That's why when they came and got me, I wasn't in the streets. I was sleeping, waiting to go to work.
Let me ask you this, Mr. Gay. What do you think that you deserve out of life? What do you deserve? What do you deserve out of life?
I deserve somebody that's gonna treat me the way I treat them.
Do you have that right now?
Sometimes I do.
Are you gonna go back to that? So let me ask you this. So you're saying some days you're worthy, other days you're not worthy. Or are you worthy every day?
I feel like I'm worthy every day because
if you had a car, you knew you had to go to work, and you had a car that some days it would start, some days it wouldn't start. Would you fix the car, get a different car, or will you continue getting fired from work because you don't show up on the day your car decides it's not going to work?
Would either be to get a new car or fix it.
Okay, so fix your life. Stay away from this person if you don't want to keep going back to jail. If you want to go back to jail, stay around that person. That's the beauty of this country. You get to choose. You get to choose. Ain't nobody, it's not your mother, not your father, not her, it's you. Okay?
Yes, and another point, now I do remember what I was going to say at the end.
Okay.
The person that we're discussing, she was in the case, the women's side, she was on those cases.
Okay.
And she's the one that had the obstruction for justice.
Because they said that she tried to stop the police when they came to arrest you.
Yes, the point I'm trying to make is, if you really look at those situations, you can clearly see I'm not the problem.
Yes, you are. Yes, you are. I don't know why you believe that your poor decisions don't fall back on you.
Because
that's the problem. That's how you are the problem. You make poor decisions. You make poor decisions. If you decided that you were going to go to a party rather than pay your rent and you got kicked out of your apartment, is the apartment complex wrong or are you wrong?
I mean, you're wrong because you threw the party.
So no, you spent your money to go to the party.
Oh, you say go to the party. Oh.
Yes. If you keep making these poor decisions, you're going to keep coming back here, and it's nobody's fault but yours. And I really hope you get that. Does that make sense to you?
I get it. I accept that it was because I shouldn't have stayed with her. I get that. I get that. I should have left, but I keep trying to voice to you that how do you leave when somebody does these things? When a woman, I know you're married.
I'll tell you how you leave. You pack a bag, you take 2 steps out the door, close the door, and you never look back. That's how you leave. Yes, sir. Go ahead.
I've done that, and I got the police called on me.
Hey, sir, listen. Are you telling me she's kidnapping you? Is she holding you against your will? Is she doing something that prevents you from exercising free will? No, she's not. You're exercising free will. Things aren't working the way you want them to work. Now you're looking to blame somebody. You need to look in the mirror. I mean, I would carry a mirror in my pocket. Every time you think about going back to her, pull that mirror out and look at your face. or even this is on YouTube, screenshot this and look at yourself on YouTube in an orange jumpsuit. And every time you think about, I just want to go back to her, pull that picture out and look at yourself on YouTube in an orange jumpsuit talking about, I just can't leave her. Am I getting through to you, sir? So, Mr. Gay, we all have to make decisions about our life. All of us, each one of us. When you become an adult, you can't turn around and blame somebody else. You have to look in the mirror. So if for whatever reason in your life, you believe that this is what you're worth, fine.
No.
I'm telling you, you're worth more than that. But only you can make that decision. Do we understand ourselves, sir? Do you have any more questions, Mr. Gay?
Like I stated earlier, I wasn't able to go to work, so I know their policy. I know they're probably about to fire me. So, and like I mentioned earlier, I don't have a mother. I don't have usually that person I could just call to bail me out. So, and I don't have my money on me. They didn't let me grab my money.
Uh-huh.
Yeah.
So let me ask you this. Do you think Miss Shannon is going to bond you out or try to lift a finger to help you get out of jail? Do you think Miss Shannon is going to get you a job back?
No, sir. I have to get out so I can get her out. I'm the one that makes the money. I'm not saying I'm going to be around her, but I'm saying I do care about her freedom. I don't need, she's 20 years old. I don't want her to mess up her life over not being able to control her emotions, because that's what's gotten us into this.
Sounds like she's messing up your life.
Yes.
But you keep going back.
I'm not trying to go back. I'm just letting you know I am literally a good person. I'm not what that looks like. All that, whatever those charges are, is not me.
Okay. Well, she told the police about that. So that's the person that you're going. Let me ask you this question. Let me try to explain it in a different way. If I told you that there's a rattlesnake in that basket and you just have to take the lid off, stick your hand in there, but it's going to bite you and you may die. And you stick your hand in there and the rattlesnake bites you, but you don't die. Then the next month I say, hey, it's a rattlesnake in that basket. Why don't you stick your hand in there? It's going to bite you, but you may not die or you may die. What I'm hearing from you is you're going to stick your hand right back in that basket and get bit. And you're going to keep doing it and keep doing it and keep doing it. And how I hear you experiencing this is I'm such a good person. I just cannot stop sticking my hand in the basket for that rattlesnake to bite me. So Judge, I mean, I know the rattlesnake keep biting me, but Judge, don't kill the rattlesnake, because the rattlesnake is actually a good rattlesnake.
She is a good person. It's just
no, she's not. No, she's not.
Yeah,
no,
she's not. Sometimes when she's angry.
Okay, well, sir. Now I'm wasting a bunch of people's time by having this conversation with you,
right.
But it just hurts my heart because I know I'm going to see you probably in another 3 or 4 months.
Why?
Because the thing that you don't understand is that you're not the only person. And when I say I'm gonna see you again, it's because I see people again. I know you're like, no, not gonna be me. No, but hey, you know what, Judge? Yeah, you're right. She got mad at me. And I know I said I wasn't gonna come back, and I didn't do anything. All I did was go back around her so that she can get me arrested again, but I didn't really do anything. Okay, fine. I'll see you. Let's say you want to put down July, August. When you want to come back and see me again?
I don't ever want to come back here, sir. I've done so much not to be.
So act accordingly.
Understand.
And I'm trying to pour energy into you, sir, so that you don't come back. People believe that people charged with crimes are violent they're evil. No, just people make bad, poor decisions. So that's what you don't have to, I don't care. I don't care if you're evil. I don't care if you're good. I look at the charges. I do what I'm supposed to do. So when you say you're a good person, it really doesn't matter to me. You could be like the most evil person in the world, charged with the same offense, and you don't get the same treatment. It's poor, it's decision-making. Stop making poor decisions, please. Okay, thank you, sir. Thank you, deputies, for indulging me.
I don't know
Yes,
my bond. I don't know my bond.
Okay, all right.
I don't want to keep.
No. All right, $10,000 for the battery, $3,000 for the criminal trespass, damage to property, and $3,000 for the second criminal trespass. Just so you know, the warrant that was taken out on the other day was for criminal trespass, warrant number 2022 CW 51147. The warrants that were taken out in 2021 are for battery and criminal trespass. And as I stated before, the reason I set the bond at $10,000 on the battery, because you have two open warrants.
The other one happened after, and I was leaving, sir. That's what I'm saying. I was trying to leave.
Is this a trial? Did I appoint a lawyer to represent you? Do you have somebody you can say that you were leaving, and you right now have the opportunity to put 12 jurors in a box and go to trial and say, I was leaving? What is wrong? What is wrong with you, Mr. Gay?
Because I'm just not understanding how something like this could happen, even though I'm not even, I was never doing, I left, I was trying to leave.
All right. So she called the police and told them that you did the stuff that was placed in a warrant, where the police officer went to a judge and said, I spoke to Miss Shannon. Miss Shannon said he did this. That based upon that, I'm seeking warrants for his arrest. That's what I think you're not getting. The person that you're all snuggly boo, I wanted it. She is the reason, the only reason that you are in custody right now. She is the only reason that you are in custody right now. So go back to that. Because what you're telling me is that she's a liar. She lies and gets you arrested. But oh, I love her so much. She can, I mean, when she's not lying, I want to be around her. Great. That's why you're going to be back here again. Because you've already said she doesn't tell the truth all the time. She lies at times. Guess what? When she decides she's going to lie, she's going to call the police. There's going to be another warrant for your arrest, and you're going to go back to jail. And you're going to get out, and you're going to go back to her, and she's going to do it again and do it again and do it again until one day, either you're going to be in jail for 5 years and you're going to have time to separate yourself from that, or someone is going to tell you, or you're going to learn on your own. This is not a good look. This is not a good relationship. So, sir, you're doing it to yourself. I have no problem in following the law, but you are wasting people's time. Is there any other questions that I can answer that are of value?
Yes, sir. Is there, because like I said, I'm the one that makes the money, and I don't have that much. Is there any way we can work on that, the price of the bond, so I can get out?
No. Next question.
I forgot what. Thank you.
So, Mr. Gay, what I'm sensing from you is that you are somehow trying to talk me off of something that, no, stop. You're trying to talk me off of something that I told you I'm not going to change. I don't understand why you're standing here, but it's my job to answer questions. So keep asking and I'll keep answering.
You never answered the question about what should I have done in the situation when I actually did what you said.
Didn't answer that question.
Yeah, he said.
I did. I've asked it, I think, about 3 or 4 times.
No, when you told me that you to pack your bag and leave, and I told you I did that. What else am I supposed to do?
You said that she does this once a month. You said she does this once a month. So
That's-
you have.
That's if I had to, that's if I had to put into statistic, yes.
Deputies, am I being unclear to Mr. Gay, or is it he just don't
You're
want
clear,
to?
sir. All right, Ms. Gay, do you have any questions that do with bond or court date? Yes or no? If not, let's go.
What was the court date, since I'm being held there?
All right. We're gonna do this again. Mr. Gay, and I want you to listen to everything I say. You're charged in warrant number 2021 CW 56317 with committing the offense of battery. The bond is going to be set at $10,000. This warrant was taken out on December 30th of 2021 with Ms. Shannon being the complaining witness. You're also charged in warrant number 2021 CW 56318. Bond is going to be set at $3,000. That charge is criminal trespass, damage to property. That bond was also taken out on December 30th, 2021, with Ms. Shannon being the complaining witness. So you're charged in warrant number 2022 CW 51147 with committing the offense of criminal trespass. That warrant was taken out on March 17th of 2022 at 12:07 a.m. So a judge had to get waken up to do this warrant with Ms. Shannon as being the complaining witness. Bond's going to be set at $3,000. These are misdemeanor offenses. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived when you're bonding out, and you'll get a new court date in the mail. I've appointed a lawyer to represent you. Is there anything else that you don't understand, Mr. Gay?
How did I get criminal trespassing?
Because which one?
The first
for
one?
For December or for March?
For December.
Okay.
I can see how it happened for March.
Bob, stop talking. Stop talking. Because when you start talking, you start forgetting things. You asked a question, I'm about to answer it. So the allegation is on December 30th, 2021, at an address on Riverdale Road, you did commit the offense of criminal trespass, damage to property. On that above date and time, you allegedly committed an act of criminal trespass, and that you allegedly intentionally damaged an iPhone 10 and a 50-inch Samsung flat screen television, the property of Ms. Shannon, without her consent by throwing the phone, causing the screen and the back glass to shatter. Said offender damaged the television by dropping it to the ground. Said damage being less than $500. That's the allegation against you. I've appointed a lawyer to represent you. You now know the charge. Speak to the lawyer about it so the lawyer can defend you.
I just need the total, that's it.
16,000.
16?
Yes. Every point, that's 4 days. You have any questions for the judge?
Yes, sir. I'm done.
All right.
Can you take us off YouTube and before you look?
Please enjoy this pre-COVID bond court session. Starting in 3, 2, 1. Bond court.
We are on the record. It is April 4th, 2019. This is Judge Wish, Courtroom 1, Session 1. Can I have the parties please announce themselves for the record?
Coffee Kennedy Swanson on behalf of the Office of the State Attorney.
Alexis Augusto on behalf of the Office of the Public Defender.
All right, ma'am, please tell me your name. Carlson? All right. Ms. Carlson, you were here in 2019, CF 4545. You were arrested for attempted burglary of a conveyance. I do find probable cause for the offense. I'm going to appoint the public defender to represent you. I'm going to order that you not have any contact with any victim or any witness in the case. Not to possess any weapons or firearms or ammunition. And I'll stay the bond at the $1,000. Okay. He was medical yesterday.
We'll waive, Your Honor.
Okay. In 2019, MM 2810AO, Willie Edmond was arrested for possession of drug paraphernalia. I do find probable cause. I am going to appoint the public defender to represent him. He was also arrested in 2019, MO 597AO, for an open container violation. I do find probable cause. In the possession of drug paraphernalia, I'll stay the bond at $500. He's not to possess or consume any illegal substances without a valid prescription. And the open container violation, I'll set it at the $250. And I did speak with, we had a meeting yesterday with Mr. Diaz and Deb Barra and Ms. Vickers. And so I think we're gonna try and start setting the MO and the CO cases for statuses, because they get lost in the system. So if there's an offer from the state on the open container, so that he can plea if he wants to plea at any point, I don't know if the state has an offer on it, but we're gonna start setting these for statuses because they end up staying in for 45, 60 days, and they don't need to file information on the MOs or the COs. So is there an offer from the state that Mr. Augusto could relay?
It's credit for time served.
Okay, so it would be a credit for time served, adjudication withhold, I don't know, but can we set Mr. Edmond for a status on his MO case in a week?
Once it leaves IAs, then that's going to be on them to talk to the city, because then it becomes the city's case to make the offer. So
Right, that's what they're doing. They've agreed
Okay.
to do that.
Okay,
yeah.
so
Yeah.
that credit for time served offer may not be what the city then conveys.
Right. I've never had it not be, but that's what we all agreed to yesterday, that we would try and do that now. So if we can just set him for a status on the MO case in a week, and that would be helpful. Okay? Thank you. All right. Is this Mr. Edwards? Okay. All right, Mr. Edwards, you're here in 2019 MM335AW. You're arrested for resisting an officer without violence and loitering and prowling. I do find probable cause. That's in, did I say 2019 MM335AW. I am going to appoint the public defender on that case to represent you. Your bonds will stay at $500 and $100 on counts 1 and 2. In 2019 MM336AW, you were arrested for stalking. I do find probable cause. I am going to appoint the public defender to represent you in that case as well. You're not to have any contact whatsoever with the victim in this case. You're not to go on her property. I believe she's your neighbor. And your bond in that case will be set at $1,500.
You're gonna also ask for
Is
no
he out
weapons?
on no weapons and firearms? Is there, and he's out on bond? Okay. You're out on, it looks like pretrial release. In 2018 MM 691 AW, I am going to revoke that release and set that at none. In 2018 MM 659 AW, you're out on pretrial release. I am going to revoke that release and set that at none as well.
So what is that? So will I stay?
Next one, Your Honor, Phyllis Cologne, refused.
Okay, thank you. Jeannie, still need these if you have those. Thank you. Okay. Mr. Cologne refused again? Okay. We'll try one more time because there's a lot of cases here, so,
We're
okay?
gonna ask that it be waived. He refused yesterday and he's refusing again today, Your
Okay,
Honor.
I'm gonna try one more time, okay?
The next one, June Jambar, mental health, Your Honor.
Right, we'll reset Mr. Jambar, or Miss Jambar.
Next one, Sardo Leonard, mental health, Your Honor.
Okay, because the serious nature of the offense, I am gonna reset that one too.
Rosemary Sawyer, Your Honor, mental health.
We'd waive that, Your Honor.
Okay. All right, in 2019 MM 2807AO, Ms. Sawyer was arrested for resisting an officer without violence in a conservation violation level 2. I do find probable cause for those offenses. I am going to appoint the public defender to represent her. And are you waiving her? You said
Yes,
on the
Your Honor.
record, you're
We waive.
waiving her appearance. Are there any conditions that the state would ask me to impose?
Yeah, Your Honor.
I don't know if there's any conditions that,
I don't know if the statute, I mean, I can look up the statute to see if there are conditions that are mandatory for the court to impose. The penalties, I don't see any.
I don't see any either. All right, her bonds will stay as set at $500 apiece.
Tatiana Rory Stone refused.
We'll waive that one as well, Your
Okay.
Honor.
In 2019 CF 4557AO, Mr. Stone was arrested for possession of heroin, possession of drug paraphernalia, and possession of cocaine. I do find probable cause for the offenses. I'm gonna appoint the public defender. They have waived his appearance. And he's not to possess any illegal substances without a valid prescription. And his bonds will stay at $1,000 on count 1, $100 on count 2, and $150 on count 3. All right, please tell me your name, sir.
Samuel Lamar Taylor III.
All right, Mr. Taylor, you're here in 2019 MM 2771AO. You were arrested for disorderly conduct. I do find probable cause for the offense. I am going to appoint the public defender to represent you. I'm going to stay the bond at the $250. I'm not going to take any action on your release case, sir, in 2018 MM 426AE and in 2018 MM 11505AO. Just make sure you keep in contact with do you have an attorney in those cases? Looks like you have a competency hearing coming up.
Yeah, they told me September 18th, somewhere around
But you
there.
have an attorney?
No, not that I'm not aware.
I believe we are assigned to that.
Huh?
I believe we are assigned
You
to
do have the public defender's office. Make sure you comply. If you come back again, I'm likely to revoke your bond, sir.
Okay.
Okay?
Is the state gonna make me an offer? Okay.
Hello.
All right, please tell me your name.
Rashida Thomas.
All right, Ms. Thomas, you're here in 2019 CF 4566AO. You were arrested for battery on a law enforcement officer, possessing an anti-shoplifting device, resisting an officer with violence, depriving an officer of means of protection or communication, and resisting an officer without violence. I do find probable cause for the listed offenses. I am going to appoint the public defender to represent you. You're not to possess any weapons or firearms or ammunition. You're not to return back to 4953 International Drive. Any store at that location. Your bond on count 1 will be $2,500. 150 on counts 2, 3, and 4, and 100 on count 5.
You had an add-on FTA cert number yesterday?
I don't see anything else in here.
Is she an AK? There's a AKA case right there.
I don't have anything.
There's this case right here.
That's Thomas. Monisha? Okay, then that is it, okay. All right, thank you. And 2018 CF 16682AO. You were arrested pursuant to a capias for failing to appear for your pretrial conference on March 20th, 2019. The judge revoked your release and your bond and set your bond at none.
What's talking about the other thing?
All right, sir, please tell me your name.
Cordero Atwell.
Mr. Atwell, you're here in 2019 CF 4627AO. You're arrested for possession of cannabis with intent to sell or deliver and possession of cannabis less than 20 grams. I do find probable cause for the offenses. I am going to appoint the public defender to represent you.
Excuse me, can I speak, ma'am?
There's a bunch of recommitment forms. Does that just mean that they're coming off the bonds? Okay. Trying to figure it out. 4627. Yeah, they're different cases, and then there's. I don't know if this isn't. Oh, this is the old case. Okay. No, it's not. Yeah, it's not him. Like I said, I'm having a bad day. All right, your bonds will stay at $1,000 on count 1 and $100 on count 2. You're out on bond for similar offenses, 2019 MM 1706AO. I am revoking that bond and setting it at none. So is this, there's no case number on here. Yeah, the ones that came off. Right, but it's, there's a bunch of different, it's all the same case number? Okay, all right, yeah. All right, sir, please tell, oh ma'am, sorry, please tell me your name.
Terry L. Bell.
All right, Miss Bell, looks like your bondsman is coming off of your bond in 2019 CF 2912AO. So do I just reinstate the bonds? Oh, she does, okay. So I'm just gonna keep the bonds the same as they were, and you can try and get your bonds reinstated, okay?
Yes, ma'am.
All right?
Okay.
And you do have a private attorney?
Yes, ma'am.
Okay. Just make sure you keep in touch with them, okay?
Okay.
All right, please tell me your name, sir.
Marcos Sinelli.
All right, Mr. Sinelli, you're here in 2019 CF 4646AO. You're arrested for trafficking and possessing counterfeit credit cards. 15 to 49 of them. I do find probable cause for the offense. I am gonna appoint the public defender to represent you. Your bond will stay at the $10,000. All right, sir, please tell me your name.
Lascelles Coley.
All right, Mr. Coley, pursuant to your request to be brought over here and take case number 2019 CF 3587, states an indictment has been filed against you for first-degree murder with a firearm. It's a capital offense. And the capias was issued in that at 0 bond. And I'm going to appoint the public defender to represent you. It looks like your case will be set for an arraignment in Division 12. Okay? All right, sir, please tell me your name.
Edel Artis.
All right, sir, you're here in 2019 CF 4626AO. You're arrested for possession of cocaine and petty theft. It's a retail offense. I do find probable cause. I am going to appoint the public defender. You're not to return back to that Walmart at 5734 South Orange Blossom Trail. You're not to possess or consume any illegal substances without a valid prescription. Your bonds will remain as set at $1,000 on count 1 and $100 on count 2.
Thank you. Have a good one.
All right, please tell me your name, sir.
My name is Gustavo Fernandez.
All right, Mr. Fernandez, you're here in 2019 CF 4591AO. You were arrested for burglary of a structure, grand theft third degree, criminal mischief. I find probable cause. I'm going to appoint the public defender. I'm going to appoint them to represent you on all the cases that you have here before me, okay?
Yes, ma'am.
I'm going to
Thank
order
you.
that you're not to return back to any of the locations alleged to have been burglarized in the affidavits. The Family Dollar Store, the Boost Mobile, Sherman Williams, You're not to have any contact with any victims or witnesses or co-defendants in the case. You're not to have any weapons, firearms, or ammunition. Your bond in, and I do find probable cause for all of the other offenses in the other cases, 2019 CF 4593, burglary of a structure, grand theft second degree, and criminal mischief. 2019 CF 4589AO, burglary of a structure, grand theft third degree, and criminal mischief. All of those same conditions will apply in each of the cases. In count 1, in 2019 4591, your bond will be set at $3,500 on count 1, $150 on count 2, and $100 on count 3. In 2019 CF 4593AO, be $3,500 on count 1. It'll be $3,500 on count 2 and $100 on count 3. In 2019 CF 4589AO, count 1 $3,500, count 2 $150, and count 3 $100. Yeah, for the second case, it's over 20,000. All right, sir, please tell me your name.
Matthew Glover.
All right, Mr. Glover, you're here in 2019 CF 4628AO. You're arrested for possession of cocaine, possession of drug paraphernalia. I do find probable cause. I am going to appoint the public defender. You're not to possess or consume any illegal substances without a valid prescription. I will stay the bond at $1,000 on count 1, and it will be reduced to $100 on count 2. Tell me your name, please.
D.O. Hardeman.
All right, Mr. Hardeman, you're here in 2019 CF 4639AO. You're arrested for possession of cocaine. I do find probable cause. I am going to appoint the public defender to represent you. Your bond will stay at the $2,500. You're also out on bond in 2019 CF 246AO. I am revoking that bond and setting it at none. Yeah, I did. Oh, on the out on bond? Okay, and I'm gonna appoint them to represent you in the out on bond case too. Mr. Augusto, do you need that case number?
No, I have it here.
Okay.
Thank you, Your Honor.
I have a migraine. Yeah, I've had it since last night. I'm like dizzy. Okay, sir, please tell me your name.
Good morning, Pierre Henderson.
Good morning. Mr. Henderson, you're here in 2019 CF 4630AO. You were arrested for possession of a firearm or ammunition by a convicted felon, carrying concealed firearm, and possession of ammunition by a convicted felon. I do find probable cause for the offenses. I'm going to appoint the public defender to represent you. I'm going to stay your bond on count 1 at the $4,000. Count 2 will be $150. Count 3 will be $150. You're not to possess any weapons or firearms or don't say anything. Don't say anything. You're not to possess any weapons or firearms or ammunition, okay? Just
Yes, ma'am.
don't say anything. Please tell me your name, sir.
Good morning. Festus Horace.
All right, Mr. Horace. You are here in 2019 CF 4631AO. You're arrested for possession of cocaine and possession of cannabis, more than 20 grams. I do find probable cause for the offenses. I am gonna appoint the public defender to represent you. Your bond will be on count one, $2,500, count two, $150. Does he have the PD on the, out on bond, do we know? No. On your out on bond case in 2019 CF 4310 AO, I am revoking that bond and setting it a none. I am gonna appoint the public defender. I don't believe they've been appointed, okay? Please tell me your name, ma'am.
Juanita Miller.
All right, Ms. Miller, you are here in 2019 CF 4620 AO. You were arrested for battery on a law enforcement officer, resisting an officer with violence, and petty theft retail. I do find probable cause, and I'm gonna appoint the public defender to represent you. You're not to return back to that Walgreens at 4502 South Orange Blossom Trail. Not to possess any weapons or firearms or ammunition. Your bond will stay at the $2,500 on count one. Counts 2 and 3 will remain at $100.
Thank you, Judge Wish.
Please tell me your name.
Neil Ramsrand.
All right, sir, you're here in 2019 CF 4648. You were arrested for possession of Xanax and possession of cannabis less than 20 grams. I do find probable cause. I'm going to appoint the public defender to represent you. You're not to possess or consume any illegal substances without a valid prescription. I will stay the bond at $1,000 on count one and $100 on count two. All right, please tell me your name, sir.
Joseph Rodriguez.
All right, Mr. Rodriguez, you're here in 2019 CF 4597AO. 2019 4595AO. 2019 4590AO, 2019 CF 4594AO, 2019 CF 4596AO, 2019 CF 4592AO. I find probable cause for all of the offenses listed in those cases. 4597, burglary of a structure, grand theft third degree, and criminal mischief. The same in 4595. It's the same in 4590. It's the same in 4594, and it's the same, sorry, it's in count 2 of grand theft second degree, 20,000 or more. In 4596, burg structure, grand theft, criminal mischief, and 4592. I'm going to appoint the public defender to represent you in all of those cases. You're not to have any contact with any victim, witness, or co-defendant. You're not to possess any weapons, firearms, or ammunition. You're not to return to any of the locations listed in any of the affidavits. Family Dollar, Sherman Williams, the Boost Mobile, in the Walmart. Your bonds in 4597 will remain at 3,500, 150, and 100. 4595, 3,500, 150, and 100. 4590, 3,500, 150, and 100. 4594, 3,500, 150, 100. 4596, 3,500, count 2 will be 3,500, and 3 will be 100. And finally, 4592, 3,500, 150, and 100. Please tell me your name.
Anthony Ross.
All right, Mr. Ross, you're here in 2019 CF 469 or 09 AO. You were arrested pursuant, looks like you turned yourself in, for grand theft third degree of a motor vehicle. I do find probable cause for the offense. I am gonna appoint the public defender to represent you. I'm gonna stay the bond at $1,000, sir. Not to have any contact with any victim or witness in the case, okay? All right, sir, please tell me your name.
My name is Jeffrey Shackle, Your Honor.
Okay, do we know what happened to Mr. Sanchez?
He's mentioned.
Okay. Let's send him over to courtroom 2. All right, sir, you're here in 2018 CF 15396AO. You were arrested pursuant to a capias for failing to appear for a pretrial conference on March 20th, 2019. The judge revoked your release, forfeited your bond, and set your bonds at none. Do we know if he has the public defender? He does? You do have the public defender, okay?
Ma'am, can I explain something to you?
There's nothing that I can do about the capias, sir. So if you want to talk to Mr. Augusto, you can ask him. But there's nothing that I can do about what's in the capias. All right, please tell me your name, ma'am.
Katrina Smith.
All right, Ms. Smith, you're here in 2019 CF 3585. You were arrested pursuant to a warrant, which probable cause was already found for 3 counts of sexual battery on a child under 12, lewd and lascivious molestation on a child under 12, 2 counts, sexual battery by a person in a custodial authority, and lewd and lascivious molestation of a child under 16. I am going to appoint the public defender to represent you. State, would you like to be heard as to bond?
Yes, Your Honor, I believe the defendant should be held at no bond on the first 3 counts based on proof evident presumption grade. Looking at the 8-page affidavit submitted by Detective Shaw, and it looks like the 2 victims, one was approximately 12 years old at the time of the alleged incidents, and one was approximately 9 years old. It says that this defendant forced the 2 victims, are 2 boys, male children. She forced their penis inside of her vagina on different occasions. She was undressing in front of them. She was without actual penetration, humping them over her underwear, but the children were undressed at the time. The victim was allowed to live with the defendants based on, I guess, their parents or the children's parent met the victim at church and allowed them to live. These events occurred when the mom of the children was out at work. Based on all the information in the affidavit, we asked the defendant be held at no bond on the first 3 counts. No contact with any minor children, definitely no contact with these children, no return to this residence, no weapons, no firearms, no drugs.
Mr. Augusto?
Yes, Your Honor. We would ask that the court use its discretion to set a monetary bond. In this case, Ms. Smith has no prior criminal history, no failure to appears. She has all her family here, and she's lived here all her life, so she's not a flight risk. So we would ask that this court use its discretion to set a monetary bond.
Okay, based on the statements of the 2 children being very consistent, and it not just being one witness, I do find proof evident presumption great based on everything that was alleged in the affidavit. I'm gonna order that she be held on no bond on counts 1, 2, and 3. Count 4 will be $10,000 and $150 on 5 and 6, and $150 on 7, sorry. You're not to have any contact with any minor children under the age of 18. You're not to return back to the victim's residence, which is listed in the affidavit for the arrest warrant. You're not to possess any drugs or alcohol or illegal substances without a valid prescription. You're not to possess any weapons or firearms or ammunition. You're not to have any contact with any witnesses or victims in this case. Please tell me your name, sir.
Keontae Stanley.
All right, Mr. Stanley, you're here in 2019 CF 4634AO. You're arrested for trafficking in MDMA. I do find probable cause for the offense. I'm going to appoint the public defender to represent you. Your bond will remain at the $50,000. You're not to possess or consume any illegal substances without a valid prescription. Please tell me your name.
Jamal Thomas.
All right, Mr. Thomas, you're here in 2019 CF 4640AO. You're arrested for grand theft 3rd degree of a motor vehicle. I do find probable cause for the offense. I am going to appoint the public defender to represent you. Your bond will be set at $3,500. You're out on bond in 2018 CF 17549AO, and in 2018 CF 17517AO. I am going to revoke those bonds and set them at none. Do we know, does he have, is it the PD on both? Okay, and it looks like you do have the public defender on both of those cases. I never know, because sometimes they put somebody's name and then or it's blank.
Your Honor, we would ask if the court would reconsider the revoking of the bond simply because my client has informed me that information wasn't filed in either of those two cases.
Okay, no, I'm gonna revoke the bonds. Part of his conditions of release are not to commit any new law offenses.
Thank you.
All right, please tell me your name, ma'am.
Jennifer Turner.
All right, Ms. Turner, you're here in 2018 CF 13909BO. You were arrested pursuant to a warrant, or excuse me, a capias, in which probable cause was found by a judge for the offenses of burglary of a structure and criminal mischief. You're not to return back to Size Coin Laundry at 3221 Curry Ford Road. Not to have any contact with any victim or witness in the case. Your bond will stay at the $5,000 on count 1 and $100 on count 2. 2018, I'm going to appoint the public defender on all of the cases, okay? 2018 CF 13907BO, you were arrested pursuant to a capias where a judge found probable cause. You're not to return back to the listed location of the offense in the affidavit for arrest warrant. You were arrested for attempted burglary of a structure and criminal mischief. Your bonds will stay at $5,000 on count 1 and $100 on count 2. You're not to have any contact with any victims or witnesses in that case. In 2018 CF 14577AO, you were arrested pursuant to a warrant, which probable cause was found for burglary of a structure, grand theft third degree, possession of burglary tools, and criminal mischief. Your bonds will remain as set at $1,000 on count 1, $500 on counts 2 and 3, $250 on counts 4, 5, and 6. Again, you're not to have any contact with any victims or listed witnesses in the case. And you're not to return back to the location of the offenses as listed in the affidavit. All right, sir, please tell me your name.
Jose Luis Villanueva.
All right, sir, you're here in 2019 CF 4619AO. You were arrested for driving while license revoked as a habitual offender, driving while license suspended as a subsequent offender, an expired license of more than 6 months. I do find probable cause for the offenses. I'm going to appoint the public defender to represent you in that case, as well as 2018, if they're not already appointed, 2018 CF 1903AO. In that case, you are arrested pursuant to a capias for failing to appear for your arraignment on 5/9/18. The judge revoked your bond and set your bond at none. In the CF case, in the 2019 CF case, your bond will stay at $2,500 on count 1 and $100 on counts 2 and 3. You're not to drive without a valid license. please tell me your name.
Audrey Walker.
All right, Ms. Walker, you're here in 2019 CF 4635AO. You're arrested for giving false information and petty theft, 2 prior convictions. I do find probable cause. I'm going to appoint the Public Defender's Office to represent you. Your bond on count 1 will be set at $100. Count 2 will stay at the $1,000 in 2019 CF 3782AO and in 2018 CF 16562AO. The Office of the Public Defender already represents you. I am going to revoke those bonds and set them at none. Please tell me your name, sir.
Roshima Williams.
Or ma'am, sorry.
Roshima Williams.
I'm having one of those days this morning, so I'm sorry. I did not mean to call you sir.
Okay.
You're here in 2019 CF 4629AO. You were arrested for trafficking in MDMA and possession of cocaine and possession of cannabis, less than 20 grams. I do find probable cause. I am going to appoint the public defender to represent you.
There's no objection to PTR, Your Honor. Obviously, no drugs and no weapons.
Sorry?
I said no drugs and no weapons on PTR.
All right, Ms. Williams, you do qualify for pretrial release. My problem is you have a history of arrest for trafficking. So I'm not going to place you in pretrial release. But I am going to stay the bond at the $50,000 on count 1. Counts 2 will be $150 and $100. Huh? Oh, no drugs, sorry ma'am, no drugs or alcohol or medications without a prescription, no weapons or firearms or ammunition. All right, sir, please tell me your name.
My name is Antoine Wilson.
All right, Mr. Wilson, you're here in 2019 CF 4632AO. You're arrested for possession of cocaine and possession of drug paraphernalia. I do find probable cause. I am going to appoint the public defender to represent you.
Thank you.
Your bond on count 1 will be $2,500 and $100 on count 2. You're not to possess or consume any illegal substances without a valid prescription.
Ma'am, they told me one bond was account 1,000.
We would ask, Your Honor, if Your Honor would reconsider reducing the bond or staying the bond to the 1,000.
My problem is that the most recent failure to appear was February of 2019. And he has 9 felony convictions, 15 misdemeanor convictions, 3 unknowns, 2 failures to appear, a lot of drug convictions, a lot of drug arrests. That's the reason for my bond.
Good morning, Your Honor.
Morning. Please tell me your name.
Daniel Mayfield, Your Honor.
Okay, we'll reset. Okay, we'll reset. Mr. Mayfield, is that what you said?
Yes, ma'am.
Okay. So you're here in 2019 MO 6020. You were arrested for state misdemeanors. I do find probable cause for the offense. I am going to appoint the public defender. Do you want to try and resolve your case today?
I would love to, Your Honor.
Okay.
There is no offer from the state.
Okay.
No.
Would Your Honor be willing to extend?
I'm rereading the affidavit so that I'm more familiar with what's going on here. Based on my review, again, of the affidavit, and this being technically a victim crime, and without any input from the victim, I'm not going to make an offer today.
Your Honor, if I may.
Sure.
Well, Your Honor, I really would appreciate if you could possibly.
I'm not going to make an offer today. This is a victim crime, and the victim has a right to be heard. So if, and this doesn't appear as if the state's had any contact with the victim. So I'm going to stay the bond at the $250. You're not to have any contact with the victim in this case. You're not to return to her residence or the apartment complex.
Well, Your Honor, I live in that apartment
Okay,
complex.
well, you're not to go back to her residence, okay?
Sure. All right. But there is one thing, Your Honor. I'm already out on bond for a charge that I got arrested on in January, and I was assigned a public defender on that case, and I'm supposed to be going to court on Monday.
I don't have any information about any out on bond case.
Well, I'm out on.
May I have a moment, Your Honor?
Yeah, well, anyway, I mean, you're in the public defender's office, right? Hey, my lawyer's name is Charles Frederick.
2019 MM25. His name is spelled differently on this. It's missing an I in his name. It's Daniel.
What's the offense?
It is a battery, first-degree misdemeanor. Same date of birth. 1/25/75 is the date of birth on this case. Charles Frederick is the PD assigned to the case. Has a pretrial. Has the trial set on 4/8, which would be Monday.
Okay, so what's your question?
Wondering that if I'm gonna have to, because I don't have any means of bonding out at this time, if I'm gonna be in jail anyway, would it be possible for you to revoke my bond on my previous case and contact my public defender to let him know that I'm currently incarcerated? Because I don't want to have to be sitting in here and end up with a failure to appear because nobody knew that I was here.
They would transport you over there, sir, but I will revoke your bond, okay? Can you read me that case number again?
19 MM25AA.
Thank you. All right, Mr. Mayfield, I will revoke your bond in 2019 MM25AA. And so that you'll start receiving some credit, okay?
I appreciate that.
And Mr. Augusto can let Mr. Frederick know, okay?
Yeah, I sure would appreciate that. Okay, thank you.
But again, you're not to have any contact with the victim in the case, okay?
Certainly.
And was that 258A or
25AA.
AA?
Yeah.
Thank you.
All right, please tell me your name.
Joseph Samard.
All right, Mr. Samard, you're here in 2019 MO6030. You were arrested for disorderly conduct. I do find probable cause for the offense. Did you want to see if the state has an offer? You did not fill out a form for the public defender.
Yes, please.
Thank you. State, is there an offer?
No objection to ROR or adjudication, 3 days.
And he has 2 days in? Okay. So, Mr. Samar, the offer from the state is an adjudication of guilt with 3 days with credit for 2 days, but I think you would get out today. Is that correct? If you want to take that.
Okay, I'll take that.
Okay. And I do have to impose court costs, just so you know. You're okay going forward without an attorney?
Yes.
Okay. You want to plead no contest?
Yes, please.
All right, Mr. Samard, I'm showing you this plea form. Is this your signature at the bottom?
Yes.
Did you understand everything contained within the plea form? I just need you to say it out loud.
Yes, yes, I do.
You understand all the rights you're giving up by entering the plea?
Yes, I do.
Okay. And are you on probation anywhere?
Nowhere.
Okay.
Yeah.
Do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Yes, I do.
Okay. I do find a factual basis for you to enter the plea. I am going to adjudicate you guilty, sentence you to 3 days in the Orange County Jail with credit for 2 days' time served. I am going to impose court costs. I'm going to order that you pay those by April 4th, 2020. It gives you a year to pay them off, okay?
Okay,
If you want to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you.
Okay.
All right? Good luck to you.
Thank you.
All right, please tell me your name.
John Flores.
Do we know what happened to Mr. Candelaria? Okay. Send him over to courtroom 2. Mr. Flores?
Yes, ma'am.
Okay. All right, you're here in 2019 MM2830AO. You were arrested for possession of cannabis, less than 20 grams, and possession of drug paraphernalia. I do find probable cause for the offense. I am going to appoint the public defender to represent you. Your bond on count 1 will remain at the $100, count 2 the $500. You are out on bond, sir, in 2019 CF 2855AO. I am going to revoke those bonds and set them at none. All right, ma'am, please tell me your name.
Tijuana Smith.
All right, Miss Smith. You're here in 2019 MM2829AO. You're arrested for possession of drug paraphernalia. I do find probable cause for the offense. I am going to appoint the public defender to represent you. Your bond will stay at the $500. I believe you're out on conditional release on a bunch of cases, right? Mr. Augusto, it looks like she has one of the next hearings she has is on April 8th.
Yes, Your Honor.
In 2018 MM 6910. Trying to see if there's any release conditions on the conditional release. Looks like in the 18 CF 5823AO, she was found incompetent in 2018, but Judge Adams denied anything as to conditional release. I'm trying to find some conditional release plan. Mr. Augusto, are you aware of any plans she's on?
No, Your Honor. The only ones that I'm seeing here that say conditional release is 2018 MM 7873 AO. And then 1218 AW.
Let me look that one up because I'm not seeing any. I'm shocked that it's not in a felony case. It looks like, are you reporting to Aspire?
Yeah.
Okay. When was the last time that you reported to Aspire? Do you
It's
have a
been
case
about
manager?
2 weeks.
Do you have a case manager?
Yes, ma'am.
Who's your case manager?
Shit, I forgot his name. I forgot his name.
Okay, I just trying to figure out, you know, what's going on with your cases.
Right.
Are you receiving, you're receiving competency restoration program?
Yes, ma'am.
You're in their program?
I'm actually on the pre-trial release, so.
right, I'm not gonna take any action on these cases today. But I am gonna alert the judges, those cases, okay?
Okay.
So just make sure you keep complying with your release, conditions of release. And I believe they're listed for Mr. Augusto's purposes in 2018 MM 7874AO. That's the only order that I can find that has the conditional release program.
So I'm getting
information.
released?
Huh?
I'm getting released.
I'm setting your bond at $500, okay? You're not to possess or consume any illegal substances without a valid prescription. That's part of your conditional release program plan, okay?
Shit. All right.
All right, ma'am, please tell me your name.
Toshiba Buckles.
All right, Miss Buckles, you're here you're picked up on an out-of-county warrant out of Osceola County. And looks like the bond is $1,000 in that case. Osceola County has 24 hours to come and pick you up. And looks like there's another warrant out of Osceola County as well. And that bond is at 1,000. And another one in Osceola, and that bond is also at 1,000. So if you can't bond out, and I'm not gonna take any action on the out on bond case in Orange because I don't know anything about the Osceola County cases. So I can't take any action on that, okay? So, but if you can bond out, you bond out. If not, Osceola has 24 hours to come and get you, okay? All right, please tell me your name, sir.
Jamel, LaShawn, Little John.
All right, Mr. Littlejohn, you were picked up on an out-of-county warrant out of Polk County for a violation of probation, and there's no bond in that case. So I think Polk County has 24 hours to come and get you if you, so they should come and get you, okay?
Okay, if they don't come and get me within the 24 hours, what happens?
You'll come see a judge again,
Okay.
okay?
Thank you so much.
I can barely hear you, Lisa. I can't hear you at all. Actually, hey, can we quiet down, please? Yes, ma'am, I will. Yes, Your Honor, we can. Callie Chrysler, Assistant Public Defender, and with me today is Evelyn Jimenez and Janine Ante. Your Honor, we do have some that are going to require an interpreter today. I just wanted to let you know so that yes, Your Honor. Yes, Your Honor. That's what I was looking to, what you wanted to do with them. Oh, here, you can pick it up.
Justo Arellano. Yes. Yes. Yes.
I believe so, Your Honor. But he has a private attorney on the DUI, and I believe that private attorney has also filed in the VOP, just not a notice of appearance. Yes, and I believe that that same lawyer filed a bond motion in the VOP from what I saw last night. Yes. Yes, Your Honor. Deny.
I'd like to deny for today, please. I'd like to deny for today.
Oh, we cannot hear the clerk, Your Honor. Yes, Your Honor. He's not in custody, Your Honor. I know, but I was informed by the CO that he is not in custody. No. That would make sense why he's not here then. He has a private attorney, Your Honor.
Good morning. Gesley Burles. Yes, ma'am. Thank you.
Rigoberto Bernal.
Not guilty, Your Honor. Okay. Your Honor, he actually says that he wants to plea right now, but no offer was conveyed.
That's fine, Your Honor. Yes, ma'am.
There it is.
That's fine, ma'am. As to this charge, and when would I be sentenced? Today?
No. Here. That was a question for you.
I'm sorry, ma'am? Yes, for a plea date. Yes, I'm already sentenced to a case. That's why I was trying to get it resolved today. Yes, ma'am. The 25th of March. 200 days. I'll take that. Yes.
Yes, Your Honor. You can have a seat.
Good morning. Harrison Bodrick.
Your Honor, he does have a valid driver's license, and we wanted to know if that would change the offer from the state. It was admit 30 days, revoke in term. Yes, Your Honor.
Yes, ma'am.
I explain. I would deny it.
What is? I don't have a recent marijuana charge.
You said that the marijuana charge is what's violating him, and it's from Polk County, Your Honor?
They dropped two of them. It was only the suspended.
It's up to you, but I would deny it.
I'm gonna deny it.
Yes, Nikisha Boggs. Yes.
Absolutely not, Your Honor.
4. Okay. Okay.
Your Honor, Attorney Blanco is here, and I believe he wishes to be heard. It's a 10 a.m. docket.
I woke up early, Judge. Judge, no, it's a quick question. I don't want to interrupt your docket, Judge. It's for Ricardo. It's for Ricardo Trujillo. He is 10 o'clock docket. It's for a plea. I didn't have the joint motion for substitution of counsel. I had sent it to the PD's office. They couldn't get to it until today. I got it now. It's in front of me. It's all signed by my client and by myself. Actually, my client signed it yesterday, and the PD signed it this morning. So on the docket, it shows do not transport, but the defendant is here in court. So I didn't know what to do here. So. Okay. Okay, so 10. Okay. No, it's fine. I'll come back, Judge. Not a problem. All right, thank you.
As far as I know, he's still in Tennessee, Your Honor. This is going to be an interpreter, Your Honor. He refused to come? No, that was Cabrera. Yes, Your Honor.
Good morning, Your Honor. Edgar Dominus Cortijo.
Your Honor. Your Honor, my colleague who's assigned to the case informed me that there was a conflict that she was filing on for our office, and that we were going to have to withdraw because of that.
Yeah, that sounds great. Thank you, Your Honor. Have a good day.
Thank you, Your Honor. He is here. Oh, yeah.
Ms. Ferguson? Cyril Ferguson?
There was no offer conveyed, Your Honor. Or the... plead not guilty.
Not guilty.
Yeah. Yep, this is also going to be an interpreter, Your Honor. Oh, wait. Oh. Oh, wait, he says that he can do it in English. Yep.
Good morning. Miguel A. Garza. Yes, it'll be okay, thank you. Yes, ma'am.
Can I have a moment, Your Honor?
Yes. What's that?
Ese es el máximo. Can I have a moment, Your Honor?
Okay, thank you.
He's approaching, Your Honor.
David Garcia.
Your Honor, not guilty.
Thank you.
Good morning, Your Honor. Nicholas Marcos Gomez.
Your Honor, there was a, we detected a possible conflict in this case. We detected a possible conflict in this case. We haven't filed a motion yet, but it was just approved last night. We will be needing to not represent him and wait for the motion to be resolved.
Yes, ma'am. There's no way that I could represent myself right now. Is there any way that I could represent myself right now? Yes, ma'am. That's fine. Your Honor, I have also been incarcerated since December 27th of 2018. No, ma'am, but I've had a hold for this case while I was in Seminole. Thank you. Would I be able to have a moment to contemplate this, Your Honor? To contemplate this, would I be able to have a moment? Yes, ma'am. Okay, thank you.
He's approaching, Your Honor.
Good morning, Your Honor. Roberto Gonzalez Broach. Not guilty, Your Honor? Yes, ma'am. Not yet, Your Honor. Yes, ma'am.
She's not in custody, Your Honor. Your Honor, I was aware by the public defender appointed in her case that an offer was conveyed and they were trying to locate plea date certain, but they were not on time before this hearing, so.
Adrián Guzmán. I got a felony. Yeah.
Your Honor, I expressed that to the client, to the defendant, and the offer was an adjudication of guilt, credit time served, court cost, and his position was to take the offer just before I came to the podium.
Yeah.
Are you against?
Yeah, I understand. Yeah, I'm sure.
Your Honor, we want to make it on the record that it was against public defender's advice, and he still wished to take the plea. Your Honor, accordingly to the records, it says he's in Volusia County. No, Your Honor. He's approaching.
Oh, Your Honor. Chad Everett Kerr.
Your Honor, an offer was conveyed for an adjudication of guilt, credit time served, and court costs, and he wishes to take the plea.
Guilty.
Eric Lopez. 92590. Well, I paid 2 tickets.
May I have a moment, Your Honor? Your Honor, an offer was conveyed, an adjudication of guilt, 60 days, and court cost. Will he be getting credit for the 54 days? It's on the docket. So, yeah, he wishes to take the plea, Your Honor.
Guilty. Guilty.
Alyssa Martin. it's not.
That's the offer, Your Honor. Credit time served.
Yes. Yeah, I'm pleading guilty.
Now I got it.
Yeah.
Yes,
Yeah,
Your
it's
Honor.
8 months, 30 weeks. I'm trying to.
Yes, Your Honor.
I'm just gonna plead guilty.
Good morning, Your Honor. Saquon Martin.
Not guilty, Your Honor.
All right, thank you.
Your Honor, may we, Miss Greenleaf, Cara Greenleaf was here, was in minimum, and by mistake, it was stated that she was not in custody. She's here. Page, I think, yes. Okay.
Jennifer Metelsky.
Good morning, Your Honor.
Yes, ma'am.
Your Honor, we could not hear what Ms. Rapchick was saying.
Yeah.
Not guilty.
Not guilty. Yes. Yes.
She already has, Your Honor. Thank you, Your Honor.
Thank you.
Good morning.
Kenneth Newhouse.
Your Honor, Mr. Newhouse will be taking a plea this morning. Yes, Your Honor. The terms is an adjudication of guilt, credit time served, followed by 12 months probation, consecutive drug evaluation and treatment and court costs.
Yes, ma'am. Guilty.
She hasn't been brought up just yet. They're bringing her up. He's approaching, Your Honor.
Jose Luis Ramos.
Mr. Ramos will be taking a plea this morning as well. An adjudication of guilt, credit time served, and court costs.
Guilty.
Mr. Riddle's approaching.
Evan Riddle.
Do you have anything else pending?
Not in this county. Not in this county.
Not in this county, Your Honor. He will be taking that offer, Your Honor.
Guilty.
Your Honor, according to the docket, Mr. Sanchez Torres is incarcerated in Dade County Jail. Mr. Smith refused to come. I guess, Your Honor. Mr. Smith is approaching.
Jamal Curtis Smith.
Yes. Ma'am, before you keep on going, I want to tell you I've been served both of them warrants on March 1st, 2018, when I first got incarcerated in Orange County Jail. I don't even know what they talking about.
We
I
couldn't
can't
hear the offer.
But how I got credit for 9 when I've been served these warrants last year. He said 45 days or what, all consecutive and stuff like that? And you said 6 months papers. 6 months probation.
And would this be an adjudication or a withhold, Your Honor?
It'll be with adjudication. Not guilty. Yes, and I'm going to trial. I need a speedy trial.
I believe he did, Your Honor.
Calvin Thomas.
Make sure you speak up. You're a little bit soft-spoken. Okay. Not guilty, Your Honor. She's approaching, Your Honor.
Bianca Trinidad.
Not guilty at this time, Your Honor. Ms. Trinidad intended on taking the offer this afternoon on the VOP, so I need some time to discuss this with her. And Could I have a moment to discuss this with her? Have a seat.
Good morning, ma'am. Jermaine Trochet. Not guilty. I'm a higher lawyer. Thank you.
Good morning, Your Honor. It's Kenneth Witt. Yeah, I'm gonna plead guilty. I'm gonna plead guilty.
Thank you, Your Honor.
He wants to plead not guilty, Your Honor.
I'm not guilty, I'm Galarza.
No, Your Honor, one moment.
I'm not guilty, I'm Galarza. Okay.
Oh,
Okay. No problem.
thank you.
Thank you.
Your Honor, if I choose to plead not guilty and I get set for pretrial, do you have any idea, hypothetically speaking, how long, how far out that would be set for? Yes, ma'am. I'm gonna just plead guilty and take the 18 days. But actually, before I say that, when I was first originally arrested on this charge, I was here for 2 days. Will I not get time for credit for that too? Yes, since the 24th, I was served the warrant. But when I was first originally arrested for this, I served 2 days here for that too. Okay. Okay, I'll go ahead. I'll plead guilty. I'll take the 30 days. No, I was hypothetically asking a question, Your Honor. Yes, that's better than May 1st.
Yes, Your Honor.
Cara Beth Torrey Greenleaf. Cara Beth Torrey Greenleaf.
Tori is a name.
That's my maiden name. Greenleaf was my married name, and I think that's why I didn't get my notice for the court, because
Your Honor, an offer was conveyed, withhold car costs, no return, and credit time served, and she wants to take the offer, Your Honor.
thank you.
Oh, I've got 3 up here. This way. Here we are.
Yes.
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 Chad Everett Kerr. Chad Everett Kerr.
Adrian Guzman.
Rigoberto Bernal.
Yes.
He,
Have to sign.
yes. I did not know, Your Honor. I thought I had all the papers here. Yes, he did.
Yeah.
Yes.
I'll go over it with you.
Yes.
Yeah.
Yes.
Yes.
Yeah.
Yes.
Okay.
No.
Nope.
No.
No.
Nope.
No.
No.
Nope.
No.
No.
Nope.
No.
Yes.
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 Yes. Yes. No.
Yes. 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 Thank you, Your Honor.
don't drive.
Yes, Your Honor. Yes. Yes, Your Honor. Yes, Your Honor.
Thank you.
Thank you. Oh, excellent. Do you want to come up here? Oh, no, I got that one. Is that the only one that we have? Cool. Cabrera.
Hola.
Say your name.
Hello.
Just say your name.
El micrófono no sirve.
Your name. Your name. Say your name. Say your name.
Hello. What?
Your name. Tu nombre.
Pero a quién se lo digo aquí. Dilo en el micrófono. Pero el micrófono está supuesto sonar como ella.
Your Honor.
¿Eh? No está supuesto sonar así.
Háblale, que ya te escuchan.
Ah, ok.
Your
Está
Honor,
bien. Sí, eso ya sé, Cabrera.
we have some concerns. Yeah. Yeah. No. And yes, Your Honor, we do have some concerns, Your Honor, and we would be entering a plea of not guilty today. May 1st.
Sí.
What was the other one in Spanish? He said and then changed his mind. Oh, we have somebody who's waiting for their private attorney? Yes, Your Honor.
It's Ricardo Trujillo, Your Honor. It's Mr. Blanco, the private attorney that was here this morning. He's not here? Yes, I think
Yes.
so.
Yeah.
Your Honor, also, can you take into consideration that we sign a joint motion to the public defender office be removed? Will be here, and he will be there. Yes. I know.
You can stand.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Jose Luis Ramos.
Evan Riddle.
Kenneth Newhouse. Yes, ma'am.
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Yes, ma'am. No, ma'am.
No, ma'am.
No, 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 ma'am. Yes, ma'am.
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Yes, ma'am. Guilty. Yes. Yes, ma'am.
Guilty. Yes, ma'am.
Guilty. Yes, ma'am. Yes, ma'am.
Within 5 days of your release.
So I might get released from that Pasco County. Still good.
No, Your Honor, it's been consecutive. Yes, that was what was discussed.
Yay.
Thank you, Your Honor. Mr. Gomez has not finished completing his plea form. Mr. Witt has. Mr. Lopez? Lopez? Do you speak English, sir? Yes. Okay.
Yes, ma'am.
My apologies, Your Honor.
Yes,
One of you
ma'am.
is-
Yes,
Answer.
ma'am.
Oh, yes.
Yes, ma'am.
Eric Lopez.
Kenneth Witt.
Yes, I did.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
Yes.
Yes, ma'am.
Nope.
No, ma'am.
No, ma'am.
No, ma'am.
No, ma'am.
No, ma'am.
Yes, ma'am.
Yes, ma'am.
Yes.
Yes, ma'am.
Yes, ma'am. Oh, sorry. Guilty. Yes. Probably, ma'am, but I wasn't working at the time. I didn't have a phone. I didn't have a cell phone. Couldn't pay the bill. Yes, ma'am.
Guilty. Yes, ma'am.
They're approaching, Your Honor. Do you have your paperwork, ma'am? Yes. Thank you. Do you have your paperwork, ma'am?
Yes.
Yes. Yes.
Kara Beth Greenleaf.
Alyssa Morton.
Yes.
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 Yes, except for the court costs. Do I have court costs? Okay, thank you. Yes.
No, ma'am.
No.
No.
No, Your Honor.
No.
Yes, Your Honor.
Yes.
Yes, Your Honor.
Yes.
Guilty, Your Honor. Yes, Your Honor.
Guilty. Yes.
Can I possibly go to the courthouse today? Okay. Okay, thank you, Your Honor.
Okay.
Your Honor, Ms. Trinidad will be accepting the offer. I had the completed plea form for the violation of probation at the office ready for this afternoon. If we can just confirm what the offer was, we can go ahead and get everything taken care of this morning. Both, Your Honor. Sure, Your Honor. Could we would you like to transport her this afternoon, or would you like to do the plea for this afternoon today? Sure. Sure. Your Honor, what I would ask, with Ms. Trinidad's understanding, would be enter a plea of not guilty on the new charge, get set for pretrial, and that should give the state enough time to contact the victim, and hopefully we can plead that day. She is not, Your Honor. Understood, Your Honor. I just need 1 second to prepare the form. Thank you, Your Honor. Sure, thank you very much.
Yes, Your Honor. Yes. Nicholas Marcos Gomez. Yes. 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 No. Although I was rushed, no. No, ma'am. No, ma'am, it's all right. Nope. Yes. No. Guilty. Yep. Yes. Yep.
Good morning, Your Honor. Yeah, I understand. Brock Shields on behalf of Ms. Schweitzer. Your Honor, just for the court's edification, the no registration will be null pros, and she's pleading guilty as charged to the suspended license. Yeah.
Yes, ma'am. Christy Schweitzer. Yes, ma'am. Yes, Your Honor. Yes, ma'am. No, ma'am. No, ma'am. No, ma'am. No, ma'am. Yes, ma'am. Yes, ma'am. Guilty. Yes, Your Honor. Yes, Your Honor.
There was a no registration in 2018 CT, I believe 3418. She was charged with two separate cases. No registration? Oh, the state's null processing that, Your Honor. Thank you, Your Honor. You too, Your Honor.
Yes, Judge, unfortunately he does. I'm sorry, I wasn't here I thought it was at 10 a.m. and I had stepped out, so I apologize. Okay, all right, thank you, Judge.
Ms. Boggs is in here, yes. Yep. She is, Your Honor. One thing, Mr. Bodrick, 18 CT 3866, caught my attention again, and he says that he does wish to plea today. No. Yes, Your Honor. Yes, Your Honor.
Thank you, Your Honor.
Yes. Bianca Trinidad. Yes. Yes. Yes, ma'am. Yes. No. No, Your Honor. No. No. Yes, ma'am. Yes. Guilty. Yes. 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 Okay. 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 Just, we were dating the same person. Yeah. Yeah. Neither of us. Yeah. No, it's true. Yes. Thank you.
Thank you, Your Honor. Thank you, Your Honor. And she completed a new one. She completed a new one as well. Thank you, Your Honor.
Your Honor, can you send the Mr. Schuler to our office to make an appointment? I don't have any information right now. Yeah. No, downstairs, first floor. Yes. Thank you. Thank you, Your Honor.
Your Honor, all that, oh, I apologize, I apologize. Yes, Your Honor, all that's left is Mr. Blanco's client. May we be excused? And Miss Boggs, yes. Yes, Your Honor, thank you. We'll see you this afternoon.
Okay, thank you, Judge, that's fine, I'm just here talking to PDs. Thank you. Lazaro Blanco on behalf of Ricardo Trujillo. Judge, should he hold the microphone?
Sí, señor. Ricardo Trujillo. Sí, señor. Sí.
Thank you, Your Honor.
Yes, Judge. Yes, it is, Your Honor. He's going to be withdrawing his previously entered plea of not guilty, enter a plea of no contest to no valid driver's license. The agreed upon disposition is an adjudication credit time. Right. And it's the agreed upon disposition is with the state is an adjudication, credit time served, and court costs. And we would, stipulate to a factual basis, Judge, to resolve the case. Yes, Judge, I had the plea form here. He signed it. I gave it to the public defenders, and they took it.
Sí. 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 No. 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 Sí. No me opongo. Sí. Okay. Thank you, Anna.
$223. What? Dice, dile 4 meses.
4 meses está bien. Okay. Thank you, gracias.
Thank you so much, Your Honor. I apologize. No, I apologize for stepping out. That was my fault. Thank you.
Good morning again, Your Honor. Yes, Your Honor. We do, Your Honor. I reviewed it with my client. She has signed it.
Yes. Nikisha Boggs. Yes. 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 No. 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 Yes. Yes. No contest.
Oh, sorry, admit, Your Honor.
As far as the payments, ma'am, yes. Yes.
I would, for the purpose.
As, the payments, I do know that I may have gotten behind on the. Yes, ma'am. I submitted it with the last 10 hours that I did at the baseball field. It was 2 days I had to do it, 4 hours a day. To be honest, I don't remember the exact month because it was a while ago. I really don't know the exact month. Yes, it should have been. Yes, ma'am.
Your Honor, may I have a moment briefly? Yes. If you find that we can go to a hearing, but you're stuck here, I think you should admit to it, and then argue the court that you did, and ask them to show that you did abscond, okay? This plea, Your Honor, would admit.
Yes, ma'am. Yes, ma'am.
Your Honor, this is an open plea. We'd like an opportunity to present factors of mitigation. No, Your Honor, the state's asking for 20. We're pleading to the bench judge and asking the court to consider time served. I'm sorry, Your Honor. I apologize. I didn't specify it. Yes, and Your Honor, I will do a notice of filing of those documents as well, so they'll actually be in the court file if you need me to. That's fine, Your Honor. Okay. Yeah, I just wanted to hear, did the state say Brevard County? Okay. Your Honor, I wish for proper testimony from the defendant. All right. Ms. Boggs, well, let's start with your probation. Did you complete the duels class?
Yes, sir.
Can you tell us a little bit about what you went through in that class?
Yes, it was actually a class that I had to complete within 2 days, 4 hours a day to complete an 8-hour session.
And what kind of things did you do? Where did you remember where you took this class?
Yes, it was an online class.
Online class. And can you remember some of the stuff that the class talked about?
Yes, basically, the class that I took specifically was involving driving on a suspended license. We had to go over a booklet, we had quizzes, we had tests, we had scenarios that they went over. We even watched a court viewing.
And can you, just to enlighten the court, is there anything about, I know this was a couple years ago, but is there anything about those classes you remember?
Yes.
Can you please just give some details to the court?
Well, I do know that for the first 2 hours of each class, it was just basically class-based. And then you had a pre-quiz, and then at the end, they went over other things, and then you had a test afterwards.
What kind of stuff was in the class?
Oh, as far as yielding, the basic driving signals, the basic driving rules, almost as if you're taking a permit test or a permit class.
Okay. And community service hours, did you complete any community service hours?
Yes, I did.
Where did you do those hours?
I did them at a baseball field in Brandon.
And you understand that you're under oath right now? That's
Yes.
Under the penalties of perjury?
Yes.
Okay. And what did you do for these hours?
I did a concession and tickets.
Okay, it was like a little league?
Yes. Mm-hmm.
Okay, and this is for the city of Brandon?
Yes, Brandon.
Okay. And did you send money to your probation officer?
Yes, I did, in the form of a money order every month. I used to send it when I had to send my paper to basically sign in.
Okay, and you would do that roughly every 30 days?
Yes, every month.
You had communication with your probation officer?
Yes, I believe her name was Monique Randall.
Okay. And what about payments to the court?
Payments to the court, like I said, I may have missed payments to the court. I honestly thought I was paying my stuff. I didn't know that it was for it.
You were making a good faith effort to pay?
Right.
Your Honor, no questions, no further questions.
My mother.
Your Honor, if I don't know if there's, I just have argument left. I don't know if there's anything else you want to proffer from. Judge, the important thing that we want to stress to the court, Your Honor, is that this is not a case of absconding. If that were the situation, the affidavit gives the impression that it's a matter of absconding, Your Honor. And if it was, Your Honor, I would take the 20 days because honestly, 30 would be appropriate and she would save 5 by doing the 20. But Judge, we're asking the court to consider a credit time served, and we believe that there's indications of compliance and a good faith effort to try and comply, Your Honor. If you see the court records for when the payments are made, they're not made in the court, and they're in the court file, and I ask the court to take judicial notice of the file. They're not made on the 4th of every month, but they are almost on a monthly basis, and that's an indication that Ms. Boggs did make an effort to try and comply with paying the court. I think the court can weigh her testimony, and I think she can show under penalties of perjury, because she's risking looking at 5 years in prison if she's lying to you here today, Your Honor, that she did make an effort to do the class, and the fact that she's able to give details about the class, even though this was probably 4 or 5 years ago at this point, Your Honor, because this is a 2014 case and she's on probation in 2015, now 2019. 4 years later, she's able to remember a fair amount of detail about the class, how long it took, what was in the class, also her work at the baseball field, working concessions and tickets. I think is indication to show. But yes, she will admit that she's admitting, Your Honor, that she did fall behind, but she was trying. I'd ask the court to consider 14 days credit time served and D6, any expenses to the court and probation. She's in the process of getting her license back. She did, Your Honor, pick up a new charge 5 years later in Seminole County. which she was arrested on and posted a bond. We're dealing with that, Your Honor. But she's going to be getting her license back, and I have a feeling that when she gets out, her family's probably going to retain my services, and I'll assist her with that.
Okay. December, okay. Yes, ma'am.
And we'll be available, Your Honor. Thank you. Your Honor. Judge, this is the only matter I had before this court. It's good to see you again. May I be excused? Yes. And Your Honor, which part of the alphabet do you, I'm back in Kissimmee now. Which part of the alphabet do you have? What used to be Judge Epperson's. And Judge Sanders, is she in criminal? She's in civil. So, what used to be, okay. B through G. Okay, all right, I'll have to write that down. Thank you, Judge, good to see you. Bye.
I have the parties please announce themselves for the record.
Kathy Kennedy Swanson on behalf of the Office of the State Attorney.
Alexis Augusto on behalf of the Office of the Public Defender.
Adam Reese on behalf of Defendant Sierra Smith.
Good afternoon, Mr. Reese.
Good afternoon.
How are you?
Pleasure to see you. I'm good.
Good. Okay, can you tell me your name, ma'am?
Sierra Smith.
All right, Ms. Smith, you're here in 2018 CF 16728, is that correct? Yes, BO. And you were arrested pursuant to a capias for kidnapping with intent to inflict bodily harm or terrorize with a firearm, aggravated battery causing great bodily harm with a firearm, and aggravated battery with a firearm. And you're represented by Mr. Reese here, and this is, count one is a life felony. Does the state want to be heard as to bond?
Yes, Your Honor. We'd ask this defendant be held at no bond, looking at the four corners of the document supporting the information that was filed on count one. Looks like this defendant with a co-defendant forced the victim. I guess there was allegation that he may have taken a wallet, forced the victim back in the house. The co-defendant held a gun to the victim's head. The defendant began striking the victim. They had him empty out his luggage. The victim believed that it was a setup. The wallet was found in a room in a drawer. The co-defendant had the defendant hold his hand over an open flame and burn his hand. This co-defendant was a willing participant in this. They took his cell phone. Based on all that information in the affidavit, we asked the defendant be held at no bond. No contact with the victim, no contact with the co-defendant, no weapons, no drugs or firearms while this case is pending.
Mr. Reese?
Your Honor, would you like testimony or a proffer? Would proffer be sufficient?
As to bond?
Yes, ma'am.
I would prefer the testimony.
Okay, that's fine. Just a very brief response, and then I'd like to offer some testimony to my client. From what I've reviewed, and it's not nearly as much as the state or it may be, I was given the information this morning by one of your clerks as well as a charging affidavit. It appears as though the co-defendant is a bit more culpable than my client. With that, I would like to just ask Ms. Smith a few questions.
Sure. Can you have her, let's have her sworn in, okay?
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
May I proceed?
Absolutely.
Could you state your name, please?
Sierra Smith,
Ms. Smith, where were you born?
Orlando, Florida,
And how old are you?
23.
And have you lived your entire life in Central Florida?
Yes, sir.
Were you most recently employed?
Yes, I was.
Where were you working?
I was at the Roadway Inn on Oak Ridge and
Oak Ridge and OBT. I was just about to get promoted, but I quit my job
And why did you quit?
because I found out I had a warrant.
And after you learned you had a warrant, did you make arrangements to retain my office?
Yes,
Did you also surrender yourself last night knowing that there was a warrant and that you might be held no bond?
yes,
Why did you surrender?
because I found out I had a warrant.
That's the right thing to do?
Yes.
No further questions.
Okay. And so the state's asking me to find proof evident presumption great and to hold her no bond?
Yes, Your Honor.
Okay. Is there any other argument other than she's just less culpable?
Not on the facts of the case, Your Honor. However, if the court does find proof evident presumption great, this court still has discretion to set bond, as the court's well aware. We have a situation where somebody made arrangements to go ahead and surrender to the Orange County Jail, knowing that there was a warrant and that more likely than not it was a no bond case. She was also, I think, responsible enough to quit her job in advance. That way she could prepare for the case and get her job back should the court set bond, not leaving her employment hanging. She was born here, she's raised here, and I believe she's got significant ties to the community. I think under the circumstances, the court could exercise its discretion and set bond in this matter.
Okay. First, the conditions of any release are going to be you're not to possess any weapons, firearms, or ammunition. You're not to have any drugs or alcohol without a valid prescription. You're not to have any contact with any victim, any witness, or any co-defendant in the case.
Yes, ma'am.
I have read the affidavit. It appears as though the victim was severely injured in this case. Does she have an active warrant indicator? That's what I'm showing on the face sheet.
No, I got married, so they always make me
Okay.
show my ID. Because when I went to court last time, my last name's changed. But I don't have.
So there's no active warrant?
warrant.
I'm just showing
Well, I
that on
don't
my
know. No,
face sheet, so.
Never even been there. And Osceola, my name was coming up under something else, so I showed my ID.
Let's just check on that.
Okay.
Oh, I'm looking at the wrong face sheet. I am mistaken.
First time for everything.
No, it's to my left, and they usually are, but this is attached to it, so. Let's see. All right, here's what I'm gonna do. I do find proof evident presumption great. I'm gonna set the bond on count 1 at $150,000. Count 2, $10,000, and count 3, $10,000. And all of those conditions will apply. If you violate any of those conditions, ma'am, I will revoke the bond,
I appreciate you.
okay?
Thank you.
Thank you, Judge.
Thank you, Mr. Reese. All right, please tell me your name, sir.
Craig Blocker.
Mr. Blocker, you're here in 2019 CF 2589AO. You're arrested pursuant to a warrant in which probable cause was found for grand theft third degree. In 2019 CF 2589. Is that the same case? Sorry, same case. 2017 CF 14341AO. You're arrested for failing to appear pursuant to a capias for pretrial on March 27, 2019. The judge in that case set your bond in that case at none. In the new case, the bond will be stayed as set in the warrant at $1,000. You're not to have any contact with any witness or victim in the case, and you're not to return back to the scene of the offense.
Where were you appointed on that, Your Honor?
Sorry. Yes, I'm appointing the public defender. Thank you. And I don't know, does he have the public defender on the pretrial case? Yes, okay. Sorry, I can take this. Please tell me your name.
Jamel Clark.
Do you know what happened to Mr. Christian? Okay, take no action. Oh, take that out. Mr. Clark?
Yes.
All right, sir, you're here in 2019 CF 4659AO. You were arrested for possession of cocaine with a weapon. I do find probable cause for the offense. It appears you do not qualify for the public defender's office based on your application. Okay, so I cannot appoint them at this time, so you'll have to contact an attorney. I'm going to order that you not possess any illegal substances without a valid prescription.
Okay,
And
yes,
you're
ma'am.
not to possess any weapons or firearms or ammunition.
Yes, ma'am.
I'm going to set your bond at $3,500. Do you think you'll be able to meet that bond? Because if not, I'll set a determination of counsel in a week. And just so, I don't want you sitting in there without an attorney if you're not able to bond out.
Yes, I can bond out.
Okay. Okay. I'm just gonna leave the bond set, okay?
Okay.
All right. And you're sure you think you can bond out?
Yeah, well, they was telling me something about a pretrial or something downstairs, but I don't, this is my first time, so
I can
I
put you in
don't know
pretrial.
how it works. I'm not.
You do qualify for pretrial release. And you don't have any real history here, and that's what I'm gonna do. I'm gonna put you in pretrial release, okay? You're not gonna have to post a bond.
Okay.
All those same conditions will apply. You're gonna be subject to random urinalysis, okay, within 24 hours of your release.
Okay.
You'll have to meet with pretrial release once a week, face-to-face, okay?
Okay.
But you won't have to post a bond. And you need to make sure that if you move, or if you, if you change addresses and the address on file changes, you need to update the clerk and pretrial release.
Okay.
Okay, so they can get in touch with you. Otherwise, if you violate any of their conditions, we can revoke your bond and set your bond at none.
Okay.
Okay, and I don't want that to happen to you.
All right,
so.
I appreciate it.
Okay?
All right.
All right,
Since
good
he
luck.
doesn't have an attorney representing him at this time, is there anything that he would test positive for if he's going to be tested within 24 hours so that he's not violated? If he has marijuana in his system, obviously within 30 days, that's going to automatically violate him.
He's charged with possession of cocaine.
I understand.
Yeah.
But if he has any drugs, but it could be cocaine, it could be cannabis, that if he had an attorney, obviously they would ask for not to be tested for marijuana for 30 days. Because he's unrepresented, he may not understand to do that.
Okay. I mean, do you think you would test positive for marijuana?
Well, I tested some today, but I smoked some today, so.
Okay, so I'll ask that pretrial release not violate you for cannabis
Okay.
within 30 days.
Okay.
That doesn't mean you can smoke it.
Yeah, I got you.
Okay? So, but the cocaine should have been out, if you'd used any of it, should be out of your system fairly quickly, so.
Okay.
Okay, so for cannabis, just don't smoke it.
Okay.
okay?
All right, I got you.
All right.
All right.
All right, please tell me your name.
Jose Antonio Cortez.
All right, Mr. Cortez, you are here on 7 cases, 2019 CF 2054AO. You were arrested pursuant to a capias for fleeing and attempting to elude a law enforcement officer with lights and sirens activated, possession of drug paraphernalia, and resisting an officer without violence. The bonds in that case are $2,500, $100, and $100. You're not to possess or consume any illegal substances without a valid prescription. On the capias, it says, do not return to the scene of the offense and not consuming the illegal substances. In 2019, CT 1560AO, you were arrested pursuant to a capias for failing to appear for arraignment. The judge set your bond at $500 in that case. 2017 CT 5564AO, you were arrested pursuant to a capias for failing to appear for your arraignment. The judge set your bond at $1,000. In 2019 CT 1561AO, you were arrested pursuant to a capias for failing to appear for your arraignment. The judge set your bond at $500. In 2019 CT 1131AO, you were arrested for failing to appear pursuant to a capias, and that was for an arraignment. The judge set your bond at $500. In 2019 CT 2632AO, you were arrested for no valid driver's license. I do find probable cause. I'm going to stay the bond at the $500. Do not drive without a valid license.
Yes, ma'am.
In 2019 MM 2838AO, you were arrested for loitering or prowling and resisting an officer without violence. I do find probable cause. Your bond will be set on count 1 at $250 and $500 on count 2. And I am going to appoint the public defender on all of those cases. I don't know if you have them already for some of the cases that
Yes, I
were
do.
failures to appear. All right, ma'am, please tell me your name.
Sierra Ebony Dickerson.
All right, Ms. Dickerson, you're here in 2019 CF 3469AO. You're arrested pursuant to a capias for criminal mischief as a subsequent offender. The judge in that case set your bond at $250. You're not to return back to the scene of the offense. And you're not to have any contact directly or indirectly with the victim, any witnesses in the case. I am going to appoint the public defender to represent you. It's on the capias, $250, yeah. Please tell me your name, sir.
Brian Jones.
All right, Mr. Jones, you're here in 2019 CF 4652AO. You're arrested for possession of heroin and possession of alprazolam. I do find probable cause. I'm going to appoint the public defender to represent you. I'm going to stay your bond on count 1 at $100. On count 2, I'm going to reduce it to $150. You're not to possess or consume any illegal substances without a valid prescription. And I did say that I appointed the public defender. All right, please tell me your name.
Crystal Baricia Jones.
All right, Ms. Jones, you're here in 2016 CF 339AO. It's a violation of probation. I'm going to appoint the public defender to represent you, and I believe you should be seen by Judge Whitehead in a week to 10 days, okay?
Yes.
All right, please tell me your name.
Roderick Jean Jules Jr.
All right, Mr. Jules. You're here in 2019 CF 4656AO. You're arrested for fleeing and eluding a law enforcement officer with lights and sirens activated. I do find probable cause for the offense. I'm going to appoint the public defender to represent you in that case, and also in 2019 CF 4655AO. You were arrested for possession of a firearm and commission of a felony, grand theft third degree of a firearm, carrying concealed firearm, and resisting an officer without violence. I do find probable cause for those offenses as well. You're not to possess any weapons or firearms or ammunition. You're not to possess or consume any illegal substances without a valid prescription. And you're not to have any contact with any victim in the case. In 2019 CF 4656AO. Your bond will be set at $7,500. In 2019 CF 4655AO, your bond will be stayed at the $5,000 on count 1, $2,500 on count 2, $150 on count 3, and $100 on count 4. All right, please tell me your name.
Kathy Lodge.
Do we know what happened to Mr. Is it? He bonded? Okay, we'll take no action. That's Mr. Klum.
Yes, sir.
Okay. Ms. Lodge?
Yes, ma'am.
All right, ma'am, you're here in 2018 CF 9624AO. You're arrested pursuant to a capias for failing to appear for your pretrial on March 27, 2019. The judge in that case revoked your release, forfeited your bond, and set your bond at none. Do you have the public defender?
Yes, ma'am.
Okay, so you have the public defender, and they can file any appropriate motions for you, okay? No? Let's just check. Let's just make sure you do. Hold on one second.
She does.
You do? Okay. Thank you. Okay. Okay, thank you. All right. All right, please tell me your name.
Daria Richardson.
All right, ma'am, you're here in 2018 CT 9975AO. You were arrested pursuant to a capias for failing to appear for a status hearing. Your bond is set at $250 on that case. In 2018 CT 9974AO, you were arrested pursuant to a capias for failing to appear for a status hearing. Your bond is set at $250. I'm going to appoint the public defender if they haven't already been appointed to represent you. I'm not going to take any action on the out on bond cases because there's no new law violation. All right, please tell me your name, sir.
Hi, good afternoon. My name is Miguel Angel Rodriguez.
All right, Mr. Rodriguez, you're here in 2019 CT 2635AO. You're arrested for driving under the influence. I do find probable cause. I'm going to appoint the public defender to represent you. You're not to possess or consume any illegal substances without a valid prescription. I'm going to stay your bond at the $500. Okay, sorry, let me do that again then. I'm gonna put you in pretrial release. You're not to have any alcohol, you're not to have any drugs, you're subject to your analysis within 24 hours of your release. Okay? All right, please tell me your name.
Mandy Ray Holland.
All right, Ms. Holland, you're here in 2019 MM 2837AO. You're arrested for trespass on property after warning. I do find probable cause. I'm gonna appoint the public defender to represent you. Is there an offer from the state?
Adjudication, 3 days, no return.
Does she have 2 days, 1 day in? Okay. And I do have to impose court costs if that's something that you wanna do. If you don't want to take it, Ms. Holland, I'm just gonna stay the bond at the $500. I'm not gonna take any action on your out on bond case, but if you come back, probably will, so, but if you want to take the plea, you're more than welcome to. If not, I'll just stay the bond, okay? Huh? Yeah, do you need some time to think about it?
Just sorry.
Okay, we'll recall you. Just go back over there and you can think about it. All right, please tell me your name, ma'am.
Javette LaPointe.
All right, Ms. LaPointe, you're here in 2019 MM 2836AO. You were arrested for resisting an officer without violence, possession of drug paraphernalia, and littering. I do find probable cause for the offenses. I'm going to appoint the public defender. Was there an offer?
Adjudication 3 days.
She has 1 day in?
Yes.
You will accept that offer, Your Honor, and plead no contest.
And I do have to impose court costs, ma'am, just to let you know. Okay. Thank you. All right, Ms. LaPointe, I'm showing you this plea form. Is this your signature at the bottom?
Yes, ma'am.
Did you understand everything contained within the plea form?
Yes,
Do you
ma'am.
understand all the rights you're giving up by entering the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Okay. Do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Yes, ma'am.
Okay. I do find a factual basis for you to enter a plea as to the charges in the affidavit. I'm going to adjudicate you guilty, sentence you to 3 days in the Orange County Jail with credit for 1 day time served, and that'll be on each count, and they'll all run concurrent, okay?
Yes, ma'am.
I'm going to impose court costs. I'm going to order you pay those by April 4th, 2020. Gives you a year to pay them off.
Yes, ma'am.
If you want to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you, ma'am.
Yes,
Good luck
ma'am.
to you. All right, please tell me your name.
Holly Penny.
All right, Ms. Mahoney, you're here in 2019 MM 340AW.
Sorry, Your Honor. I believe she said Holly Penny.
Oh, okay. The names are very similar. Okay, do we know what happened to Miss Mahoney?
Mahoney? She bonded, Your Honor.
Okay, thank you. Take no action on her. Okay, Miss Penny, you're here in 2019 MM 341AW. You were arrested for petty theft. It's a retail offense. I do find probable cause. I am going to appoint the public defender to represent you. Is there no offer from the state?
No offer.
Okay. I'm just going to stay the bond at the $250. You're not to go back to the Beals outlet at 13367 West Colonial Drive. You're not to have any contact with any victims or witnesses or co-defendants in the case. All right, sir, please tell me your name.
Juwan Webster.
All right, Mr. Webster, you are here in 2019 MM 2834AO. You were arrested for possession of cannabis less than 20 grams. I do find probable cause. I'm going to appoint the public defender. Was there an offer for Mr. Webster if he wanted to resolve his case?
There is not an offer, but no objection to ROR.
Okay. You do also, let me see, look at your history here.
He qualifies for PTR as well.
I'm gonna put you in pretrial release, Mr. Webster, and you're gonna be subject to random urinalysis. If you test positive for cannabis within 30 days, I'm gonna ask them not to violate you, okay? But any other drugs in your system will violate you. So you're not to possess or consume any illegal substances without a valid prescription, okay? Okay, thank you.
I'm just take the bond.
Okay. All right, I'm recalling Ms. Holland's case, 2019 MM 2837AO. And I'm gonna see the bond at the $500. You're not to return to that location. Appears as though there's a trespass authorization warning on the building through the city, so don't go back there. But I won't take any action on the out on bond case, but if you come back, I'm likely to revoke that, okay?
Thank you.
All right, please tell me your name.
Melvin Johnson.
All right, Mr. Johnson, you're here in 2019 MO 604AO. You were arrested for camping. I do find probable cause. I'm gonna appoint the public defender. Is there an offer for Mr. Johnson?
There's no, yes, sorry, withhold credit for time served.
Is that something you wanna do?
Yes, ma'am.
Okay, so you have 1 day in? Okay, so withhold credit for time served. And I do have to impose court costs.
Your Honor, were we appointed?
Yes.
Okay.
Thank you. All right, you want to plead no contest, Mr. Johnson?
Yes, ma'am.
All right, I'm showing you this plea form. Is this your signature at the bottom?
Yes, ma'am.
Did you understand everything that was contained within the plea form?
Yes, ma'am.
Understand all the rights you're giving up by entering the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Okay. Do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Yes, ma'am.
You understand?
Yes,
Okay.
ma'am.
I do find a factual basis for you to enter the plea. I'm going to withhold adjudication, sentence you to 1 day in the Orange County Jail with credit for the 1 day that you've served. I do have to impose court costs. I'm going to order you pay those, excuse me, by April 4th, 2020. It gives you a year to pay them off, okay? If you want to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Good luck to you, sir.
Thank you.
All right, sir, please tell me your name.
My name's Richard Reyes Salgado.
Okay, Mr. Reyes Algado, you're here in 2019 MO 605AO. You were arrested for open container violation. I do find probable cause. I'm going to appoint the public defender. Is there an offer for Mr. Reyes Algado?
Adjudication, 3 days.
So you have 1 day?
We will accept that offer, Your Honor, and plead no
Okay.
contest.
Thank you. All right, sir, I'm showing you this plea form. Is this your signature at the bottom?
Yes, ma'am.
All right, did you understand everything contained within the plea form?
Yes.
Do you understand all the rights you're giving up by entering the plea?
Yes, ma'am.
Okay. Are you on probation anywhere?
No, ma'am.
Okay. Do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
What was that?
If you're not a U.S. citizen, the plea will subject you to deportation. Do you understand that?
Yes, I do.
Okay. I do find a factual basis for you to enter the plea. I am going to adjudicate you guilty, sentence you to 3 days in the Orange County Jail with credit for 1 day time served. I do have to impose court costs. I'm going to order you pay those by April 4th, 2020. It gives you a year to pay them off. If you want to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Good luck to you.
Okay, thank you.
Please tell me your name, sir. All right, Mr. Wilson. You're here in 2019 MO 606AO. You're arrested for fishing from a city-owned property, specifically one of the accepted locations where you're not supposed to fish, Lake Eola. I do find probable cause. I'm going to appoint the public defender. Was there an offer for Mr. Wilson?
Adjudication 2 days, no return to Lake Eola.
Okay. Would he get out today? Okay. But he would get, you would get out today, sir. So
I'll
it's
accept that offer, Your Honor.
2 days, credit for 1. Thank you. All right, Mr. Wilson, I'm showing you this plea form. Is this your signature at the bottom?
Yes, ma'am.
All right, did you understand everything contained within the plea form?
Yes, ma'am.
Do you understand all the rights you're giving up by entering the plea?
Yes, ma'am.
Okay, are you on probation anywhere?
No, ma'am.
All right, do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Yes, ma'am.
Okay. I do find a factual basis for you to enter the plea. I'm going to adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for the 1 day you've served. And I do have to impose court costs. I'm going to order you pay those by April 4th, 2020. It gives you a year to pay them off. If you want to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you, sir. Good luck to you. All right, please tell me your name.
Jeremy Tabar Ziegler.
All right, Mr. Ziegler, you're here in 2019 MO 607AO. You were arrested for an open container violation. I do find probable cause. I'm going to appoint the public defender. Is there an offer for Mr. Ziegler?
Adjudication credit for time served.
Just 1 day. 2? Okay.
Your Honor, we will accept that offer and plead no contest.
Okay. Thank you. All right, Mr. Ziegler, I'm showing you this plea form. Mr. Ziegler?
Oh,
Hey.
hi.
Hi. I'm showing you the plea form. Is this your signature at the bottom? Is that a yes?
that's
I
my
just need, you need
Yes.
speaking yes or no, okay?
Yes, that's
All
my
right, did
signature.
you understand everything contained within the plea form? Do you understand all the rights you're giving up by entering the plea?
Yes, I do.
Are you on probation anywhere?
No.
Okay. You understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Oh, okay.
Is that a yes? You
Yes, I
understand? You
I
understand?
yes.
Okay. I do find a factual basis for you to enter the plea. I'm going to adjudicate you guilty, sentence you to 2 days in the Orange County Jail with the credit for the 2 days that you've served. And I'm going to order that you pay your court costs by April 4th, 2020. It gives you a year to pay them off. If you want to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. All right, sir?
Okay.
Good luck to you. All right. We'll be in recess until
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la oficina del defensor público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre, y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
All right, good afternoon, everyone. I'm Judge Margaret Schreiber. I'll be presiding over initial appearances today. A couple of things I want to go over again with you. The purpose of IAs is to advise you of the charges and determine and set an appropriate bond if one is appropriate. If you are here because of an out-of-county warrant or a warrant issued by another judge that sets the bond, it's highly unlikely I will modify that bond. If you qualify, I will appoint legal counsel to represent you. If we do not have your information, I will provisionally appoint her to represent you pending future qualification. You have the right to remain silent. I want everyone to exercise that right today. If you have any questions or discussions, do not talk about the specific facts of your case. Anything you say can and will be used against you. When I call your name, come up to the podium or the microphone, whatever you have there. And once you get your dates, take your seat. I call the interpreter cases first so that we can release the interpreter. So let's begin. John Doe. Do we have a name associated with John Doe 3075?
Photo ID.
All right, Jose Luis Vera Cervantes, maybe. Anyway.
Muy bien, es posible que tú seas José Luis Vera Cervantes.
Sí.
Yeah.
Okay.
And Your Honor, if the interpreter could adjust this microphone a bit, I think it's a little hard to hear him.
How about now?
Perfect, thank you.
I'm appointing the Office of the Public Defender to represent you.
Estoy nombrando a la oficina del defensor público para que te represente.
You were charged with no valid driver's license as a non-resident.
Tú estás acusado de manejar sin licencia válida siendo no residente.
Sí.
There is probable cause for the charge.
Hemos encontrado causa probable para ese cargo.
State, was this a zero bond because of the identity question?
Y estamos en cero fianza debido al problema de identidad.
I'm not sure why they did a zero bond, but I would think that a monetary bond would be appropriate with the identity issue.
No estoy segura de que sea porque no tenía identidad, que le dieron cero fianza, pero entendemos que es apropiado que se le dé una fianza monetaria.
Typically, if they can't identify the defendant, they do set him at a zero.
Típicamente, si pueden identificar al acusado, lo pueden soltar de la cárcel.
Oh.
Bond is set at $250.
La fianza va a ser $250.
And he is ordered not to drive without a driver's license.
Se ordena que no puedes manejar si no tienes licencia.
And that is all.
Y eso sería todo.
Dates are as follows.
Court dates April 11th is still in jail. May 1st, 8:15, courtroom 4A is out.
Muy bien, la próxima cita en el tribunal va a ser el 11 de abril si todavía estás en la cárcel, o el 1 de mayo en la sala 4A si ya saliste bajo fianza.
You may be seated.
Te puedes sentar.
Does anyone else have need of a Spanish interpreter?
¿Hay alguien más que necesite intérprete español que no haya pasado al frente?
What's your name? I'm sorry? Julio, okay. Your Honor, Lopez Cortez, Julio is requesting the translator. He was not available this morning, so we did not know if he needed one.
Él no estuvo disponible esta mañana, no sabíamos que necesitaba intérprete.
Here's what your warrants, Judge. And the PD was approved.
Thank you. Cortez with a C.
Lopez Cortez.
It's a violation of probation, so.
I'm appointing the Office of the Public Defender to represent you.
Estoy nombrando a la oficina del defensor público para que te represente.
You're charged with violating the conditions of your probation
Estás acusado de haber violado las condiciones de tu probatoria, de tu libertad supervisada,
by failing to report and changing your residence without obtaining consent.
al no haberte reportado y haber cambiado de residencia sin notificar ni sin consentimiento.
Bond is set at 0.
La fianza va a ser 0, no hay fianza.
Next court date's April 15th, 8:45, courtroom 4F.
Tu próxima cita en el tribunal va a ser a las 8:45 el día 15 de abril en la sala 4F.
Please be seated.
Te puedes sentar.
Last call for anybody needing the services of a Spanish interpreter.
¿Alguien más que necesite intérprete español? Por favor, levante la mano.
No one else, Your Honor.
All right. Have a nice day. Jordan DeSauer. Sir, you're here based upon, looks like 3 out-of-county warrants out of Polk County. They set your bonds respectively at $2,000 for the failure to appear, $2,000 for the failure to appear on the leaving the scene of an accident without giving information, and 0 on the domestic battery, domestic violence count. So 2,000, 2,000, and 0. It'll be left there. Take your seat. Rhonda Harrison.
She refused, Your Honor.
You refused?
Yes, ma'am. Oh, I'm sorry, she's detoxing, apparently?
Okay. We'll reset her for tomorrow.
Okay, thank you.
Oswald Wassel. Sir, you're here based upon an on-view violation of your probation. And that's out of Orange County. Bond is set at 0. Bruce Wohl.
Bruce? He's not,
Bruce Wohl, W-O-H-L.
the officer is going to call for him, if we could,
We'll skip them for now.
yes, thank you, Your Honor.
Rachel Burtis.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You are here pursuant to an arrest warrant for retail theft and grand theft in an amount greater than $300 but less than $5,000. The state has elected to charge you only with the grand theft third-degree count. Your bond was set in that case at $2,500. I'm going to modify the retail theft bond to ROR, since the state didn't file on it, and include pretrial release conditions.
Next court date's April 10th, 8:45, courtroom 5A.
Patrick Eli.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You are charged with aggravated assault with a deadly weapon without intent to kill, aggravated stalking, and trespass after warning. Previous, probable cause was previously found. And the warrant set your bond at 0 on 2 counts and $500 on the trespass count.
Your Honor, we would request a bond for counts 1 and 2 based on the fact that the charges are entitled to bond. They are not first-degree punishable by life offenses.
All right, let me look at the affidavit. Does the state have a bond recommendation?
We would ask for a reasonable bond in accordance with the bond schedule, as well as no return and a no contact, no
Okay.
weapons or firearms.
All right, bond is set on count 1 at $3,500, on count 2 at $1,000. On the trespass count, I'll leave it at $500. You are to have no contact with the alleged victim, not return to the scene, and possess no weapons or firearms. In the event you own any weapons or firearms, they're to be turned in within 24 hours of your release.
Next court date's on demand.
Randy Emery.
Your Honor, Mr. Emery is requesting that you waive the reading of his charges today.
PD approved.
Mr. Emery, I'm appointing the Office of the Public Defender to represent you. Your attorney has waived the reading of the charges. Your bond is set at, I can't read it, is it $3,000 or $5,000? $5,000 on count 1 and $150 on count 2, where it will remain.
Next court date's on demand.
Justin Hennessy.
PD approved.
Hennessy. I'm appointing the Office of the Public Defender to represent you. You are here based upon a alleged violation of your probation. Underlying charges was petty theft, and your bond is set at 0.
Next court date's April 15th, 8:45, courtroom 4F.
Melissa Hurst.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You are here based upon a failure to appear on a written promise to appear at your VOP sentencing. Your bond is set at 0, no bond.
Next court dates, April 12th, 8 o'clock, courtroom 4E.
Warren Lamb.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You are here based upon alleged violation of your probation and/or community control, as well as failure to appear on a written promise. That being, looks like a drug court case. Bond in both cases is set at 0.
Next court dates, April 26th, 2 o'clock, courtroom 5D.
Giovanni Ortega Maldonado.
PD approved.
Your Honor, we're asking a review of this case and a ROR based on the fact that Mr. Ortega Maldonado did not receive notice of his hearing.
What says the state?
Your Honor, that should be set for a hearing in front of the judge with the ASA that handled that case.
I'm appointing the Office of the Public Defender to represent you. You are here based upon arrest warrant that was issued for failure to appear. But it gave you a bond on each of those counts of $2,999. I'm going to leave the bond in place. You can address a reduction of that bond at a future hearing.
Next court dates, April 11th, is still in jail, April 29th, 8:15, courtroom 4E, if found.
Madison Wiley.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You are charged with failing to appear. Your bond is set at $2,000.
Next court dates, April 11th, at jail arraignments.
Lymel Alston.
PD approved.
Your Honor, we have a probable cause argument for this case.
All right, give us 1 second. Have
Sure.
a seat. I'm appointing the Office of the Public Defender to represent you at this time. You are charged with 1 count of battery, simple touching or striking, domestic in nature. Ma'am, what is your name, please?
My name is Jasmine Northern.
Okay, and are you the alleged victim in this case?
Yes.
Let me hear your probable cause argument, counsel.
Your Honor, based on the police affidavit at the time of arrest, it seems like Miss Jasmine's statements were conflicting. The defendant did present evidence to the arresting officer that some of those statements were not 100% true. I do believe that the officer was required to arrest who he believed to be an aggressor in this case, but that it was not a warranted arrest.
Well, let me read the affidavit. What says the state?
Your Honor, I do believe that there is PC based on the affidavit. Ms. Northern at the time had said that the defendant had thrown the credit card at her, that he had then approached her with aggression, and then they got into a physical fight.
I'm sorry, Your Honor, I think that's a different case.
It is a different case. I'm trying to find that in here.
Sorry, I'm thinking the wrong one. That's my fault.
Alston.
Right, someone picked up and took her outside. I do believe that there is probable cause for that offense within that affidavit, Your Honor. That it was against her will. She had said it was against her will. I understand that she then changed that statement, but there wasn't a cut on her right arm, and I do think that the officer had probable cause to arrest the defendant.
And if I could reply, Your Honor, Ms. Northern did tell the police that cut was not received from the defendant.
Correct.
Your Honor, if we do take any testimony from Ms. Northern, I'd ask that she gets sworn in.
Raise your right hand, please. Do you solemnly swear affirm the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I agree.
State your name for the record, please.
Jasmine Northern.
Put your hand down now.
Oh, okay.
Counsel, do you care to inquire? You want the court to?
The court may inquire, Your Honor.
Okay. Reference the cut on your arm. Did you receive the cut on your arm in this incident?
No, ma'am, I did not.
Are you afraid of, what is his relationship to you?
He is one of my closest friends.
Okay, are you afraid of him?
Absolutely not.
Want to prosecute?
No, ma'am.
Did he pick you up from the bed and carry you outside of the home and put you on the floor?
No, Your Honor.
Does the state care to inquire?
Did at some point grab your arm to take you out of the home?
No, no, ma'am.
Did he touch you at any time without your consent for this incident?
No, ma'am.
Further from the state.
While considering the additional testimony found today, I don't find there is probable cause for the charge. And I typically would give the state 24 hours to amend, but given the fact that the alleged victim is present and has just testified, I'm inclined to release him ROR at this time.
I don't think there's anything that we would be able to amend, Your Honor. I do understand there's conflicting statements. I again do think that the officer had probable cause at the time, but
I'm going to release him ROR at this time.
Thank you, Your
so
Honor.
much.
Next court dates, May 1st, 8:15, courtroom 4A.
I'm sorry, Your Honor. Madam Clerk, that was May 5th?
May 1st.
First, thank you. And Your Honor, if you wish to readdress Mr. Wool, he is here present now.
Let's do that. Bruce Wool. Sir, you're here based upon a warrant issued out of Orange County for grand theft, third degree of a motor vehicle, which sets your bond at $5,000.
Can you lower that?
Your Honor, the defendant is requesting if you have the ability to lower his bond.
I do not.
Thank you, Your Honor.
He'll be transported. He can make that argument at a bond reduction hearing.
Yes, Your Honor.
Junior Dunkley.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You're charged with grand theft auto, possession of marijuana under 20 grams, and possession and/or use of drug paraphernalia. I've reviewed the charging affidavit. I find there is probable cause for the charges. Your bond is set at $1,000 on count 1, $250 on count 2, and $500 on count 3, with He's got a low, does he have any prior convictions? Only convictions?
One and only conviction out of 2006 out of New York.
Okay.
That's his entire arrest record.
I'm going to amend counts 2 and 3 to reduce those bonds to $100 each, so it's $1,100, $100, and add PTR as a condition of release.
Next court date's on demand.
Daniel Fink.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You're charged with the following: grand theft auto, possession of a controlled substance without a prescription, possession and/or use of drug paraphernalia, knowingly driving while your driver's license is suspended. I've reviewed the charging affidavit. I do find there is probable cause for each of these charges. I hear from PTR. Recommending mental health PTR if he qualifies?
Yes, Your Honor, he has no prior arrest. In interviewing him this morning, he did indicate that there were some mental health concerns that we found, and so we would ask whether with monetary or without mental health PTR, or in the alternative PTR with mental health conditions.
Okay.
And Your Honor, we would request a non-monetary release based, I have spoken to his sister who does work for the Marion County Sheriff's Office and who has indicated the ability and desire to take him in if he needs to stay with somebody.
What says the state to a non-monetary bond? No prior arrests.
I leave that to the court's
Okay.
discretion, Your Honor.
As to the 3 drug cases, as to the grand theft auto and the possession of controlled substance without a prescription and possession and or use of drug paraphernalia, I'm ordering that he be released under mental health PTR if he qualifies, under PTR with mental health conditions if he doesn't. I'm not imposing a monetary bond as it relates to the knowingly driving while driver's license suspended. I'm releasing him ROR with the stipulation that he is not to drive without a driver's license. That will constitute a violation of his conditions of release.
Thank you, Your Honor.
Next court date on case number 19 CT 1065, April 23rd, 8:30, courtroom 5B. Case number 19 CF 1213 on demand.
Timothy Jones.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You're charged with 1 count of battery, unlawful touching, or striking. I find probable cause for the charges. Bond is set at $1,000 with PTR. You're to have no contact, you're to have no hostile contact with the alleged victim. Let me explain hostile contact. There's no hostile direct or indirect contact. It includes physical contact, yelling, screaming, shouting, anything of a hostile nature directly with each other. It also includes indirect contact, sending emails, text messages, Instagrams, whatever, of any type of a threatening nature. All of that will constitute a violation of your conditions of release, right back in the orange jumpsuit.
Your Honor, would you consider reducing that based on the fact that the defendant doesn't, while he has officially moved to Florida and does work in Florida, he doesn't have a Florida license yet, so he may find it difficult to post bond?
I would. What are you requesting?
If Your Honor insists on a monetary release, no more than $100 or $200, which would be comparable to what he would pay to the bail bondsman.
I'll go $250.
Thank you, Your Honor.
Next court date's April 11th, is still in jail. May 2nd, 8:15, courtroom 4E, if out.
Justin Lousy.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You're charged with possession of cocaine, possession of a controlled substance without a prescription, and possession or use of drug paraphernalia. I have reviewed the uniform charging affidavit. I do find there's probable cause for the charges. Bond is set at $2,500 on count 1. $2,500 on count 2, $500 on count 3 with PTR.
Next court date's on demand.
Erica Mitchell.
PD approved.
Your Honor, Ms. Mitchell's in the same situation as her fiance, Mr. Jones, if you would consider.
I'm appointing the Office of the Public Defender to represent you. You are charged with 1 count of battery, unlawful touching, or striking. I've reviewed the charging affidavit. I do find there's probable cause for the charges. I'll set your bond at $250. I'm going to order that you have no hostile contact with the alleged victim, your fiance in this case, and you just heard me read a list of what that entails.
Would you like PTR with that as well?
With PTR, yes. Thank you.
Next court date's April 11th, is still in jail. May 2nd, 8:15, courtroom 4E, if out.
Odette Montero.
PD approved.
Your Honor, Ms. Montero is requesting you waive the reading of her charges today.
Okay. I'm appointing the Office of the Public Defender to represent you. Your attorney has requested a waiving, has advised that you are waiving the reading of the charges against you. Sir, what is your name?
Luis Adames,
And what is your relationship?
boyfriend.
Thank you. However, I do find there is probable cause for the charge.
She has no convictions, Your Honor.
That may be, but I'm setting the bond as recommended in the bond schedule at $50,000 with PTR.
Next court date's on demand.
Lemmy Prescott.
So he's hiring a private attorney.
The Prescott. Is it your intent to hire private counsel?
She asked if you're going to hire a private attorney.
Yes, ma'am.
Okay. All right, you can put that down. I just want to confirm you're hiring private counsel. You are charged with violating your pretrial release regarding dating violence. Was it an injunction in place? Hold on, let me look at this. All right. So in 2019, MM 1050, you were ordered to have no contact with the alleged victim, who subsequently apparently had contact with the alleged victim. PTR's had no contact with the alleged victim?
That's correct, Your Honor. He is out on bond on that 19 MM 1050, 2 counts of battery domestic.
Well, sir, a no contact order means a no contact order, so I am finding there is probable cause. I am setting your bond at 0, also revoking your bonds on the open cases and setting those bonds at 0. You can take it up with the presiding judge. At this time, I'm not aware of any conditions of release that would protect the alleged victim.
Next court date's April 11th, is still in jail, May 2nd, 8:15, courtroom 4E if out.
William Roman.
PD approved.
I'm appointing the Office of the Public Defender to represent you. You are charged with possession of a controlled substance, that being alprazolam, possession of marijuana in an amount greater than 20 grams, and possession or use of drug paraphernalia. I've reviewed the charging affidavit. I find there is probable cause for the charges. Bonds are set at $1,000, $1,000, and $500 respectively, along with PTR. You're also out on bond in case number 2018 CF 4405. Looks like the same type of underlying charges. And I am revoking your bonds in those cases and setting your bonds at 0.
Next court date's on demand.
Kathleen Garcia Rodriguez, or Catalina Garcia
She's-
Rodriguez.
She's still detoxing, Your Honor.
We'll reset her for tomorrow. Rodney Jones.
PD approved. I believe it was Judge Johnson.
Your Honor, he was an unidentified John Doe at his first appearance on Tuesday, so that's why he's still at 0 today.
Okay. I'm appointing the Office of the Public Defender to represent you. Probable cause was previously found for the charges against you, but your bonds were held at 0 based upon the identity question. I am now setting your bonds as follows: $500 on criminal mischief and $100 on trespass after warning, not including PTR.
Ask for no return condition.
And no return condition to where this incident took place.
Next court date's April 11th, is still in jail, April 30th, 8:15, courtroom 4E if out.
Joel Manuel Ortiz Colon.
He refused. Okay, he's refusing, Your Honor. It sounds like he wouldn't mind if you waived his appearance.
How many times has he refused? Why don't we waive his appearance?
Yeah.
I'm going to find that he has waived his appearance, and we are going to proceed. He is charged with, he's here on an out-of-county warrant, which sets his bond at 0. Done. Emmanuel Rivera.
PD approved.
He's in the back, Your Honor.
Mr. Rivera, I'm going to appoint the Office of the Public Defender to represent you. You are here on a charge of petty theft in an amount greater than $100 but less than $300 and providing a false name or identification by an arrestee. I reviewed the charges. I do find there's probable cause for both of the charges. Bond is set at $500 on count 1 and $100 on count 2. However, those charges also purportedly violate your probation and/or community control. I'm finding an undue violation of that probation and/or community control in 2017 CF 2151 and setting your bond at 0.
Next court date on case number 19 MM 1212, April 11th, is still in jail. April 29th, 8:15, courtroom 4A if out. Case number 17 CF 2151, April 8th, 8:15, courtroom 5F.
Is there anyone who has not yet been called up? Raise your hand.
No, you were just up here, Mr. Jones. You want to ask the judge a question?
I don't take questions after the arraignment, so if I appointed counsel, he can ask you counsel.
No problem, Your Honor.
All right?
Thank you.
All right, we're adjourned. Have a nice day.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.